will be next week, I think. And in that time, I would hope that, because this is a huge thing and I'm willing to put my money where my mouth is, so to speak, and literally, like, I'll put money down on this that I'm writing. Anybody who wants to challenge me, anybody whose livelihood is invested in making money from the land patent, what I'm going to start calling a scam now, if they promote it as a panacea to prevent foreclosure and whatever, then they can come and debate me and I will prove them wrong and do it to their face. I'll do it to their face. But this is an important thing. And so I'm putting out a challenge to the world. So that's what this is just kind of to put out lay out the basic explanation, and I guess you could say theory, and to show it with facts and backing it up and everything, and explaining really why people have misunderstood it. And then next week will be the full presentation, like A to Z, all nicely presented with diagrams and case citations and stuff like that. Because I'm still going through Ron Gibson's land patent manuscript, and there's a lot of case law on that. And I want to go through the case law as well, which I haven't done because I want to see if there's anything in there that I'm missing, which at this point I'm 98.5% sure I'm not. Other than, there's other issues still involved. Like I was talking to Gavin earlier, and he was saying he thinks the tax issue is still a thing, the property tax issue. And he thinks he said the land patent doesn't necessarily, he agrees with me that the land patent doesn't save you from taxes or protect you, I should say, from property taxes, but he thinks there's some other legal theory that will address that. So we both agree that the land patent has nothing to do with that, and that there's a possibility that the property taxes can be addressed in a different way. However, with the caveat that I put forth that the property taxes are part of the police power, and we've already gone over that last week. So, but I'm not saying anything about that. I'm just strictly focusing on this week on, the basic idea, the basic explanation behind why everybody's just wrong about land patents, including me 10 years ago, and Bob Schaefer and everyone I learned from and all that, and including Ron Gibson now and everybody else who promotes it. And so I guess if you can indulge just 3 more minutes of waiting, because I decided to hold off if you're just arriving lately, which kind of everybody has been here now for a few minutes listening to me blab. I was wanting to wait for the email to get out before we formally started. And also the reason I have an Apple logo, the old Apple logo for my icon, is because I was doing a nerd thing with over the weekend, and I changed my thing for that. So I'll just turn on the video. So yeah, we'll start at 6:15. So if you guys don't mind hanging around, because I'm hoping for more people to arrive. Yeah, there you go, Max. You're gonna like this one, but ultimately, it's not really gonna be of any use to you. The only way it would have been of use to you is if I could have proved that land patents do all the magical things people have promised over the years, and unfortunately, I'm not going to be able to do that. Yep, yep, yep. So let me well, I'll do that at 6:15. I'll start the recording and the official meeting at 6:15. But I was just going to say, and I'll hold the update for Randy the Barber for the recording as well for posterity. But it's in summary, we think that's moving to settlement. Because Randy already actually talked to the deputy AG above the guy that's been prosecuting him. Had a heart-to-heart, man-to-man, apparently. So I'll give an update on that, which is good news. So we think we're close to settlement on that. So I'll be right back. We're a minute away. I'm just gonna go get some water. Hit me as I was walking away. I realized if you know, oh, here's somebody else. Here's Dev. If you know of anyone who would like to hear this information tonight, please put the word out and invite them to come on. Again, because I forgot to send the ding message out, but I'll be right back. No one else? Dang it. Um, got your message, Faye. Yeah, anybody you know who is considering wanting to do the land patent thing, definitely want to send them invitation for next week. I don't want anybody anymore to waste any of more of their time, money, energy into this thing as far as some kind of solution to their foreclosure problems when they could be investing all of that into more productive actual solutions that may save their house. All it does is, when you think about it, it may well be a ploy by the banks to just, make people run off and waste their time so they lose their houses. Let's start the recording. Where is this?
Recording in progress.
It's March 19th, 2024. This is the regular IDP meeting. And I am your host, Salam, filling in for Jackie once again. Tonight is the prelude to my definitive debunking of the land patent issue once and for all. So what I'm going to present tonight is my preliminary and almost complete research on the land patent issue. And this is an evolution of thought that's occurred over the last, let's say, 10 years, from first studying under Bob Schaefer, beginning in about probably 2012. And Bob Schaefer, in case you're not familiar with him, he was, as far as I was concerned, he was the foremost authority on land patents in the country. Um, and probably even in terms of like people who literally do land patent law, maybe not like an attorney, but Bob was a fighter and a self-taught legal scholar out of San Bernardino County. He was able to hold his own. He had a fence around his property with no trespassing signs, big like chain link fence around his whole property there. And he had his patent warnings, land patent warnings and everything, and had perfected the land patent. And he went down that path and learned all that stuff as a result of losing a hotel property that he and his father owned together, like in a joint venture, and they were fixing it up in downtown San Bernardino, and they were going to well, they basically got bamboozled out of it. They got screwed out of it, lost like $1 million, and this is like in the 70s. So it was a big deal, and it kind of ruined them. And so Bob, who owned his house at the time, he said he rented his house out so that he didn't have any expenses, and he moved himself into the shed in the backyard, and he lived out of his shed. He surrounded himself by law books, and he studied law for 3 years until he learned everything there was to know about land patents, I guess, and among other things, obviously. But he, that's where he, learned all about land patents and came away with the idea that they could be used to establish like an absolute, well, I'm not going to use the term absolute title because that's actually a correct term. They do establish absolute title, but not allodial title. That's the difference, because absolute title is a completely different species altogether than allodial title, which we're going to get into in a second. So I trained under Bob. I met him through uh, Kelby Smith down in Los Angeles, who has been at this for a long time. I still consider Kelby a friend. And, we haven't spoken in a long time, but Kelby, he's kind of, our journeys have been pretty much the same. We both lost our houses and got into this trying to figure out how to get around foreclosure. And his special insight and knowledge into this is he was a real estate broker, and so he knows a lot about real estate law and stuff. And so he was able to see the quote unquote fraud that exists in terms of the mortgage and everything like that. But our journey's kind of been the same. We went through all these different schemes, of all different kinds, including the land patent stuff. That's how I got introduced to it, was through Kelby. But over time, I kind of see, when I follow Kelby now, he has his own channel. His thinking has evolved in the same way that mine has, where a lot of the stuff we used to believe, like the American State National thing, which is going to be a separate debunking. And what's the other thing? Anyway, there's all these different myths out there. I've seen that he's also now telling people, that there was just a lot of misunderstanding, whatever. So I'm glad to see him also, finding his way in what I believe is the right direction. So, in fact, I got to get Kelby on as a guest one of these nights. It'd be great to reconnect with them. Anyway, so Kelby set up these seminars. That's where I met Bob. I went to the seminar and met Bob, and eventually, over time, after having attended 2 or 3 of the seminars, including one up here in Sacramento, I became friends, personally acquainted with Bob, and to where he would be fine with me calling him directly, because the way they set everything up, they didn't want people calling Bob directly because he had a lot of work. He was helping a lot of people with legal issues and stuff like that, writing their court cases, and also he was trying to finish setting up this package for the land patent package. They were trying to automate it in a way, where you filled in a form, put all your information that they needed, and then they would produce all the documents for you. And so I knew exactly what they were trying to do, and I tried to offer my expertise, but they said they had it all figured out. So I was like, okay, but that was a big cluster F. And so, but eventually, I got the land patent documents, and I threw them up on, and I put I put my all into studying the stuff, right? I learned it as Bob taught it. I read all the history behind it. And that was the great thing about Bob. Bob taught the history. He taught the along with the law. And so that was really important for understanding what the laws were about. And it's also helpful in understanding how Bob was wrong, which was facing him, staring him right in the face. And again, this is something when people want something to be, they're going to rationalize it, right? They're going to, I'll have more to say about that before we begin also, because that's an interesting part of all of this is people have clung to this because they want to believe it's true, including me, including Gavin that's just coming on, who I was speaking to about this earlier. You want it to be true, but at some point, especially after it doesn't work time and time again, it didn't work for anybody in the group that I knew that went to the seminars. Kelby was never able to find anybody it worked for. Hey, Gavin. The group that I had that, we all got together in the Bay Area as a support group to work with each other who had all gone to Bob's seminars. None of us had success, just one by one. We all lost our houses. So, at some point, it's one thing to hold on hope because, well, maybe someday somebody will get it right. Because there's always this rumor out there that, oh, yeah, it does work. Somebody, this person made it work or this or that. There's always and there's just always the hope. But it is really, when you look at it, I don't know one success story. I don't know one success story, period. And everyone that claims a success, when you look into their actual story, I can show you. By the way, if you see me swatting like a madman, it's because there's mosquitoes in here. I can show you why it wasn't a success. I can pick it apart and say, well, this is what happened. This is, there's always some other thing. It's not the land patent. I guarantee you. To the extent that some people have, indeed, like discharge their mortgage or save their house from foreclosure, at least temporarily or whatever, it wasn't the land patent. I guarantee you that. So we have to come to grips with it. And so getting back to my story, what I'm basically getting at is I learned it as well as Bob. I think I could still recite all the history and everything like that. I learned it as well as anyone. I put it to work as well as anybody. I posted all the notices, sent them out to everybody. All the notices, that Bob said too, was like literally 30 different addressees got the registered mail with I think literally registered mail. Well, no, some of them got registered mail, others got certified mail because it's like, oh God, that's just too expensive. But the judge, the sheriff, the bank, the attorneys, everybody, the land assessor, the tax assessor, everybody, got a copy of the land patent in my notice and the 200 pages of historical background that Bob put together that goes, that was served with all of it. And when I came home from court that one day, and the house was busted, the door was busted down and bolted back up, and there was notices saying the house had been taken by the bank and no trespassing. And I found all of my 14 pages of land patent notices shoved in the trash. That was my wake-up call that, okay, well, at the time, of course, I believed that they just didn't follow the law. They don't follow the law, these bastards. They don't follow the law. But it just wasn't to be. So the last 6 years now of me coming back into this in earnest, meaning studying law, thanks to Jackie. That's why I always honor Jackie for bringing me back into this. I came back in with a very skeptical eye towards a lot of this stuff because I had already been burned, already been through it all, already tried everything, already saw everything didn't work. And so anybody coming forth, 5 years after I had already gone through all this, it was 4 years at that point, or 3 years actually after I got out of jail and decided to put all this crap behind me. I was only in jail for a month. It wasn't a big deal. I wasn't going to fall for the same bullshit again. And so that's why I was very critical of people who came on the meeting promoting something. My thing was, where'd you read that? Where'd you see that? What's the evidence? Show me the case law, show me the law, the ruling, the whatever you can. Don't give me it's in some secret writing or it's Masonic blood libel, blood oath, or It's they all know, or whatever excuse they give. No, 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 no. No. If this was real, you'd be able to go into court with a book or a citation or something and say, it says so right here. This is precedence for it. This is how my I don't have to pay my mortgage, or this is how the land patent protects me from the bank, or whatever it is. But it's just not there. So um and over the and during this 6 years, I finally did what I should have done a long time ago. But when you're in the middle of battle, you just take the weapon that the person hands you and hope that it works the way they tell you, right? You don't really have time to understand the weapon and who designed it and how it was designed, whether it actually works or not. You just try to use it. And so now that I had the time to actually go back and spend the time researching, doing the reading, doing the proper research, I came to my own conclusions, and here they are. Let's dive right into it. And again, this is just the prelude. It's going to be a kind of a slap hazard presentation. And next week will be the more formal one. But I'm going to leave you with enough knowledge for you guys, you people, because you're not all guys, to understand, to at least have the information that you need to understand this, and then go off and mull it on your own and come to grips with it, do your own research. Try to debunk me if you can, please. But then, next week will be like, okay, this is going to lay it all out. I'll have hopefully read all the case law and everything. If I don't have it fully prepared, then I will push it out. But I do want, again, the word get out. So let's start. Let me share my screen. And the first thing I want to do, let me see what I first want to share. Because like I said, I threw my notes together. Oh, yeah. Let's share my notes first, because I want to go over first some prerequisite stuff. Where is it? Here. Okay. Let me zoom this up. So I was watching this video earlier today. I posted it to the chat if you happen to see that. Why smart people believe stupid things. And the channel is After School. And it's a really good channel. It basically takes different philosophical musings, like they're like essays, and then they're spoken out, and then there's a guy who's drawing on a whiteboard, with the colored pens, the ideas that are being expressed, and it's just something to watch, but you're really listening. And so it got me thinking about the difference between intelligence and wisdom. Um, this idea of why smart people believe stupid things. It's kind of like the opposite of the Dunning-Kruger effect, where dumb people don't realize how dumb they are. So it's sort of like a similar corollary to that, why, in terms of how smart people can be duped into believing stupid things. So, like, for example, I think you guys will all agree I'm probably an intelligent guy, right? I'm not dumb. I'm probably smart. But then
Probably.
probably or at least just let's just assume. And but I fell for this shit. I fell for what, I fell for dumb things before in my life too, and now I think back and I'm like, yeah, that was kind of dumb. The land patent thing. And see, this is what the video kind of gets into also. The land patent thing, I was able to rationalize it. And when you don't have the full information about what it's all about, or at least you only have the information that the Bob Schaefers and the Ron Gibsons are teaching you, then it's easy to rationalize it. But the dumb thing and the unwise thing was to not do your own research, not do my own research. That was the difference. So I was very intelligent, but I wasn't very wise. And if there's one thing to remember from this presentation, that may be it. Not at all related to land patent thing, but it's just to remember and to know the difference between intelligence and wisdom. There's a great difference. And that's why you see seemingly intelligent people do really dumb things, like during the stupid 19 pandemic, right? Like all of us, I'm sure we had friends who just fell for it, hook, line, and sinker, and or to this day probably still injecting themselves. They could be the smartest people in the world, but if they don't have it coupled, if it's not coupled with wisdom, then they don't have they might as well be dummies. Because like I say here, somebody can be highly intelligent but extremely unwise, and someone can have low intelligence but great wisdom, and between the two, the one with wisdom generally prevails. And one with both high intelligence and wisdom is a formidable opponent. So these are kind of my musings. And also I added this: intelligence can be tested at any time. Like you can give somebody an intelligence test and be like, oh, this person's very smart, based on some score or whatever. Or you can talk to them and, get the general idea that, well, this person knows a lot of stuff, or they just come up, they're very bright. But you don't know if they're wise. They may have some really dumb bets on the stock market, for example, or they may be involved in the absolute wrong woman or something, just if you knew about it, it's like, oh my God, how dumb can they be? But it's not dumb, it's not intelligence, it's wisdom. And that can only be measured over, I posit that can only be measured over time. Because you might think that somebody made a really dumb move, but then over time you see that, oh, I see what they did there, And so this is from the video down here. It said motivated reasoning, i.e., when smart people believe in stupid things, occurs when we place our intelligence and learning into the service of irrational goals. So when we're trying to pursue irrational goals, that's where we go wrong. So this is very philosophical, but it ties into the whole idea of how people got suckered into the land patent thing. So please humor me. The root of the problem, therefore, is not our intelligence or learning, but our goals. Most goals of thinking are not to reach objective truth, but to justify what we wish to believe, i.e., oh, land patents are real. I want to believe it's true. And so the antidote is curiosity. We must also have, this was also important, I thought, this part of the video. We must also have humility. This is because the source of our strongest biases is our ego. We often base our self-worth on being intelligent and being right. And this makes us not want to admit when we get things wrong or to change our mind. I've been there, I'm sure we all have. And so in order to protect our chosen identity, the ego, we stay wrong. We prefer to be wrong rather than be corrected. I'm different because I've learned my lessons. I'd rather be shown to be a buffoon and be shown the truth than to continue to believe wrong stuff as I had for so many years. And that's a personal thing. That's something for everybody to decide for themselves. Nobody can, do that for you. That's something you just have to come to grips to on your own. And there's a lot of people who don't want to come to grips with that because their identity, not only is their identity wrapped up in that, but their livelihood. And I'm not going to name names, but I could. And there are people out there who have, I'm not talking about anybody here, but there are people out there selling products and things, services that they should know better, but they willfully overlook the fact that things don't really add up because their livelihood depends on it. I'll just leave it at that. Humility and curiosity, then, are what we need most to find truth. By seeking one, we also seek the other. Being curious makes us humble because it shows us how little we know. And in turn, being humble makes us curious because it helps us acknowledge that we need to know more. I really like that. So I'm going to put this link to the video. Keep all of this in mind while we move forward. And also, here's a saying that we've all heard before. It is easier to fool people than to convince them that they have been fooled. So true in my experience. So true. Okay, let me stop the share. I'm going to put, what is this in the chat room? Who posted a big photo? Oh, it's a Mark Passio, a cosmic abandonment. I think the picture is so big I can't even see what it is. Anyhow, let me post the link here to that YouTube video, and then now I'll finally get into the land patent stuff. But before we do that, it's first useful. We need to start with the homestead. So let me go to this website that has the Homestead Act and share my screen. But yeah, just FYI, I'm a big fan of Mark Passio, and I feel real bad for him lately. He's been under so much stress that literally the last 3 of his Sunday presentations, it's just 3 hours of bitter just lashing out. I've never seen him like this before. And I hope he gets over that because he's a valuable resource. But he's kind of like he's kind of like where I feel like sometimes where no matter how hard he tries, people just keep believing in stupid shit and all of his work is for naught because nobody is paying attention, no one's listening. I don't know that that's the case with me. I guess we'll find out. We'll see what happens in a year. People are still promoting this horse shit. Excuse my very truthful language. Here's the Homestead Act of 1860. This is only one of the acts that conveyed land via title from the government to a private person, i.e. a citizen or corporation. And so, because there's the railroad acts, there's military acts, there's all these different acts that by which the United States exercised its primary disposal of the soil to get the land into private hands and to therefore populate the lands that it laid claim to, because you can't lay claim to lands that you don't, have a presence in, so to speak. And that's going to come into play later. Okay. Here is the actual act. This is in the this is the 37th Act of Congress, Session 2, Chapter 75, 1862. Here is, let me zoom this up a little bit more. Hope everybody can see it. This is, you can see right here, May 20, 1862, Chapter 75 of the Acts of, again, 37th Congress, Session 2, 1862. An act to secure homesteads to actual settlers on the public land, on the public domain. So again, this is the so-called, this is what's called this is the Homestead Act, short title. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that any person who is the head of a family or who has arrived at the age of 21 years, and this is only 2 pages, so it's not going to take long, or who has arrived at the age of 21 years and is a citizen of the United States, or who shall have filed his declaration of intention to become such, as required by the naturalization laws of the United States, and who has never borne arms against the United States government or given aid and comfort to its enemies, keep that in mind, shall from and after the 1st of January, 1863, be entitled to enter 1/4 section or less, 1/4 section or a less quantity of unappropriated public lands. And so 1/4 section is, a section is 640 acres. So 1/4 section is 160 acres. And again, that's how you derive down to the 40 acres and eventually down to like 10 acres and 20 acre lots. It all started from 640 acres. They'd quarter that. You'd have 460 acre sections. They'd quarter those. So they get subsections of that. So that would be 40 acres each, and then they'd quarter the 40 acres and you get 10 acres and whatever. Or they do 5 acres, or they do 80 acres, or they do, there was different allotments or whatever. But it all started from the base of 640 acres, which is a square mile, which is also called a township in surveying parlance. Okay, be entitled to 1/4 section or less of, or a less quantity of unappropriated public lands upon which said person may have filed a preemption claim, or which may at, I just got this notice that says participants can now see your application. Did my share just start all of a sudden? The screen share? Anyone?
No, we've seen it the whole time.
Okay, forgive me for that. I just trying to make sense of these notices. Okay, thank you, Cynthia. Nice to see you.
Man, nice
Okay.
to see you back too, Salam. I was wondering when your meetings were going to come back on, because I'm going to start up my little monthly donation for you, because I just love your meetings.
Oh, well, thank you. Well, this one is worth it for sure tonight, because but thank you. Okay, so entitled to one preemption claim. So a preemption claim, I'm thinking, is like, like a dibs, basically. I think, anyway, that's not important. Or which may, at the time the application is made, be subject to preemption at $1.25 or less per acre. So basically they were, once they put in the application for the part of the land, the 160 acre section that they want, then that's what the preemption is referring to here. And they were eligible to purchase it at $1.25 an acre. Or less, actually, because it says or less per acre, or 80 acres or less of such unappropriated lands at $2.50 per acre to be located in a body in conformity to the legal subdivisions of the public lands, and after the same shall have been surveyed. Now, you're welcome to go back and read all this and make sense of it. It's not important to understanding what land patents are. I'll just put it like that. This is really basically just kind of putting forth the bargain, what the bargain is. Provided that any person owning and residing on land may, under the provisions of this act, enter other land lying contiguous to his or her said land, which shall not, with the land so already owned and occupied, exceed in the aggregate 160 acres. I think what that's basically saying there is you're allowed to cross over other people's lands to get to your land. Section 2, and be it further enacted that the person applying for the benefit of this act shall, upon application to the register of the land office in which he or she is about to make such entry, make affidavit before the said register or receiver that he or she is the head of a family or is 21 years of age or more of age, or shall have performed service in the Army or Navy of the United States, and that he has never borne arms against the government of the United States or given aid and comfort to its enemies, and that such application is made for his or her exclusive use and benefit, and that said entry is made for the purpose of actual settlement and cultivation, and not either directly or indirectly for the use or benefit of any other person or persons whomsoever. And upon filing the said affidavit with the register or receiver, and on payment of $10, he or she shall thereupon be permitted to enter the quantity of land specified. So what this is saying here is the whole idea of this act was to promote the inhabitants of the Western lands with American citizens, American families specifically. So they wanted you to go out there, set up an actual homestead for yourself, and you weren't just doing it like for investment and you were going to buy it and then flip it, basically what everybody does today. All that shit was, of course, already going on back then. But so this is just saying, like, laying down the parameters. You can't, it has to be for you. It's kind of like a modern day homestead exemption when you file for when you record a homestead exemption on your property, so you can get a homestead exemption discount or whatever on your property taxes. It's kind of the same thing. It has to be the house you live in to get the exemption. You can't get it on a rental house. Same idea. All right. Anyway, and then so you paid a $10 fee, and then now you were basically permitted to enter onto the land once you got all that preliminary administrative stuff out of the way and paid the fee. Provided, however, that no certificate shall be given or patent issued, therefore, until the expiration of 5 years from the date of such entry. So you couldn't actually get the patent until you were on the land for 5 years, because that was also, again, to show that you were literally making an effort to establish a homestead and you weren't just, trying to scam some free, cheap land off the government. And if at the expiration of such time, or at any time within 2 years thereafter, the person making such entry, or if he be dead, his widow, or in case of her death, his heirs or devisee, or in case of a widow making such entry, her heirs or devisee, in case of her death. So basically, all the people, the family involved, shall prove by 2 credible witnesses that he, she, or they have resided upon or cultivated the same for the term of 5 years immediately succeeding the time of filing the affidavit aforesaid, and shall make affidavit that no part of said land has been alienated, meaning like given away or sold or encumbered, perhaps, although maybe that's different than alienated, but you haven't tried to deed it away, and that he has borne true allegiance to the government of the United States. They keep mentioning that, and that's going to come in later in an indirect way. Then in such case, he, she, or they, if at that time a citizen of the United States, shall be entitled to a patent, as in other cases provided for by law. And provided, okay, so this is basically saying that they need to make an affidavit swearing that, they, with 2 credible witnesses. That's just 2 credible witnesses witnessing your affidavit. That's not, I don't think it's saying they had to have witnessed you actually making the homestead. But it's, basically you have to put forth an affidavit swearing that you did all the things, that they say, they want you to have done. And provided further, so you get a patent if you do all that, and provided further, that in case of the death of both father and mother, leaving an infant child or children under 21 years of age, the right and fee, okay, notice the fee, okay, I don't believe that's referring to the fee that was paid, because there wasn't any mention of a fee. It actually used the term, what term did it use actually? Where's the $10? Payment of $10, all right? So they're referring to like fee simple, okay? The right and fee shall inure to the, and you'll start to understand why that's important in a second, shall inure to the benefit of said infant, child, or children. And the executor, administrator, or guardian may at any time within 2 years after the death of the surviving parent, and in accordance with the laws of the state in which such children for the time being have their domicile, sell said land for the benefit of said infants, but for no other purpose, and the purchaser shall acquire the absolute title by the purchase and be entitled to a patent from the United States on payment of the office fees, and sum of money herein specified. Okay, now that is using the term in the sense of a required payment amount, which makes me wonder now if maybe the other fee wasn't. But again, immaterial. Don't get caught up on it. But this part again, this is like so as it said on the last page, like basically if it's an orphan, then an executor will come in, sell the land on their behalf, and then the purchaser of the land will acquire the patent. And so the people who were trying to homestead the land, they die, the parents die, the child's still there. The child obviously can't fulfill the patent requirement. So in order to protect the child in terms of the investment the parents made, the term of that application to get the patent is sold to somebody else. The proceeds then go to the infant to raise them and give them a life. But then the person who buys the right now can then apply for the patent as if they were the original parents. That's what that's saying. And be it further enacted, Section 3, that the register of the land office shall note all such applications on the tract of books and plats of his office, and keep a register of all such entries, and make return thereof to the general land office, together with the proof upon which they have been founded. So that's basically just some administrative stuff. Section 4, and be it further enacted that no lands acquired under the provisions of this act shall in any event become liable to the satisfaction of any debt or debts contracted prior to the issuing of the patent therefore. So you can't, take a mortgage out on it until you got the patent, because it's not your land at that point. You're just sitting on it while you fulfill the government conditions and all those cure. The government still has title, so you can't encumber government land or land to which you don't have proper title. And be it further enacted, Section 5, that if at any time after the filing of the affidavit as required in the second section of this act, and before the expiration of the 5 years aforesaid, it shall be proven after due notice to the settler to the satisfaction of the register of the land office that the person having filed such affidavit shall have actually changed his or her residence or abandoned the said land for more than 6 months at any time, then and in that event, the land so entered shall revert to the government. So basically, if they renege on their deal and they're into the bargain or abandon it or whatever, then the patent reverts to the government. The land reverts to the government. And then they'll try again to give it up to somebody else. Section 6, and be it further enacted that no individual shall be permitted to acquire title to more than 1/4 section under the provisions of this act. So you were only allowed to get up to 160 acres. And that, because that's what 1/4 section is. And that the commissioner of the general land office is hereby required to prepare and issue such rules and regulations consistent with this act as shall be necessary and proper to carry its provisions into effect. And that the registers and receivers of the several land offices shall be entitled to receive the same compensation for any lands entered under the provisions of this act that they are now entitled to receive when the same quantity of land is entered with money, one half to be paid by the person making the application at the time of so doing, and the other half on the issue of the certificate by the person to whom it may be issued. But this shall not be construed to enlarge the maximum of compensation now prescribed by law for any register or receiver. So I think that's basically just covering the compensation of the officials handling all of this administration. Provided that nothing contained in this act shall be so construed as to impair or interfere in any manner whatever with existing preemption rights, and provided further that all persons who may have filed their application for a preemption right prior to the passage of this act shall be entitled to all privileges of this act. And all persons who have filed their application. Okay, so I guess there was people had filed preemption right applications prior to the Homestead Act under, I don't know what provision that would have been, or just maybe a general thing. So they're saying that those shall basically be applied as if they were submitted via this act, provided further that no person, and if you, by the way, if you have a contrary interpretation than what I'm saying here, please chime in. But I'm just kind of, I've read this already, and a lot of this can be pretty dense. And again, some of this is irrelevant to our purposes here, but I want to read through all of it so everybody can see that there's nothing I didn't go over, or, oh, maybe there's something you missed. Everybody's seeing exactly what the complete Homestead Act says. Provided further that no person who has served or may hereafter serve for a period of not less than 14 days in the Army or Navy of the United States, either regular or volunteer under the laws thereof, during the existence of an actual war, domestic or foreign, shall be deprived of the benefits of this act on account of not having attained the age of 21 years. So it's saying here, if you aren't 21 years, because that's one of the requirements, you have to be 21 years. So you're not 21 years, but you served in the military for at least 14 days, then there's an exception for you. And you can do the patent. Section 7, and be it further enacted, we're almost done, that the 5th section of the act entitled, an act in addition to an act more effectually to provide for the punishment of certain crimes against the United States and for other purposes, approved the 3rd of March in the year 1857, shall extend to all oaths, affirmations, and affidavits required or authorized by this act. So I haven't gone to this to read this. I am 99.9% sure it's immaterial anyway, except it just says that this seems to be some kind of act that has to do with crimes against the United States, might even be the act that established Title 18 or something like that. And so basically it's saying here, what it's implying to me is that anybody who makes a fib on their affidavit or, makes a false oath is going to be punishable by the crimes as they're laid out in this act right here of 1857. Okay, and lastly, and be it further enacted, that nothing in this act shall be so construed as to prevent any person who has availed him or herself of the benefits of the first section of this act from paying the minimum price or the price to which the same may have graduated for the quantity of land so entered at any time before the expiration of the 5 years, and obtaining a patent therefore from the government as in other cases provided by law on making proof of settlement and cultivation as provided by existing laws granting preemption rights. So basically, I think if you waited the 5 years, you could buy the land at like a discount. But if you wanted to just go ahead and exercise the option, you could buy it at like the full price. That's kind of how this all worked out. So that's it. That's the whole act. That's the whole Homestead Act. Approved May 20, 1862. Now, again, this is just one act that the United States used to dispose of the land under its authority of the primary disposal of the land, which we're going to get into that term briefly because it's important. It's all a part of this. But remember, the important part here is what it said about the title, where it said, where did it say it? It was in section 3, I believe. Actually, hang on a second. Hang on 1 second. Stand by. Stand by, stand by, stand by. Gosh, where is it? 1 second. I think we should probably just jump into it. There it is, yeah. Okay, yeah, there. I didn't say where it was, so I gotta find, anyway. Well, we need to find it because otherwise. Wait a minute, wait a minute, wait a minute, wait. Okay, 393, sorry. Just want to show you it's here because when we get to the part in my notes, I want you to show you, I want you all, everybody to agree that it's here. I apologize. Again, this is preliminary, so the purchaser shall acquire the absolute title by the purchase. The purchaser shall acquire. Does anybody see that? The purchaser shall acquire the absolute title. We need to find where it says the purchaser shall. Must be right here somewhere. Where does it say that? Maybe it's on. It's up here. Let's see. Oh, here it is. Sorry. At the very top, said land for the okay, but for no other purpose, and the purchaser shall acquire the absolute title by the purchase and be entitled to a patent from the United States on payment of the office fees and sum of money there herein specified. Okay, now and I think I got a little distracted to trying to explain the whole thing about the infant thing, but remember that this whole clause, that last part there, like this is explaining how, after the 5 years, and once you do this, and then you do this, and then you do this, except if they're dead, and then it's the widow, but except if the widow dies, then it's this, and then, but if both of them are dead, and there's an infant child, blah, 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 if all of those things, after all of that, whatever the case is, there's going to be a purchaser, and it all culminates, this is, and the purchaser shall acquire the absolute title. See that term there? It's very important. The absolute title by the purchase and be entitled to a patent from the United States on payment of the office fees and sum of money herein specified. So I'm just going to very quickly capture this because I want to put this in my document. And then so copy that. And so now I'm going to stop the share here. And now I'm going to move over to the good stuff. So this is what y'all been waiting for now. Move over to my notes. And it's right here. And this is what I was looking for. And I'm going to put that right under here. Okay. So let's begin. In just a preliminary note, unless noted, all the definitions here that you're going to see were taken from Black's Law Dictionary, 4th edition. And any emphasis you see, such as underlining or bolding, I added it. And so like we just finished saying, on page 393, the Homestead Act, it refers to absolute title. Okay. Let's come back to this because this is actually, this kind of should be at the end of the document. But remember, I kept pointing out the part where it says he has never borne arms against the government of the United States or given aid and comfort to its enemies. And so one of the things that allegiance okay, again, this shows you kind of my presentation still needs work here. allegiance plays into the feudal system, right? Obviously, you had to pledge allegiance to the feudal lord above you, and and on to the crown. So allegiance is an important thing here, and they keep expressing it here, right? You can have never borne arms against the government of the United States. And what is allegiance? It's an obligation of fidelity and obedience to government in consideration for protection that government gives. So allegiance to the government is an obligation of fidelity. So the citizen owes an obligation of fidelity and obedience. So they must obey the government in consideration, in exchange for protection, for the protection the government gives. So the government protects our borders, protects you from foreign invasion, from somebody stealing title on your house, protects you from common thuggery, and theoretically, of course, right, all these things, because the government is, especially these days, sucks at the job that they're supposed to be doing. But we're going to return to that later, but keep that in mind. Let's look at some terms here. A lot of people want to call patents alloidial. And gosh, one of the things I wanted to do is pull up an actual patent so we can read an actual patent. But at this point, I think you guys are probably done with looking at source material. But it is important to look at a patent. If you've never looked at one before, we'll do that later, because that is important to actually see what an actual patent says. Because it never says allodial on the patent, for one, okay? And people use this term all the time, but never once is allodial mentioned anywhere having to do, well, I take that back. There is one place, and we'll get to that. There's always a complication, but allodial is the definition: free, not holden of any superior lord, or superior lord, owned without obligation of vassalage or fealty. The opposite of feudal. Remember that. Allodial is the opposite of feudal, okay? Let's move on. Feudal, pertaining to feuds or fees. Fees, relating to or growing out of the feudal system or feudal law, having the quality of a feud, as distinguished from allodial. So allodial is not feudal, and feudal is not allodial. These are two entirely different concepts. Does anyone disagree? I will give ample time for anybody to raise their hand, to chime in and disagree that these two concepts are entirely different and separate.
Well, fear and faith aren't compatible, and I don't see how and feudal is compatible in any way,
With what?
right?
With fear and faith.
I and feudal are not
You're breaking up. I don't know if that's
together.
you. Is Cynthia breaking up for just me or for others as well?
Others too.
Me too.
Okay.
Oh.
Thank you. Say it again, Cynthia. You were breaking up.
Am I breaking up now? Is that okay?
No, you're good. You sound good now.
Kind of
So the
cutting out too. I think our about ready to go down with the rest of the country.
Okay.
I was just saying fear and faith are not compatible, and neither is allodial or feudal.
Thank you.
Yeah, they're two different things.
Okay. So we all agree, basically. We all agree. Okay. I just wanted to make sure that there's no differing opinion or whatever. Now moving on. Fee. Here's what a fee is: a freehold estate and land held of a superior lord as a reward for services and on condition of rendering some service in return for it. So that's what a fee is. Okay. And in American law, in a state of inheritance, and I underline that for a reason, which we'll get into, without condition. So this is what a fee is in American law, okay? Because this is the English common law definition, and then this is the specific American law definition of fee. That's what this is saying here. In a state of inheritance without condition, belonging to the owner. Okay, so inheritance without condition. This is a very important term, which will start to become clear as we go on here. Being attacked by a fly. Belonging to the owner and alienable by him or transmissible to his heirs absolutely and simply, and is an absolute estate in perpetuity and the largest possible estate a man can have, being in fact allodial in nature. And this is the thing I was talking about up here, where there's this exception. And we'll address that in a second. But basically, this is saying that a fee is an estate where it can be inherited without condition. So it can be passed down to any subsequent generation or heir or whatever without any condition, whether they're male or female or whatever. I'll show you that distinction here in a second. We'll get to that. And so it's alienable by him, meaning he can sell it if he wants, or it's transmissible to his heirs, absolutely and simply, which just means, he can just put it in his will and pass it on to his children. And is an absolute estate in perpetuity, meaning it doesn't expire. It doesn't end when he dies. It doesn't end when his children dies. It's forever. Is that starting to sound familiar? The forever benefits of the land patent. Okay. That's the forever benefit. We'll start to show you how that is, what it's referring to, and not something else. Okay. So here's a note I put in here where I say, sure, one can point to the last part where it says allodial in nature. But I respond thusly: one, in nature is not the same as allodial. So they're just saying in nature. They're saying it's like allodial. They're not saying it's allodial. Point one. Point two, that definition would otherwise contradict with everything else I'm pointing out so far. Because again, allodial is not feudal. And as we're going to see as we go on, a fee simple estate, a fee simple, the title, which is the highest title in American law, is based on the feudal system and not the allodial. Okay, that's the important part. So maybe this part should actually be pushed down lower in the explanation here. But keep that in mind if you must. But I will show you how that, I believe, is some kind of mistake. It's either, as I go on to say here, I think the court erred in that ruling, or it's a mistranscription. I need to go into this case. I need to find this case and read it and see what was actually said, because that's where this quote comes from, out of Black's Law Dictionary. If you weren't aware, when you read Black's Law Dictionary, everything you're reading, it always has a citation after it, because that's the actual case where it came from, where what they're saying came from. So it was something that a learned judge said somewhere. They went through and they edited all, they pulled definitions from all the different case law. Black, whatever his name was, I forget his full name. He must have read through millions. I don't know how many cases the guy read, because that's what Black's Law Dictionary is. It's just excerpts from infinite number of cases. So that's from this case. And so I'm going to read this case and find out exactly what it's saying here, and find out where this allodial in nature, what the context of that is. Right? That's going to, for sure, clear up what was actually going on here, because I think it's a mistake of some sort, and it shouldn't be there. Let's move on. Fee simple is, so I already said this. Fee simple is not allodial. We already agreed to that, because we've agreed that allodial and feudal are different. A fee is a estate of land held under a feud, or is it's basically under the feudal system. And so we're dealing with feudal law here. Okay. So at this point, allodial title is out of the question with patents, because again, I still need to prove that. Sorry, jumping the gun. Okay. So let's continue. Here's the definition for fee simple absolute. Again, this is from Black's Law Dictionary. A fee simple absolute is an estate, and if you've arrived late, all the definitions here are basically Black's Law, 4th edition. A fee simple absolute is an estate limited absolutely to a man and his heirs, and assigns forever without limitation or condition. And again, this is mirrors language you actually see in the land patent. So that's what a fee simple is. And remember, back on page 393, it said the purchaser shall acquire the absolute title. And what they refer to, and what we already know what title they're referring to, is that it's a fee, because they do mention that in the page 392. They talk about the fee. And so And so what is it? It's an estate limited absolutely to one man. So it means one guy gets to own it all or gets to have it or use it, and his heirs forever. So there's no limitation to it. Because and this is what I keep looking. I don't know if I put this in here or not. I'm not sure if I did, but what I need to do is add the there's the yeah, okay, kind of mentions it here. To understand the absolute part, you have to see it in contrast with the other types of fees, where it's fee simple conditional. So once you understand what fee simple conditional is, then you understand what fee simple absolute is. And you start to realize that all these terms, they sound great, like, oh yeah, I get to absolutely own it. It's limited absolutely to a man. That's not what it's referring to, though. It's just saying it just has to do with the inheritance of it, the inheritability. That's why going back here, I had underlined inheritance. Okay, and for the definition of fee under American law has to do with inheritance. That's what the whole thing is about. That's really what the land patent is all about. Keep this in mind. It's all about just inheritance, being able to pass the land along to the next of kin. That's all it's about. It has nothing to do with owning it and not being, foreclosed on and blah blah blah. American law. So again, we're on fee simple. In the American law, an absolute or fee simple estate is one in which the owner is entitled to the entire property with unconditional power of disposition during his life. It says unconditional power of disposition. It doesn't say unconditional power. It says unconditional power of disposition. What's disposition? Disposing of it, selling it, giving it away, whatever he wants to do, disposing of it, right? During his life and descending to his heirs and legal representatives upon his death intestate without a will. Unlimited as to duration. Unlimited as to duration. This is what I've been explaining. To disposition and descendability. Again, this has to do with, because the conditional fee simple means it can only go to certain heirs under certain conditions, which we'll get to in a second here. But note, as I wrote right here in my note here, this is anything in brackets is my notes. None of these attributes have to do with actual dominion over the land, right? None of this has to do with owning the land outright and being, the absolute owner and the supreme sovereign having control over the land. None of that has anything to do with that, okay? The estate which a man has, it only has to do with descendability, the disposition of it, and the duration of that disposition and descendability, which is for life, and for the life of the heirs and assigns, and for their life, and on and on and on. That's what it means. It means it'll never go backwards to the government. That's what it means. Because in the feudal system, it did. Land sometimes reverted back to the Lord. That's what the land patent's all about. It just says, it's yours. It's never coming back to us. It didn't mean, though, that you can't, that you won't be governed and regulated and taxed, because it's not said anywhere in the Homestead Act, right? We read it. There's nothing in there. It says, oh, by the way, when you get this patent, you're not going to pay taxes either. You'll be forever untaxed and forever unmolested by government regulations and yada, yada, yada. It doesn't say that. So pay attention while we're going through all this of what this stuff is not saying. Okay, let's read the chat here real quick. Bingo. Yes, thank you, Max. Okay. Continuing, the estate which a man has where lands are given to him and to his heir. Now, remember, we're still reading what the definition of fee simple absolute is in American law. The estate which a man has where lands are given to him and to his heirs absolutely without any end or limit put to his estate. The word fee used alone is a sufficient designation of this species of estate, and hence simple is not a necessary part of the title, but it is added as a means of clearly distinguishing this estate from a fee tail or from any variety of conditional estates. See, now we're starting to see the contrast. which now gives us better understanding of what fee simple absolute means. Okay. A fee tail, and then this is just a edificationary note. A fee tail is a conditional state, meaning one limited to a fixed line of succession, the issue or children of the grantee, right? So that's what a conditional state is. It can only go to the children. Why? Because in feudal times, if a superior lord granted a fee to somebody, it wasn't absolute. It was conditional. You can only give this when you die. You can only pass this on to your children, and that's it. When they die, it comes back to me. That might have been the deal, or it could have been, but during your lifetime, you can't sell it. It's fee simple, meaning, but it's not absolute. It's conditional, meaning it can only go to you. Okay, you get it. It can only go to your children or some limited thing. So that's what absolute is talking about. In case you had some idea that again, going back to here, limited absolutely to a man. If you're not reading these words right, understanding what these are saying, what these terms are referring to within the context of feudal law, then you're getting a different idea that's based on your biases, on your preconceived notions that you want to believe are true, because it's going to solve a problem for you, but it's not serving you. It's only working against you ultimately. Fee simple signifies a pure fee, an absolute estate of inheritance. This is all out of Black's Law Dictionary, by the way, this whole thing. I'm just FYI. Fee simple signifies a pure fee, an absolute estate of inheritance, clear of any condition or restriction to particular heirs, being descendable to the heirs general, whether male or female, lineal or collateral, meaning like, I guess, adopted people or something like that. And my note, again, nothing about dominion over the land here. Simply has to do with succession and inheritance. Okay. Terms fee simple, and fee simple absolute are equivalent. All means the same thing. Oh, there used to be an emphasis here. I copied all these notes from chat room where I initially posted all this. Okay, now I highlighted, you notice I emphasized, I italicized estate in all these places where estate was written, right? Well, here's why. Let's look at the definition of what an estate is. The interest which anyone has in lands or in any other subject of property. An estate is lands, tenements, and hereditaments. An estate in lands, tenements, or hereditaments signifies such interest as the tenant has therein. So an estate in lands, tenements, or hereditaments signifies the interest that the tenant has. That's what the estate is. The condition or circumstance in which the owner stands with regard to his property. Okay, so your estate is the condition or circumstance in which you stand with regard to your property. In this sense, estate is consistently used in conveyances in connection with the words right, title, and interest, and is in a great degree synonymous with all of them. So an estate is your right or your title or your interest in the property. That's what your estate is. Your estate comprises your bundle of rights, title, and interest. Okay, so going back then, everything being, I just wanted to show that, what was I trying to show here? I guess what I was thinking at the time was that it just shows that it's really just a bundle of rights and not like the actual land itself. It's not like you're getting, well, you are getting the land itself, but let me develop out that idea further. It's not important for our discussion right now.
It's almost like you're getting a privilege to hold on to that piece of property until like something happens in your life where they might reclaim it so they can put the property back in circulation.
Yes, that's exactly right. Or when you dispose of it. And so your estate in this case is absolute fee simple, meaning it's for life and it's for all your heirs and assigns forever. Okay. So I was just trying to, but when you start looking at these words and their definitions and stuff, it's useful in that it does give you a broader understanding overall. You just get a much broader understanding. So it's useful to bring this up. But again, I think that's what I was thinking at the time, but we'll just pass on. I'll refine that thought more later, like I said. Okay, so this is me saying this. Land patents have never passed a allodial title to the grantee, only fee simple. Okay. Does anybody disagree with this statement at this point?
That's about accurate. I can't find any disagreement with that.
Anyone else? Let me read what you said in here. I'll wait for anybody else to chime in. Feel free to at any time. If you're late coming into this, the question I put, as I've been going through this, is I'm saying if I'm wrong with any of this, tell me where I'm wrong and or where you disagree, and we'll discuss it. But you probably can't do that if you came in late, because you really need to have seen the beginning of the presentation. But anyway, just going to read what Max says here. Fee simple absolute, fee simple determinable, and fee simple conditional estates, as well as life estates, are all forms of freehold estates. And so, see, again, you read that term freehold and you might think it means one thing, but again, it's a feudal term. It comes out of the feudal system. Fee simple absolute estates are the most common forms of estate in the United States, and most home ownership deeds fall under the fee simple absolute definition. Right. Okay, so do we agree that land patents never passed a allodial title to the grantee? Only fee simple. Last chance to object. Otherwise, we all agree to agree. All right, moving on. Absolute title, again, this is from anytime you see a bolded thing like this, this is this definite, well, it says right here, it comes from Black. So this is from Black's. As applied to title, as applied to title to land, absolute title is an exclusive title, or at least a title which excludes all others not compatible with it. With an absolute title to land, an absolute title to land cannot exist at the same time in different persons or in different governments. So basically, just gives more color to this term absolute, what an absolute title is. And it's just saying it's exclusive to one man. And so I think what I was trying to do here is, again, show that these words absolute, I didn't really focus too much on freehold, but what's the other term that we were looking at? Again, absolute, limited, absolutely, if you don't understand these terms, what they really mean, then you might be led to believe, again, as I was, that they indicate something that they don't. So that's why I was including that definition. So this is me again. Land patents are entirely misunderstood. The title does not grant unlimited freedom of use of the land, i.e. absolute sovereignty over it, but rather unlimited right to pass it down to successors. That's what fee simple is all about. So that's what the land patent is all about. It just, again, the most succinct explanation is it's the government's way of saying we are never taking this back, because that's what happened in the feudal system. In the feudal system, the land would revert back eventually to the superior lord. What the land patent does is says this is never coming back to the government. It's one way only. That's all the land patent is about. That's all it's about. Nothing more. Nothing about you have a sovereign authority over it, and now it's your own nation state, and you can make whatever laws you want. You'll never be taxed on it, and blah, 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 blah. That's still all bullshit. Okay, moving on. So again, this is me. Note, this is only about title to land, no, not right to govern over it absolutely, i.e. sovereign land, see allodial. Again, so allodial is not feudal. We've already explained that in all that. I don't know where I got this from. Title is the means whereby the owner of lands has the just possession of his property. That probably came from Black somewhere. And then, so I write here, I note that Section 4 of the Homestead Act, remember when we read this, that no lands acquired under the provisions of this act shall in any event become liable to the satisfaction of any debts or debts contracted prior to the issuing of the patent, therefore. And this is my note. Why? Because you can't encumber land for which the government has not yet released title, of course. And once they release the title to you, then you're welcome to encumber it and lose it through foreclosure if you don't pay your mortgage or your property taxes. So again, going back to, we read the Homestead Act. It said nothing about it protects you from foreclosure or whatever, right? It just basically is all about title, all about transfer of title, all about the right to transfer title, and it's not going back to the government.
Well, that
Again, the
opened a can of worms right there.
yeah. Again, the Homestead Act says nothing about giving the land in allodium to the purchaser, so it can't be assumed that's what the purchaser has gotten, especially in lieu of any case law otherwise. And again, as I mentioned earlier, I've still got to go through a bunch of case law, but I don't think I'm going to find anything different to change my conclusion here. And now here's the thing to really think about. And this is the kind of stuff that, you always kind of wonder, like, yeah, wait a minute. But you somehow rationalize it away because, again, you want to believe this stuff is going to work for you. If one were to have actual allodial title to one's land, free from all U.S. or state government regulation, then one would truly be an independent nation. One would be broken away from the U.S. as a contiguous landmass, right? You'd be a completely separate entity if you had sovereignty over the land. And such a separation would require a treaty between the purchaser and the government. They're not just going to give you the land and say, yeah, have fun, just try not to piss anybody off around you. That's they'd have to enter into a treaty with you to make sure that you wouldn't turn around and start building up a army and then go to war with the United States if you had that kind of authority over your land, as people have suggested.
That comes back to the obedience part as being part of this social contract. So if we had like multiple feudal lords with the allodial titles, we'd have just constant war here.
That's exactly what I said. I said otherwise, complete chaos would ensue as many dictatorships sprung up across the nation. And although Bob Schaefer used to say to the contrary, there's no evidence that the land patent was intended to prevent the government from exercising its authority within the boundaries of privately held land that is within the jurisdiction or boundaries of the United States of America. That's just not how it works. So that's the presentation. That's the preliminary presentation. That's the end of it. I think I covered everything. Any questions? In summary, the land patent secures your right to keep the land forever, as long as you're alive, and then to dispose of it as you wish in accordance with the law. But it does not grant you any sovereign authority over the land itself. It does not grant you immunity from lawsuit, immunity from foreclosure, especially if you encumber it. It does not grant you immunity from eminent domain, which is already expressed in the land patent itself. That's what I wanted to do. I wanted to bring up an actual land patent just so we can, if you're not familiar, you can see what an actual land patent grants you as well, because that's also, I think we'd all agree, an important part of this equation here that everybody needs to see, so we don't leave any stone unturned. But before we do that, I will humor Kathleen. Go ahead. Kathleen, you have a question?
Yeah, sorry, I had too many things open. I was just gonna say that, I'm sure people know this, but if you do not pay your taxes on your land in a timely manner, they can put a tax lien on your, for sale on your, and publish it nationwide, and people can purchase your land without you knowing.
But
Yeah,
that's not the federal government. Those are local municipalities, the counties or the states. Generally, unless the IRS is coming after you or something.
I had a question.
Yeah, go ahead.
Kathleen, thanks for bringing that up. I've been in a wrongful foreclosure in the courts for quite a long time. They've been paying the property taxes on my property. Do you think I'll have to pay that back? I mean,
It depends on what settlement you eventually end up with.
Oh,
Once solved.
optimistic saying settlement because I plan on getting one. That's for sure with what they've done.
Well,
So,
that's what I mean. Hopefully the question implies that you're eventually going to prevail. And so when you do get to the point where you're going to settle, that's one of the things that's going to be discussed and negotiated.
Okay, I yield. Thank you.
You're welcome. So by the way, I'm on the BLM website right now, which has records of all the land patents. So I'm gonna, and this is, put this in the chat so others can play around with this. I've showed before at least a couple times how to find land patents. It's actually kind of easy, but I'm just gonna pull up a random one here just because we're gonna find one and read it. Let's see, and we have to start really in the western states. So let's do California, and here, let's try to find something in Placer County. And let's see, you can actually search by the name of the original grantee, but we're gonna not do that. We're gonna do by township and range, and I'm just gonna guess here at something because. So first of all, the meridian we're gonna use is Mount Diablo meridian. So Mount Diablo is that big tall mountain in the Bay Area. And what they did is because you could see it from from a large part of Northern California. That's what the Lewis and Clark expedition, when they surveyed the land, or I don't know if it was Lewis and Clark, whoever surveyed the land, they used Mount Diablo as what's called the meridian. That's the center point, the origin point. And then they based all of the surveying off of the top of Mount Diablo. And that's where they split everything into these townships and ranges. And again, a township is 640 acres, which is a square mile. Okay. And a township is 6 miles by 6 miles. And it's split up. So a square mile is split up into 36 sections. And each of those sections is a 640 acres is a square mile, right? Or wait a minute. No. Six by 640 acre sections is a square mile. So 36 640 acre sections is a square mile. So anyway, the whole Western United States is split up into this grid of townships and
There's
ranges.
640 acres in a square mile.
Say that again.
There are 640 acres in a square mile.
You're right. So there are 36 square miles in a township. And a township is one unit of the surveying map. And which is 6 miles wide and 6 miles high. So yeah, you're right. So there's 6 square mile plots high and wide. And so the town, so now don't get while the square mile is called a township, or I'm sorry, while the 36 sections is called a township. I'm sorry if I'm confusing you guys. None of this is important, by the way. That's called a township, but the way that they're measured is by township and range. Township is horizontal, east-west, west to east. Range is north to south. Just FYI. So we're going to select township 5. You can also get into quarters and halves and stuff. Never used that at all. It's very special cases. I'm going to say 5 north, which probably brings it up to around Sacramento in terms of that latitude. And then range will do 5 east. So that's going to be, I don't know. It might actually be in the Sacramento area where we're looking now. And I'm going to say, I'm just going to leave section empty. Because again, this is not to teach you how to look for land patents. This is just to try to find one. So here we go. Sacramento County, I was right. So here's one. Click on that. And it was issued to a railway. So it's a railway patent. So this is not what I want to find because it's not a homestead patent. But you can see right here, here's the patent. This is the authority that this patent is granted under. And let me zoom. The July 1st, 1862 railroad grant statute. So it was issued to Central Pacific Railway. These are all the different parts of land that are part of it. But what we want to do is we want to look at the patent image. So here it is. And we'll just look at this. Hopefully it comes up. Maybe it might not. It should come up. I think it's coming. But this is just a railroad patent anyway. We still need to find a homestead patent. All right, this is a big one, and it's because it probably railroad patents typically listed like a lot of different sections. Okay, what is this? Patent number 9744469, Central Pacific Railroad, primary limits. States the acts under which it was granted. Yeah, whereas by the Act of Congress approved July 1st, 1862, as amended 1864, to aid in the construction of a railroad and telegraph line from the Missouri River to the Pacific Ocean, and to secure to the government the use of the same for post-military and other purposes, yada, 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 yada. And so now basically it's just explaining the grant. You know, this is just giving all the background behind what this, how this grant is authorized, and now it's naming, now it's actually laying out, this is the meets and bounds basically. So it's giving all the different townships that are part of this patent. And here's the grant. Now know ye that the United States of America, in consideration of the premises and pursuant to the said acts of Congress, has given and granted, and by these presents does give and grant unto the said Central Pacific Railway Company, successor in interest to the Pacific Railroad Company, its successors and assigns the tracts of land listed as for aforesaid and described in the foregoing. Notice this part, to have and to hold. Some of you may remember the presentation I gave a long time ago about that phrase, to have and to hold, where I basically suggested everything that I presented tonight, because that one phrase alone indicates that the land patent is not allodial, as people used to believe. Because that phrase itself, if you look it up in Black's Law Dictionary, says it denotes that it's held of a superior lord, the feudal system. So even the railroad patents, same thing. Some people have speculated the railroad patents gave them, well, I've read it in Ron Gibson's book, for example, that they have sovereignty over the land, and blah, blah, blah. They don't. They just have, they have regulatory authority because the railroads have priority in right of way. So they have regulatory authority over their land. They guard it very closely because they don't want people squatting on it and yada, yada. So that's the only difference, but they still own it of a superior lord, which is the United States government.
What was the what sentence in there are you pointing to?
To have and to hold. See, it's in Black's Law Dictionary. I meant, you remember, you probably remember me talking about this several times, Gavin, but I'll just read it right now. To have and to hold. And I'll show you how this indicated, you know, because, and again, once I pull up, when I pull up a Homestead Act patent, it'll have this phrase in there too, and it's always bolded like that. That's the key. That's why I noticed it. I was like, why is that always bolded? And you'll notice it in the Homestead Act patent. It's a lot more obvious. Like to hear, okay, it looks a little weird. It's uppercased. Maybe you think like, oh, okay, maybe that's just like indicating the beginning of a paragraph. Well, why wouldn't they just put that in a paragraph? You know, so there's no other explanation. In other words, it stood out to me, and it stands out even more in a Homestead patent because it's a different font, it's bold, and it's all uppercase. So it really stands out. So I'm like, why is that standing out like that? So I looked it up, and it's in here as a phrase, to have and to hold, and it is defined thusly: to have and to hold. The words in a conveyance which show the estate intended to be conveyed. Thus, in a conveyance of land in fee simple, feudal, the grant is to A, that's supposed to be like a stand-in for a name, to A and his heirs to have and to hold the said land unto and to the use of the said A, his heirs and assigns forever. Then it goes on to say in the small print, this is what you really need to pay attention to. And the small print is gone in the 5th edition. Yeah, in order to get the small print, which has all the really good stuff, that's in 4th edition. That's why you want a 4th edition. So here's the small print that continues on. Strictly, sorry, there's mosquitoes everywhere around here. Strictly speaking, however, the words to have denote the estate to be taken, while the words to hold signify that it is to be held of some superior lord, i.e., by way of tenure. The former clause is called the habendum, the latter the tenendum. And then I went in this deep dive many years ago on tenure, which leads into sockage, which leads, and then in habend, what the habendum is and what the tenendum is, and all blah, 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 all these words, it all goes back to the feudal system. And then the more you understand, if you follow all those, you start to, see that, wait a minute, this is all feudal. This is all, nothing about this is allodial. So that's what I noticed. So anyway, and then here's, the signature of the president and all that stuff. And that's it. So let's go back. Let me see. Okay, let me go back. Let's try again. Let's try section. Let's see, that won't help. Let's do.
I gave you a township map in chat, so if you want to pinpoint a location.
Okay, hang on. I think I can. Okay, so this is interesting. This is a state of California. Let's look at this real quick. I think this is a state of California owned land. So this is a January 1927 Act indemnity selections. I have no idea what this act is. Sounds very interesting. Let's just quickly look at the image. Not available. See, some of these are not available, by the way. A lot of them are, though, by the way. But that's very interesting. Something to look into. Okay, here we go. Here's going to be a private one. The date it was issued 1865. There's a person's name, Anastasio Chaboya. What a great name. And as you can see here, the heirs of, so, that's covered. Remember, we read all about that. So let's go into here. This is going to be a Homestead Act patent. Or no, damn it. Dang it. It's a Mexican Spanish land grant patent, which was a special patent in itself that real quickly, because it's interesting history. When they were negotiating the end of the war between Mexico and the United States and negotiating the purchase by the United States from Mexico of Nevada and California, they gave them like 14 million silver dollars for the trade. But the sticking point was that they weren't going to honor the land grants that the Mexican and the Spanish government before that had given to, the different people like Anastasio Chaboya, for example. And so Bob Schaefer claims that was the origin of the term Mexican standoff, because the Mexican parliament refused to proceed with the negotiations until they agreed to the demands that they honor the Mexican and Spanish land grants. So eventually the United States government gave in and agreed to that, but they said, okay, the condition is we will, but you have to apply for recognition of your grant, and once you do, then we'll issue you a land patent. And so that's what this act is all about. Okay, so we can still look at it. Oh wait, no, we can't. We can't see this one. So let's try again. We need to find one that's based on the Homestead Act. And Dev, what is your question? Go ahead.
Yeah, I was just thinking about the to have and to hold phrase. It kind of reminds me of a kind of typical old school wedding vow kind of.
Well, okay. Yes, because that's what you say, right? You say to have and to hold. It's the same concept. So I was just thinking about that, and to address that, and I was thinking, well, in that case, you have your wife to have and to hold, which denotes that she's held of a superior lord. Who's the superior lord? Is it the father or is it the father?
I have an answer for that.
Okay.
The word in Hebrew, Baal, is the word for husband, and it literally means lord or manager.
No.
Oh. But the thing is, I think there's a distinction also between a wedding and a marriage. A wedding is a private two-party contract, and a marriage is a state-building contract where it's a three-party contract, and the state or heads of state are ultimately the lords of both the husband and wife in a marriage. and that's why they act like they own your ass.
Well, let's see what the definition of marriage is in Black's. Marriage, marriage, as distinguished from the agreement to marry and from the act of becoming married, is the civil status, condition, or relation of one man and one woman united in law for life for the discharge to each other and the community of the duties legally incumbent on those whose association is founded on the distinction of sex. A contract, according to the form prescribed by law, by which a man and woman capable of entering into such contract mutually engage with each other to live their whole lives together in the state of union which ought to exist between a husband and wife. So it's not a union of husband and wife. It's a state of union which ought to exist. So yeah, so it's like the fiction of holy matrimony.
I think you read two different definitions. One said estate, the second one said estate. The first one said civil status.
Yeah, well, it's the same. It's from the same definition, but it's just. Remember, when Black's Law Dictionary writes these definitions, they take them. The excerpts are from actual case law. So what's happening is the first part I read is from one case. The second part's from another case. So let me read the first part again, because that also shows that it's a state thing, right? Because it says marriage as distinguished from the agreement to marry and as distinguished from the act of becoming married is the civil status,
right,
condition, or relation of one man and one woman united in law for life. So it's the civil status.
Yes. Right. And,
so
and saying one woman, all that stuff is almost like word salad. It's really just a civil status. It's a state issue.
I agree. Totally agree.
And so I'm not trying to hijack this into my specialty, but then there's the word wedding.
All right. Well, hold on. Let's pick that up later because we could talk about that more later. I want to finish this because we have a patent now.
Right. How it relates though is I kind of take it to mean having to hold. The having to hold part, and kind of like the way you read also earlier about, I heard you say the word give, so it sounds like it's a gift. And once something is gifted, who owns the gift? Not the gift giver.
Well, yeah. Again, that's the point of this. The whole point is that in the feudal system, the land could have reverted back to the superior lord. In this case, what the land patent is saying is it'll never go back to the superior lord, which is the government. It'll always go forward. But there's still, it doesn't mean that you're sovereign. It just means that you have title to the land.
Right. It's being a sovereign and being the one title is like having titles like sovereign over objects.
Well, then, and then it also doesn't mean all these other things that people ascribe to it. Like the government can't come onto my land because I have a patent, or the bank can't foreclose on my land because I have a patent, or the local municipality can't enforce code on me because I have a patent. Those are all myths. So
I don't know, and I think you're right to look at these different terms very carefully, and that's why I actually find this very interesting that you're going through this. I just want to say one other thing. A lot of people think, like you said, this means, but of course this means that. And I like to use this and that as great examples because they're literally spelled different. They're 4-letter words, this and that, but they're not the same thing. And so we shouldn't just jump to conclusions and equate to the same thing. It's a silly example, but people think, like Adam and Eve were married. Well, the Bible doesn't say that. It says they're husband and wife. Isaac and Rebecca, Joseph and Mary.
Well, the distinguishing term that I use for a union under God is holy matrimony or matrimony. I believe that term is reserved for the actual union under God, whereas marriage is a civil term, as we just read.
Well, both matrimony and marriage come etymologically from the word mother, and I'm not trying to hijack this back into
right. Matrix means mother. Matrix means womb. Actually, I take that. It means womb.
Okay, it may even go yeah, that way as far as the etymology, but the from my etymological research, I only went back to mother. But anyway, you're probably correct about that also.
The Latin,
I'm
yeah,
just saying,
the Latin meaning of matrix is womb.
sure,
I don't,
and
I don't,
and my
and I don't know if that means literally means like the woman's womb, or if it just means like the concept of a womb, where things are,
yeah,
developed.
I'm not.
Yeah.
I'm not objecting that even the slightest. I'm just using this as a analogous example, just an example to show that people jump to conclusions about things, but when you carefully research it, you'll realize that there is literally no verbiage in the scriptures, for example, that shows that Joseph and Mary were married. They were husband and wife. The angel Gabriel said, "Take your wife," but the only thing you had for sure up until that point was that Mary was betrothed. And then you see that the only essential element that establishes a marriage really is consent. And obviously, consent is given at the point that someone says, "I will," and then later at a ceremony when they say "I do," it's just a restatement of the fact that already existed.
Ah,
And so
interesting.
that's why Mary was already his wife, because she was betrothed, which is Old English, meaning to speak truthfully. But there's a consent in that.
Well, then that's interesting that you say that. And without going further off topic,
Right. Sorry.
we'll just say that because I do want to get back to this and finish it, but because we just
Yeah.
have to go this patent. But
Right.
I did
I'm just
notice.
using it as an example to
Well,
say
listen,
it's important
when
to
me
be
and
very
my
careful about
when me and my
starting
second
with
wife
what
got our marriage license, we decided to get it a private one or confidential. You can get a confidential marriage license, and
oh, but
I
you get
don't
it
know.
from the state, right?
Well, of course, and so but we wanted it confidential just because we both agreed that we just wanted our lives private, as private as we
Yeah.
could. And
Okay.
so what it said on that form, though, when you filled it out, is it said, "We agree that we have been living together as husband and wife."
So it
So
already happened.
isn't that interesting?
Yeah, you were already husband and wife. Is the claim that you're making in the paper? Yeah, and I'm sorry, I'm not trying to make an issue about husband and wife. Even I'm just saying it's as a method of analysis, it's important to not jump too quickly to conclusions that, oh, but of course this means that, without really
Exactly.
carefully
Right.
understanding of whether they're actually related or not. And so,
Right.
so it is with land patents and sovereign. Well, you must be sovereign. Well, that's a leap that you got to
But Dan,
connect the dots.
you just hit the nail on the head on the problem with all of this shit. The people who are promoting these ideas about land patents, American state nationals, what's the other thing that's a biggie? It's all they don't know how to read law. And
Yeah,
I know
and they're
this
not
because
connecting the
I
dots.
didn't know how to read it before either, and I learned. That's the difference.
Yeah. All right. Thanks for
And
letting me contribute that.
yeah, let's get back to this real quick. Kathleen, just hold on with your question. Um, I want to just finish looking at this land patent, which is on the screen. It's hard to read with the fancy text, but let's just go through it real quick. This is a wait, did we confirm that this is a homestead patent? Where was the where's the thing where it said oh wait, no, we have to go back into it. Sorry. Patent image, patent details. Okay, so this is a different authority. Oh boy. But it's fine. It's going to be the same. Um, well, no, because we really should look at an 1860 patent just to make sure. Why would this be under the authority of an 1820 statute? Oh, because it's California? What? That doesn't even make any sense. Hang on a second. Let me try to find another one. Let's try this one. Nope, that's 1820 as well. We need to find one that's based on the Homestead Act. the heck is going on here? This is a script or nature of script act. That sounds interesting. I gotta go through and research all of these eventually. All right, hang in there, everybody. I'm trying to find.
Hey, buddy, while you're researching that, maybe I could have a couple minutes just to
Go ahead.
state my case on this. You know, do I have let's say, I don't know. I know you're almost done here at 8 o'clock. So I don't know. How much time do I have? 2
Well, I'm
minutes?
just trying to find a patent
Well, I
based
know.
on
I'm
the.
just saying mute out for a moment while I make my case. And I'd like to have the opportunity if I
Oh, I'll
may.
give you 5 minutes. How about 5 minutes?
Okay. Yeah. It's more than enough. Yeah.
Go for it.
Perfect. Okay. So yeah, just give me 5 minutes and everybody and hold off for a second while before anybody interrupts. And then
Nobody interrupt Gavin while he has the floor for 5 minutes.
okay. And I don't think I really need that, but let me just base this kind of a summary as to this excellently, very insightful, highly stimulating presentation. That we've been so gracious to receive today. And so in summary, and some of the key points that Salam has been so kind to show to us is his findings and conclusions about the land patents and how they don't necessarily mean what we believe they say they mean. And some of that is actually going to, go into the wording of the patents and actually where they're coming from in the acts of Congress and the case law, which I fully support him on. And, one of the interesting, I think, most compelling findings is that the patents come from the feudal system. Now that shouldn't be taken. Now, my point here is, and I'm kind of bring back home, is we should not glaze over that the patents come from the feudal system. Let's not glaze over that and just move forward and say, okay, great. We've got to, my challenge is that now that we've come to the conclusion that it is from the feudal system, now we have to go back and really comprehend, what does that mean? What was going on in the feudal system? What is the feudal law? How does the feudal law work? Where did it come from? And, to summarize that, where we could kind of regroup on maybe next week onto this discussion, because it's a big pill to swallow. But to summarize that is a great movie that a lot of people have seen. I will admit I'll admit that I've never actually seen it, but it's it's that stupid movie, that is a comedy, and I forget the damn name, but it's about the feudal system. And if anybody remembers it, chime in. But it's just this funny little comedy based in the UK back during the feudal system. And the feudal system comes back from not only England, but also from China and other places. Now, there's some
Monty Python, maybe?
Monty Python. Boom. There we go. Exactly.
And the King Arthur one where.
Yep.
Yeah.
Monty Python. So that kind of gives everyone kind of a background as to what the feudal system was all
That's
about.
but that's a pretty.
It's a loose reference that we can reference, right?
It's a caricaturized one, but anyway.
Right. So with that kind of loose, characterized in mind, now we see that we've got the serfs out on the manor, and the serfs are out there doing the grass and mowing the lawn. They're just serfs. And then the Lord comes out and he's like, oh, hey, you serf, you're my property. You belong to me. No, I don't. I'm not even a serf. What are you talking about? Get the hell out of, serf has no idea that he's a serf. So it's this feudal system. So we've come to the conclusion that the patents are from the feudal system. So my argument is that a case called Wong Kim Ark versus United States versus Wong Kim Ark is it solidified, along with the 1933 McFadden speech in front of Congress, that we did bring forward a Machiavellian feudal system under the law. So we are living under the feudal system. That's the McFadden speech, 1933, acts of Congress. And then also the case United States versus Wong Kim Ark, which says that. So that being said, those authorities people can look up and reference and read for themselves. That being said, if we're living under the feudal system, well, we have to kind of a couple of other things to wrap. So I've got a minute left, a little over a minute. So a couple of things to consider, and that is one. Well, we know that the Constitution outlawed in the 14th Amendment, it outlawed slavery. So we're not allowed to actually have slaves. So what the hell is going on with this feudal system if there are slaves? But we're not allowed to have those anymore. Well, it only said that involuntary servitude was unconstitutional. Involuntary servitude was unconstitutional, but there was nothing in the Constitution that says voluntary servitude is not unconstitutional. So we've got to be mindful that if we're under the feudal system, and it's unconstitutional to make people to be slaves, well then, but if they volunteer to be slaves, that's okay. So if that's the case, there has to be a way to say, hey, wait a second. I don't want to be a serf anymore on the manor. Lord, I want out. Get me out of this system, please. There has to be a way, because if not, then it's totally unconstitutional. So my point is that if we are living under the feudal system, then there's got to be a way. There is a way that we can all of a sudden say, I'm out, and you're 100% out of that. So that's my case, and I submit.
Thank you. That's an interesting point. It's compelling as well. I think that makes sense because, if we go back to biblical principles upon which the United States government and the whole idea of this country is founded, there's always that element of choice, or that not element, but the idea of choice. We have a choice to either follow God's will or to follow man, and all the calamities and tragedies that brings along. But yeah, hang on one second though, because there was one thing about that I was thinking earlier today in regards to it had to do with the discharge, and it had to do with Jesus and dying for our sins, and the debt being paid, and then relating back to House Joint Resolution 192, otherwise known as Public Law 9310, I believe, or whatever it is. But I still haven't thought that out entirely, but there's something there, and I'll share that once I've had time to flesh that out. I have lots of hands up. I apologize. Let me pick them in order, though. Gavin, your hand is still up, but you already spoke, right? So then we have now, I saw Zeke's hand up first, and then Deb. So Zeke, go ahead, and then Deb after you.
Okay, well, first, to talk about what Gavin said, I would say the feudal system is what we need to define, so we don't skip over that, and we don't say that it means slavery and it means any of that, because we don't know. We have to research out, because it doesn't mean any of that. So he said we got to study it, and then the presumption was that it's the feudal system's bad or whatever, or has allowed slavery. Okay, so then we go to slavery, and he's right, involuntary servitude. So that brings us back to the money, because that's how they're enslaving us. It's not open. It's just you got to use their money. So now we're enslaved to the system itself, and that probably leads right into what you were talking about, Salem, that you talked about, is the debt being paid and how that is all going to unfold, and the redemption of everything, which could be coming soon. So, we really don't want to box ourselves in by definitions. And one other thing, I believe that the marriage, when we talk about the marriage, it's the evidence of the marriage. Okay, and evidence of the marriage, I think, whether it's civil or spiritual or whatever you want to call it, the evidence of the marriage is the offspring. And when you have children, this system we're in, I don't know if it's a feudal system, but whatever it is, the civil system, the government now, local, county, or state, will attach, even if whether you're married or not, if you have a child, then they will come after you for child support and for insurance, whether you're married or not. So they consider the marriage based upon the offspring, and that's the proof of the marriage, whether civil or spiritual. Okay, that's all I wanted to say.
Okay, am I up?
Yep.
All right. I didn't think that I was going to comment about this again, but since you brought it up, I think you're right about the children are evidence of marriage as far as the idea of marriage being based off of a mother or a matrix, meaning the womb. So proof of a womb is in the children. There had to be a womb. But you also said whether there's a marriage or not, which kind of goes to the civil status definition of the word marriage, which is the one that I think is quite a bit more frightening than the one that's based off of the word mother or matrix or womb. So, um, anyway, going to the feudal thing, without, this is just kind of off the cuff presumption here too, to say feudal sounds like a word that comes from the word feud, like to fight. And I was thinking about how the feudal system and maritime law or martial law, all this kind of stuff may be kind of related, and thinking about how do people get into positions of power like the railroad did or big corporations do, and governments don't go after them and attack them, but they seem to be allowed to do a lot of stuff that the little people can't do. And to me, this is just sort of an idea I've had. It seems like people, corporations or whatever, they set themselves up in a way so that to attack them would be too destructive, where there's sort of mutually intertangled interests of people that say that they're from the government and people who are getting away with things that the government say they shouldn't be able to get away with, but they're carrying on without being molested by the government, even though little people would be. And so it's a lot of it seems like it's just a dynamic of power where governments and large corporations and different entities, they really just only understand power, and it doesn't have to even make any sense or be really that lawful or conscientious or noble or righteous or good or anything. It's just a power struggle, and if people are too large, or corporations are too large, or governments are too large to have large conflicts with, they just don't have them, because there would be a feud that would be mutually destructive rather than something they can just ingratiate themselves by stealing from little people, basically. And when like this nation was founded on, the revolution, and I've really thought quite a bit about how could these people be, I'm sure there were some religious elements in it, but people that are truly Christians, how could they be involved in war like that? I'm not sure I totally comprehend that makes sense. I think it has more sense to do with it would be people who are interested in power. Was George Washington a deeply devout Christian, or was he more of a Freemason or something like that? And so the Constitution may be written for a nation of Christians and people who have moral sensibilities, and that's why it's kind of turning into a mess now, because it kind of depended on the people to kind of self-govern themselves in a way like that, I guess. But I kind of feel like it's more about power than people being lawfully minded. They're more interested in.
We'll bring it back around to the land patent issue and the feudal system, at least, or something having to do with this topic, because we're not really off it yet. I don't even know what you're talking about.
Well, I'm just this is just my mind tinkering, kind of trying to think through how could it relate, because.
All right, well, think through it and then come up with, when you have a thought out, bring it up. But after we finish looking at the land patent, because that's just the last thing I want to do, and then we can just close that issue, and then we can go into the other thing. I noticed that Kathleen has her hand up. Is this relevant to the land patent stuff, Kathleen?
Yeah, I was just gonna quickly say here, let me put my hand down, that someone brought up about alloidal, ALLOIDIAL lands,
It's allodial, ALLODI.
allodial. allodial
And we
lands,
talked about this earlier.
the absolute property of their owner and not subject to any rent, service, or acknowledgement to a superior. So I just think of what's happening globally. You know, we're talking about land, and I know that there are 340,000 to 380,000 acres that China has purchased of, along with their corporations. So
What does it have to do with the land patent issue, Kathleen?
because we're just thinking of just the USA, and I just think of globally what's happening with Britain or the movement of power.
That
You
has
know,
nothing to do with the land patent issue I'm discussing right now, Kathleen. So hold
well,
that
just
for
one last thought.
hold that until after I'm done, unless it has to
Okay.
do.
It does have to do with the land, because there could be a point where there may be
Okay, but this sounds like, again, this is
no
something.
more USA.
Thought. Yeah, it's a different
imported
thought
on
having to do with
land.
something else that we're not
Got it.
discussing right now. So let's go back to this.
Got
So
it.
let me pull up the land patent. I finally found one. So this is you can oh darn it.
Thanks, Kathleen.
Got which one I clicked on here. Oh, patent details. Okay, there we go.
You're
Okay,
welcome so much for my mind tinkering.
This is Giovanni Battista Fallini. This is a out of Carson City, Nevada. I looked further eastward in Nevada because I figured that's where this Homestead Act was probably going to apply, because California, when it became a state, that was 1849, and a lot of the patents that you're going to find for early California are going to be based on either the Mexican land grant thing or that 1820 statute for some reason, which I never noticed before. Anyway, we can see right here that this is based on the 1862 Homestead Act, which we read in its entirety. So now we know that this patent is definitely based on that. And as we see right here, it's 158.54 acres, so roughly 160 acres, which the Homestead Act talks about. So we'll look at the image, and this one's pretty simple. And again, the reason I really brought this up is to point out that to have and to hold clause, that it stands out, and you can see it's down here. It stands out. This is all the same wording as well, I can't say it's the same. It's very similar wording to the 1820 Act patents. I have never compared the two, but at any rate, and you saw in the previous patent how, excuse me, the to have and to hold clause was, just it stood out very particularly. You saw it was a different font. It was all uppercase and it was bolded. Okay. Here it's less so emphasized, but at the same time, it's still emphasized. And again, as I was saying, that's what caught my eye, and that's what got me to go looking at this stuff a long time ago and kind of led me down what we're discussing tonight. So just to look at this real quick, United States of America, to all whom these presents shall come, greetings. And that's usually, there's some like fancy greeting like that. And by the way, that's like the same, if you read the epistles, that's how like John would start all of his epistles, which with a flowery opening like that. Not all of them, but like most of them. Whereas a certificate of the Register of the Land Office at Carson City, Nevada has been deposited in the General Land Office, whereby it appears that pursuant to the Act of Congress, May 20th, 1862, to secure homesteads to actual settlers on the public domain. So remember, the whole thing was about making sure it's you buying the land and not you trying to speculate and whatever. So homesteads to actual settlers on the public domain, and the Act supplemental thereto. The claim of Giovanni Battista Fallini has been established and duly consummated in conformity to law for the Lot 1, and here's the description now of what he got. Lot 1 of Section 4 and the Lots 3 and 4 of Section 3 in Township 1 North and the southeast quarter of the southwest quarter of Section 34 in Township 2 North, all in range 50 east of the Mount Diablo Meridian, Nevada, containing 158 and 54 hundredths of an acre. And so I could actually go on a map and show you exactly where this is and explain to you exactly what all this verbiage is referring to, but that's for another discussion for just historical edification, but that's just basically describing it. You could, the point is you can actually go on a map and at the or the survey map of the BLM online and find out exactly what this is referring to. And all that according to the official plat, zoom this, official plat of the survey of the said land returned to the general land office by the surveyor general. Now know ye that there is, therefore, granted by the United States, and again, I don't know why this is all uppercase like that. It's kind of interesting. Unto the said claimant, the tract of land above described, to have and to hold the said tract of land with the appurtenances thereof unto the said claimant and to the heirs and assigns of the said claimant forever. Subject to any vested and accrued, again, that's just saying it's never going back to the government. Subject to any vested, subject to. So this means that if there's already any vested or accrued water rights for mining, agricultural, manufacturing, or other purposes, then you got to honor those, right? So you could have bought land that already had its water rights or its mining rights, mineral rights, already sold off separately. So that was one of the conditions of this patent. So again, if you're trying to bring forward your land patent, which act of Congress is it based on? If it's based on the Homestead Act, then you can never be allodial because it could be subject, as it shows here, to mining, to agriculture, all these other different claims or conflicting rights. Mineral rights is a separate from the land. That's in water rights in some states. It's always been a thing. So you can never have allodial land rights on that. Even if there was some other act of Congress that maybe does, who knows? Haven't looked into all of it yet. It's possible, but that just shows you that they had no distinction between the different acts of Congress. These so-called gurus. I'm not disparaging any of them. I'm trying not to, at least. Maybe I should not use those terms in. But the people who put themselves out there as experts on this stuff, they did not. If they're not clarifying the difference between these different patents, but they're saying that you can have allodial rights and blah, 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 whatever they're saying, it's like, no, you completely ignored the actual language, the actual law, the actual rights that you were granted with these caveats. They're right in the patent. You can read it yourself and see if you're not brain dead that, wait a minute, how could there be allodial when, yada, yada. And here's the thing that's in all of the patents, always, that affects everybody, regardless of whether there's mineral or mining rights or whatever, and rights to ditches and reservoirs used in connection with such water rights, as may be recognized and acknowledged by the local customs, laws, and decisions of courts. So really, I mean, to me, what that says is, if there's ever like a flood, if if you live near a town where a town develops and it's always flooded every year, and they decide, well, we need to dig a canal through Dev's property because that's the only place that makes sense and that will divert the water around the town so it doesn't flood it every year and cause all kinds of untold damage. Well, then they're going to come in, they're going to do that's eminent domain. That's the constitutional power given to the government to come in when they need to and take land for public purposes, and that's what that's referring to. So again, you can never have allodial rights. That's the held of a superior lord part, the having to hold. And there is reserved from the lands hereby granted a right of way thereon. See right there. That's the key thing right there. There is reserved from the lands hereby granted. So that just throws allodial out the window entirely. A right of way thereon for ditches or canals constructed by the authority of the United States. So there you go. I mean, I think, again, that's just reinforcing what we've already discussed tonight. Does anybody have any final comments, questions about this? Oh, hang on, Dev. I'm sorry. I just want to read the last part because it's interesting. This is the, what would you call it? The jurat. In testimony whereof I, Calvin Coolidge, President of the United States of America, have caused these letters to be made patent and the seal of the General Land Office to be affixed, to be hereunto affixed, given under my hand at the city of Washington the 30th day of August in the year of our Lord 1923, and of the independence of the United States the 148th, by the President, by Secretary, and I think the person who actually wrote this or signed it on behalf of the president was Viola B. Q, I think that is. Because the handwriting is the same, and I don't think the president actually had time to sit here and sign patents. So it's my opinion, unofficial, unprofessional handwriting analysis opinion that this was actually signed by Viola, which makes sense because it has the by as well. But anyway, and then I think this was probably signed by the actual acting recorder of the General Land Office. And then there's their patent number, their serial number. And then isn't that cool that you can go back and download a document from 1923, and even documents older than this. The oldest I found through this system, it was signed by Thomas Jefferson, and it was from like 1804 or something. And I forgot where it was at, but that's pretty cool. Anyway, forgive me, Deb, go ahead.
Yeah, I just want to know, do they pay taxes on it? Because it's still a gift. They got the land. There's reservations of the gift, but
Well, see, that's the thing. It's an open question. Yeah, I don't know if Gavin's still here. Looks like he's gone, but he still thinks that there's a way to avoid property taxes because people have claimed to have done it. I've heard claims myself before. I don't know how to evaluate them because, quite frankly, the information I've been told, and this is from the guy that's acknowledged all over the United States as being the one who knows how to, take a property off the tax rolls, and that's Steve Emerson. And we've talked to him a couple times. Gavin has talked to him several times.
is he a bald guy? Is he like a kind of skinny bald guy?
I don't know what he looks like. I've never seen him in the flesh, but he's out of Florida and he claims to know how to get people off of the tax rolls and stuff. And so I haven't seen, quite frankly, any evidence of it yet. He hasn't been able to explain exactly how he did it. Although he just read the tax laws, it's just in there, and he says a lot of stuff again that sounds really good. Otherwise, isn't really actionable information. It's like, yeah, that doesn't, I don't, So, but here's my answer to all of that. And we answered it already last week when we went over the police powers. Did we do that last week? Police powers? I think we
We
did.
did talk about police powers.
Yeah, we did, and we never finished. You're supposed to finish this week.
What do you mean we never finished?
Well, you had the police power, and then we were talking about the 14th Amendment, and I was waiting for you to finish so I could tell you to read the Diet versus Turner case. Because remember, the police powers, or the 14th, one of the two, turned into the council issue. Remember, having council.
I apologize. I just got on this and
Yeah, you didn't finish it, and that was one reason why we didn't finish that. And this discussion here, I think that we have to look at the word feudal again.
well, let me just first say that I believe that the answer to the question is that it's because of the police power. The government has the police power to tax, and that's my very brief explanation of it, and I need to research it more.
Well, okay, and furthermore than that, because the government doesn't have any power to tax the people. They can they can have imposts and duties on corporations and interstate commerce and things like that. So there's no tax on land, and there's no tax on income. But when you redefine these words, see, we're back to redefining. And the fact that someone, I wasn't even going to get in on this discussion because the allodial title thing I had already gone through. We did that in the 80s, and the concept doesn't make you sovereign from any aspect, because sovereign is a sovereign is the government's the sovereign.
Well,
Okay,
that's exactly the conclusion I basically came to, right? I mean,
yeah, and the word at the word subject, okay, out of England, and the word citizen here, those subject doesn't mean subject to and the slavery again, like people think. You can't draw these conclusions. And the term sovereignty is it's not you don't be a sovereign, but you can exercise sovereignty. See, because that's and so if the government's the sovereign, then to exercise sovereignty, you exercise the government. Okay, now you can exercise, and the government is the Constitution, and you can exercise the Constitution properly or improperly, so to speak, in a different way. And that's what politics is really about, the proper administration of the law. And that's what it originally, you got back in the day, the Democrats, they wanted to exercise the powers of government more towards, economic or these kind of things, where the Democrats wanted to do it more towards the Bill of Rights and the freedoms of the people. And really, they just went in those directions, and then the leaders hijacked all the stuff and made it all what we call political, when that's what political means, really the administration of the law, how it's administered, but not the law. The law is fixed, and the law is the Constitution. So any federal, state ordinance, anything below that has to be pursuant to the Constitution. Okay, now what does that mean? Okay, well, it means two different things, the way you administer it, because when we talk about law, most of us really are concerned with our rights. And law and rights are really totally two different things. Rights are protected by the judicial power, where the law is just the administration of the bills and the statutes, that were that the bills were turned into by the executive. So you got legislative power and law, and usually that's generally court cases or contract law. So they go by law, where to protect a right, you have to go by judicial power, which is more the spirit of the law than the letter of the law. And so we get confused a lot studying law and going over law, when really we want to protect rights, and that's Constitution. So it puts us in the realm of constitutional law. And that's really the Bill of Rights. When we talk about the Constitution, there is the due process and the equal protection involved in that too. But otherwise, the powers of government are strict, pretty much define what they do and how, and they do. The office of the congressman and the office of the president, those are offices where the third branch is a court. So it operates by the rules of court, and no one's running it except the court, and the judicial power is vested in that court. So I just wanted to run those ideas by Devin. Probably wants to comment.
Yeah,
All right.
I just wanted to think about terms defined and things like that too. Patent, as far as I know, patent means something that's just plainly obvious. I guess they're making it something plainly obvious in their declaration of the patent there. But then again, like, it's the power of the president of the United States, and he's giving land that is in another state, one of the states of the union.
Okay, stop right there.
Right.
We got to explain to you what the primary disposal of the soil is. We didn't go over that.
Okay.
And I'll just explain real quickly so I can give you back the floor. I didn't mean to cut you off and take, but there is this concept of the primary disposal of the soil. In every admission to the union that was passed by Congress, so when, like, California, for example, applied to become a member of the union, one of the conditions of becoming a union state is you must give up primary disposal of the soil to the federal government. So all the lands within your state jurisdiction, they are forever given up by the state, except for the lands already owned. But all the public lands that will be public lands within the jurisdiction of the state are now given over in trust to the federal government. The federal government now has what's called primary disposal of the soil. And then from there, the federal government then comes up with ways to parcel out the lands to people through like the Homestead Act of 1862, that other one of 1820, the Railroad Acts, all the other different acts we saw while we were looking for patents. That's how it works. So as a condition for being part of the union, the states gave up the primary disposal of the soil to the federal government as part of the deal. I don't know exactly why that's there. You can speculate that so that
Okay, but is that eminent domain?
no. This is the definition of primary disposal of the soil. In acts of Congress admitting territories as states and providing that no laws shall be passed interfering with the primary disposal of the soil, this means the disposal of the soil, by the United States government when it parts with its title to private persons or corporations acquiring the right to a patent or deed in accordance with law. That's what the primary disposal of the soil is. It's when the United States parts with the soil and by giving title over to somebody else through a patent or some other deed.
Yeah, that's the land patent.
Right. But the primary disposal of the soil.
So they don't have any more. So they don't have any more control over it. They gave it up.
They have the authority to decide who gets title to it, which becomes part of their estate, which is the rights, title, and interest they have to the land. But that doesn't mean they're giving up sovereignty over it. It just means
the eminent domain's the sovereignty.
Well, time out. You said the option of patent or deed, and then you said title. Is title built into either one or both of those two options?
Yeah,
a deed generally grants title.
The patent is the deed here. It's the equvalent of the deed.
Right.
Why is the word or there then? You just read it and there was the word or.
What?
Didn't you just read it and it said patent or deed? What's the distinction between those two terms?
A deed is a form of patent, or a patent is a form of deed.
Hold on, he just read it.
I know.
Just literally read the page, and the word "or" was in there, so the two words can't be the same thing. Otherwise,
one's greater than the other. They're the same, but one's greater than the other.
That may be true, but I'd like to have that more clearly defined, if we could.
In acts of Congress admitting territories as states and providing that no laws shall be passed interfering with the primary disposal of the soil, this means that disposal of it by the United States government when it parts with its title to private persons or corporations acquiring the right to a patent or deed in accordance with law. Because a patent is a type of deed, it's not a deed, but it's similar. Right. It's a conveyance of title.
So that sentence you read is talking about those are two methods of parting with title.
It's a conveyance of title, yes.
Okay.
Patents and deeds are conveyances of title.
Okay, so then I'm still kind of wondering what's the distinction between the two ways of having
the U.S. government is conveying title from themselves to the person, the purchaser.
I get that, but why are there two different means to convey title? What's the point of that? You can do it by patent or you can do it by deed. What's the point of that?
Because the United States government might own some land and might decide they don't want to own it anymore. And so them being the owner, they can now deed it to somebody else.
Right, but what's the distinction between deeding to someone and patenting it to someone?
Why don't you look it up? Then you'll know. Don't take anyone's word for it, because I know Salem can't. He's not going to explain it properly. He'll go look it up for you. But now you're just doing the research, which we all should be doing. And here I have another point I'd like to raise, and then this is back to Kathleen's point, because when I looked at what she's saying about these other people, other countries buying the land, see, they might not be able to have it in a sense that the land, remember, is laid out in township and range, And then you look up the word township, it's like a township. So whether it's a city or urban, it's still the land is defined as a township. And so when you buy that piece of property, this is where your social or you're living in a city. Now you're with people, and so other rules are going to start to apply. Whether they're strict or not is a question for the city itself. But that's they're buying a township. And so they're going to be liable to the rules of a township in the United States, because it's different in Canada or Australia and things like that. So that's just another thing that we may want to research into to see how these people are coming in and buying land. But when they buy land, they're coming in and being part of our cities. So they got to follow the laws and the rules and the ordinances of the city, of the area. So
Yeah, that brings up another point, kind of fresh again, is are they paying taxes on it? Because if China's owning hundreds of thousands of acres, or there's people in Texas here that have huge ranches and stuff, and how can anyone afford to just have it and hold it and not do nothing with it, but be paying taxes on so many hundred thousands of acres? The taxes would have to be just astronomical.
Well, they probably get like these kind of breaks where if it's just like open ranch land, it's like 10 cents for, every 100 acres or something like that.
okay, now that brings up another point of whether, well, first of all, taxes. Okay, whether they should be there or not. And so let's for this discussion, then I say, okay, let's assume.
Hold on, Zeke, can I quickly do this? I just want to throw out real quick.
Let me just finish, because if there's taxes, then where do those taxes money go to? Because we're finding a lot of taxes and fees and penalties all end up going to a certain group of people, whether they're legal or not. And that's the funneling of that money is what's important, because taxes are, really just to run the government, so to speak. And if you have a very limited government, then you don't need very much taxes.
It's going
Well,
to
that's
paying
the
off
idea, but the
of
problem
the
is
Federal
everybody
Reserve
wants
and
to,
also the military complex.
everybody wants to take the benefits, and they don't consider that somebody's got to pay for the benefits. And then when they complain that their taxes are too high, they don't consider that it's because the benefits they're requesting are what's driving the taxes. And
Well, I don't believe that's true.
well, what is it then?
Greed
From who?
from the politicians. They're ripping us off.
But people are they're taking the benefits.
No, we paid for the benefits already. They're just taking all the extra away. Look at all the money that goes into the
Who
judges'
administers,
funds.
who administers the benefits?
Huh?
Who administers the benefits?
You tell me.
People that have to be hired and paid by the government.
Oh,
So
well,
all of a sudden the government metastasizes because people are demanding these benefits that were offered to them.
okay, so they're hired and paid, and they make 250 grand a year, and they collect 50 million a year. And so where does the money go? To them and their friends and their buddies and their vacations? I mean, come on.
It also goes to funding
Gave them an inch, they took a mile.
genocide.
And furthermore, and moreover, not one dime of taxes goes to paying off anything.
I know. It all goes to
The Federal Reserve prints up the money to pay for everything. So that's all, just that's the slavery part. Is the taxes slavery.
People let themselves be fooled in the 1930s when Roosevelt basically converted our system of government over to socialism overnight. That's when people should have risen up and said, what the fuck are you doing? And they didn't. So this is the system we have.
Well, okay. No, I think the Federal Reserve did it in 1913 and a little prior to that. But it's all the money is the key.
The point is, people got fooled. And now that we know better, what are we going to do about it?
Well, we're going to have to go back to an honest money system.
Yeah, but you and what army?
Before you can solve any one of the problems you've talked about today or the ones you talked about last week.
I know.
Okay.
But how do you do it?
Huh?
That's the question. How are you going to do it?
well, you're going to have to do it. And the way I think you just do it. Just do it. Because people are going to be scampering any way you look at it. And because when they go to this Bitcoin stuff and find out that the dollar's not worth anything, then how are they going to get anything out of a Bitcoin? It's not anything. You're going to have to start going back to growing food and trading assets. You know, cars and trucks and tools and food and services.
I don't disagree
Yeah,
at
and
all.
when they shut down all the electricity, you won't be able to get gas, so you can't have generators because they need gas and oil, right?
No, we can use the gas and the oil because they're going to sell it to us.
Solar panels still work.
Fair market value is going to be fine.
Yeah, but the electricity, if a grid goes down, the electricity pumps the gas. We won't
well,
have.
you got a
electricity
solar
to
panel.
pump
You got a
it,
solar
right?
panel on your house, like you
Yeah,
said.
but
it'll
look at the
work.
cloud, the geoengineering of the cloud cover. You know, we're seeing more
Well,
and
we
more
don't.
cloud
Okay, so
cover.
it doesn't matter. We can pump gasoline by hand into a truck and move it over to a place and siphon it into your car or your tractor and run it. That's how they used to do it.
Henry Ford said that everyone could have enough ethanol grown from their own property all over
Okay.
America.
And also,
And
don't forget that the original Beetle, the German car, was made to run on water. So these cars the combustion engine can run on water. And
I
people
don't
do it, huh?
I said I don't know about that one. I'd like
Well,
to.
guy got killed because he was doing it, but I know people that do it. I know
You
people that
do?
do it, and they if you get loud, then you'll get attention. But these can all run, and this is all going to come out as soon as the the system breaks loose.
I
So
had
Hang
two
on a second.
friends that drove a van down to Mexico on water. But I don't know what they did to prep their engine, but also beet
yep.
sugar is the best, not corn, for growing ethyl alcohol. They were doing it in California. That's David Bloom's book. But the thing is there's prophesied famine in our land. Okay.
Okay,
Judgment is upon
but
this
we're not
land,
there.
right?
Okay, but prophecy isn't what we're talking about right now.
Well, it should be something we talk about because it's coming down the pike pretty hard.
Well, when that's the subject we can talk about. You just brought that in. We were talking about land and taxes.
I think this whole night has been. Is it too early to declare it a success? Because I think this is a really great discussion, and
That-
it reopened the last week's discussion also with police powers, which we still have more to flesh out of it. And I'm actually really looking forward to this discussion continuing.
Me too.
I'm glad to hear that. I appreciate that. And that's the whole point here is because now it's not about, well, first of all, yeah, nobody should get any illusions that this is about shutting people down and and just basically saying, you know, just deal with it and shut up and stop complaining. That's not it at all. It's about educating yourself as to what the law actually is, so you know what actually is and what actually isn't. So as you know, and as I expressed in great detail at the beginning, you know, I don't want people to waste their time and money and energy anymore on stuff that doesn't do anything for them. I'd rather they put that into stuff that can help them, like learning law and learning how to go to court and learning how to act in court and or other stuff, you know. So that's why I'm doing this.
I
And
like
so
this, you say
for
that
your,
too.
what was that?
Your motive that you've reiterated is that you don't want people to be harmed by foolish things that other
Yeah, because
fools
I was one
proclaim.
of them. It set me up. Here I am 15 years later explaining to you guys my mistake. So
Right.
yeah.
That takes that I know that really takes something because uh you know that was a hard loss to experience, and it takes the humility to acknowledge it and share it openly with all of us.
I honestly am offended by people making money off of this stuff. I never got into this to make any money off of it. I always tried to learn what I could without spending as little money as I could because I didn't have a lot of money. And to me, this information should be free not should be free, but I mean, people should, if the point of this is to make us free, the point of this is to end tyranny and to fix our government and to do all these things that people claim they're in it for, then why would you charge for this information? Wouldn't you
I
want
agree.
other people to know this? Wouldn't you want them to also know what you know, so that we could all just get to the point, to the finish line and all be free? So to sit here,
I'd
be
like to
"Well,
answer that.
I'll teach you how to be free.
I'd like to answer that.
Which is
I'd
what?
like to answer that.
Go ahead.
Okay. Well, you know, when you live in this world, you have to pay bills. And in order to pay bills, people go do stuff. And there's a whole bunch of people that are called teachers, and they go and they study and they learn their subject area, and then they go and get a class and they teach the class, and the people pay for that knowledge. And because the person wouldn't be able to pay their bills if they gave it all for free. Okay, and if they can afford to give it for free, that means they're getting money from somewhere else. Someone else is paying their rent. Someone else is buying their food. Someone else is providing the land for them to work on and get food for. So money makes this thing go all around. Okay.
Does that mean that I need to tell people land patent
and let me
packages
finish. Let
to
me
teach
finish.
them how to get
Let me
a
finish.
Smithfield land
Let me
patent?
finish.
That's because that's what I'm talking about.
Let me finish. Okay, because I've gone through a lot, spent lots of time and energy and money to learn what I know. Okay, and when I give it out free and just say it, well, everyone just takes it as, oh, well, that don't mean, no, he just told us that, so it must not be worth anything. Actually, why should we believe him? What's his credentials? Why is he's just giving it free? Now, if we have to come and we have to pay somebody,
Really
we have to pay to get this information, then the information might be worth something. And people would take it and consider it more and not waste their time talking about it and just going round and round on these meetings and just bringing it up.
That makes no sense, because I know lots of people who charge
Coming at it from an
information.
alternative, all different ways, the way I came at it. Instead, it could be like logically put forward step by step the way classes should be. And
Let me say
I
something.
want to put class together and I want to charge. And I think that it's going to be worth a lot of money.
I don't have a problem with that, Zeke, at all. That's not what I'm talking about. I'm talking about people who go out there and espouse that, oh, I want people to be free on the one hand, and then they're charging for this special secret knowledge they have, which usually in 99 out of 100 times it's just bullshit. And that's what I'm really tired of. Go ahead, Deb.
We call them patriots.
Yeah. Snake
Let me
oil.
add something to this. Just a little bit of levity to start with. That I saw a meme today. The guy put a good working refrigerator out on the street with a sign on it that said free, and it stood there for 4 days straight untouched. So then he put a sign on it that said $50, and it was stolen that night. Okay, but now just because you paid, lawyers charge $400 an hour. Does that mean they're really good? I think that crappy lawyers are a dime a dozen. So the logical fallacy of valued highly or given away freely can be a delusion in both directions. And there's a proverb that says, don't give correction to foolish people because they will hate you. Give correction to wise people and they will love you.
Yeah.
And so, and another thing too is you talk about teachers. The great teacher, Jesus Christ, said to his disciples, I have held nothing back from you. I have told to you everything openly. And what I've told to you, even in secret, I want you to go and preach from the rooftops. So,
and my sister brings up the fact that he says, I haven't told you everything. Some things are to be sealed up for later.
Yeah, he did say that, but was that before or after the part that I just recited?
Yeah.
Because I think he was talking to his disciples what I said just before his death. But anyway, the point is this,
Yep.
you know, talk about noble causes, like preventing people who are suffering or who might suffer if they have the aptitude to hear someone like Salam is a wonderfully noble motive. Whether that motive is effective is a whole different thing. You know, if he gives it freely or if he puts a sign on it for $50 and laughs when it's stolen and it does a lot of good anyway, you know. But you know, so and that's kind of how I feel too. Actually, I feel the exact same sentiment that Salam does. And when I know something of true value to someone who needs that knowledge, I'm very happy to give it away for free so that I can help to reduce some of the suffering in the world. And actually, I dream of a time when it's kind of like, as Bill Thornton would say, one of our common sort of heroes, so to speak, quoted the time of the revolution when one of the generals said to King George, "We can't prosecute the Americans because every layperson is a lawyer." When the knowledge is that what's the word, profuse, so widespread, that's when we can have freedom. And you know, to be able to make money off of telling some people how to avoid being ensnared into a voluntary slavery, I feel like it I'm profiting off of that industry. When I despise that industry, I should be making war on that industry to make it to destroy it so that it ends completely and we can enter a time of peace where
So have you ever taught anybody how to avoid being sucked into slavery?
yes,
Oh,
and
you
it's
have?
awesome. I have, yes, but it's in a different
So
realm.
and were they successful?
Absolutely.
Well,
But
then
it's more
they need to be on this show here because we're all learning how to do it, and we're
okay.
finding out it's not just an answer isn't just do this or do that. The answer is the
Yeah,
knowledge and understanding of the words that are tricking people.
correct.
And
That's correct.
well,
My
you taught
area
that in
of
one day.
is sorry.
You taught that in one day.
Yes, usually it's in a single conversation, but
Oh,
it's an
you do it yourself.
I do it, and it's a colossal waste of my personal time to do it one conversation at a time with one individual. In my opinion, that's why I'm working on scripting a book and making it into video form because I know most people are too lazy to read a book
Oh, and the
anyway.
book's
And
going
I
to be
want the knowledge
free,
to be
right?
out
The book's going to
there.
be
Yeah,
free, right?
no, I'll charge for the book, but the video will be free, and you don't need the
You
book
can
to watch
charge
the
for the
video.
book. Yeah, they could be making money on this whole deal.
I doubt it.
I'm just giving you a hard time. I'm just saying
No,
how we look at it. Remember?
Zeke, I'm okay with it. I'm okay with it. The video is going
Okay.
to be free, and I anticipate that most people, and I'll openly tell people, if you watch
Let me,
this, you totally comprehend it. You don't really need the book, but you can buy it from me if you want.
yeah,
That's how.
let me say this. Let me say this. Like I can tell you all right now about and this is kind of a dumb example, but hopefully it works. You know, if you don't want to be considered a resident of the state of California, don't use an address. Use care of general delivery, right? At the post office. And that's something that I learned a long time ago. And I've been telling people that for a long time. And I can dispense that knowledge, and I have, and I do all the time. That's very useful to know. But what can you actually do with that information? See, that's where I can further teach you. And I mean, I'll be happy to talk to anybody about it, but like I can take that and tell you, I can literally make a whole show about it, right? Or a whole show or whatever,
Yeah.
meeting about it. But that doesn't mean that you're necessarily going to now know how to go and take that information I gave you and do something with it. And so that's where, okay, if you want me to hold your hand, yeah, I'll hold your hand. And like my whole thing is, look, I'm happy to just help people. That's how I am. Okay. Don't use me as a model. Ignore me as far
Well,
as
then
how
let's not talk about you then.
but I am talking about me right now.
Oh, okay.
Is
Well,
what I'm
then you're a
saying is this
model.
is how,
Then you're the
this is, be
model.
quiet, be quiet. This is how I prefer to do things. And so, but I will take money if you give it to me. Okay. But what I'm saying is I don't find it a problem if Zeke gives away all his secrets. And then later on, if somebody wants Zeke to hold their hand, and sure, okay, you can hold my hand, but it's going to cost you this money because I have my time and my thing and whatever, and your costs and whatever. Same as me, I just handle it different. But I'm not going to criticize Zeke for saying, "Well, I'll take you under my wing, but it'll cost you." I don't have a problem with that. But I'm
I
just
don't
saying
even-
that me personally, I would prefer to give the information for free because then it's either going to help somebody or it's going to help me because somebody's going to come to me and be like, well, that sounded really good, but I need help to understand it and I'm willing to pay you to spend some time with me. Okay, great. And that's where it works for me. That's the model I'm suggesting.
All right. Well, I think that really this whole conversation is about doing business. And so really it should be a whole nother discussion because it just, to me, it sounds like, oh, hey, Salim, you know how to fix computers. I'm going to bring over my computer and you fix it for free, right? Well, that's ridiculous to think that.
That is ridiculous.
That's something different. That's different. For
I'm-
law, this is what I've chosen for law. Because everything came to me freely, so I give it freely. That's how it is for me. That's basically in a nutshell. Faye has had her hand up for a long, long, long time. Please go ahead, Faye.
Oh yeah, sorry. It was also interesting. And I wanted to respond to what Gavin was talking about, but maybe Zeke has an answer because there's this book which I think you're probably familiar with, Mel Stamper, Fruit from a Poisonous Tree, where he does talk about, involuntary servitude being prohibited by the 13th Amendment and the 14th Amendment. And he talks about nationalism versus federalism and this remedy of natural right. And he talks about a remedy, and his remedy is this remedy of declaring your state nationalism. And I don't know if that gets confused with these people who call themselves state nationals. I guess there's a lot of different people calling themselves state nationals, so maybe they're not all lumped together in
Well,
one group.
the current term that is being utilized is American state national. That's the current iteration of the
Right. There's some people are calling themselves American state national. And so there was that, this person seems pretty astute. Like I've been using this book as a reference. And so there's a lot of history and, there's
Well-
sorry.
I'll talk to that if you want.
Oh
if
yeah,
you
yeah,
want.
please. That's a good thing.
Okay. So here's the thing about all this stuff. Okay. Now, you were born, right? If you were born in this country, you were born in this country. If you were born in a state, you were born in that state. Okay. So there you are. Everyone was born, all of us here generally will just say, we're born in this country and we were each born in a state. Okay. Well, under the Constitution, all the states are separate sovereigns and they all are required to go by the Constitution. So there are things that they're prohibited from doing at Article 1, Section 10. And so all the states are equal, and all the people that are born in those states are equal. Okay, so you can go out and say, well, hey, I'm a this, I'm a Christian, or I'm a Jew, or I'm a Muslim. Okay, well, then you're one of those, but that don't make you special. And I sent in a bunch of paperwork to the federal government, told them to fuck off. Oh, you did? Well, okay, I didn't, but you ain't special. Well, no matter what you declared, I declared that I'm really 11 feet tall. Okay, you declared you're 11 feet tall. Are you 11 feet tall? Well, I declared I am, so I must be. No one objected. Oh, okay, well then, yeah, you're not 11 feet tall. You're equal to the guy next to you. We're all equal in this game. Okay, that's the way it is. We're not any different to the government or to the states. Now, we can become different when we run into somebody and make a deal and say that we agree to do something for them and they agree to do something for us and we make a special deal. Okay, well, now you're different because you joined a relationship and you're in that game and you're playing that game. But I can do the same thing and it's a different game, but I'm still doing the same thing. I'm free to make an agreement. You're free to make an agreement. So we're all equal. You can call yourself a national, you can call your state itself a state national. But when you take these terms and then go to define them against other terms, that's where these problems start to come in to have like, hey, I got a allodial title, so now I'm a sovereign. Well, that really doesn't make sense. You got a allodial title, you got a allodial title. You're a sovereign, you're a sovereign. That one thing don't make you another thing. Okay, so this is this whole thing of capital letters. Oh, I write my name in capital letters, so now all of a sudden I'm a this. But if you write it in up and down letters, well, then you're that. No, sorry, doesn't matter what you. It's your relationship that you've established. So all that is garbage until you come down to what is the real issue. What is the issue?
Well-
And someone's trying to make an issue, but there is no issue.
What about the issue that we're meant to have a government by consent, and there's a lot of stuff that I don't
Okay.
consent to.
Let's take that. Let's look at that right there. Okay. So I'm gonna tell you we have a government by consent. Okay, and that's the way the Constitution's set up. And because it's consent, that it means you're free to consent to whatever you want. So now you're gonna have to get specific as to what it is you don't consent to. So that means you have to reduce it to an issue of what your problem is with society or with someone else. What is it you don't consent to?
Well, the biggest things are these illegal foreign wars of aggression, and the fact that the federal government's now printing $1 trillion every 100 days. I mean, raising the debt 1 trillion every 100 days, which I think that's going to, I think that's likely to impact anyone that's going to be in the US.
That's going to impact everybody in the world.
Yeah, ultimately.
Okay,
But
so
yeah.
so obviously there's nothing you can do except take some kind of personal action towards influencing the change in that. Okay, but by law, you're not going to be able to declare that you're a sovereign citizen now, and so all of a sudden all this stuff has to stop because you said it, or you said you don't consent. I mean, that doesn't work that way. The things that you can only consent to the things that are happening to you, and if it's greater than it's outside of your purview, well, you cannot consent. But there's no one else can, unless you know somebody and you know how it works and who's spraying. Now I heard that there's this in I can't remember, it's Rhode Island or one of those places over by New York, that they don't spray the sky there, and they have laws in their town that they can't do certain things. Now the laws may be there, but I don't know if that's stopping the powers that be from spraying, but they did make a law and they're claiming that it's working. So that might be a way to do something.
Yeah, have you looked into this Cal Washington and what he's been doing?
Nope.
Oh, okay.
I've heard of it, his notices of liability and stuff. It's just the same old crap look, he's a nice guy. I watched him more recently. He's talking about the same stuff. He's claimed to have had success with it. I don't doubt that he has. His whole thing in a nutshell is sending out notice and demand and getting people into contract through notice and demand and the 3-part administrative process. That's basically his tact, and he says it works. He said has success, but when you actually listen to him talk about, what he defines as success or quote unquote works, it's just the same old kind of stories, where it's like it kind of sort of did something, it maybe changed, maybe it hit something, came about of it. Usually nothing does. The county, the officials, the town officials, the city officials, whatever, they don't take shaking their boots when they get the forms and the notices as they claim. I think that's all just a lot of hyperbole, because if what Cal is saying is as successful as he claims it is, it would be used all over the country all the time, and we
Well,
would have
it's not just this country, but I mean, what's interesting about it is that it's outside the Constitution. He's using law merchant. So he's holding people accountable outside the Constitution. And I don't know where.
good luck with that. I mean, I don't know
Yeah.
how you do that. How do you enforce that? Do you bring in like God or the International Criminal Court? I mean, what jurisdiction is?
I don't know, it looks like
I
Dave
mean,
might know.
see, none of it makes sense.
Right? Dave, you know about that?
You got your hand up, Deb.
Oh yeah, yeah, yeah. I just wanted to say, I'm gonna get off here in a little bit, but I wanted to say to Zeke, I didn't want you to think that I was coming after you, Zeke. I actually really appreciate you, and I'm glad you're on tonight. And I'm always happy to hear the bits of wisdom you have to share with us. And I appreciate you also, Salam. Thank you for generously giving so much of your time and effort into keeping this going and honoring Jackie and everything. And I wish I could say the same to Gavin, but he left already. I like hearing Gavin too. But anyway, I gotta go to bed. It's I'm gonna turn into a pumpkin here soon because I'm in 2 time zones away. But I hope you all have a really good night and hope to see you all again next Tuesday.
All right. Thank you
All
for the
right.
kind words. I appreciate it. It's nice to see you as always.
Yep. Okay. Good night,
Thanks a
everyone.
lot.
Bye bye.
Good night, Deb.
All right. Well, I think I'm probably going to kind of do the same thing here. You guys, you folks, you fine people are welcome to continue conversing, but I'm going to go ahead and end the recording now and then check out. So if there's any last minute things anybody wants to ask me before I go, please speak up now.
Well, I have a visitor out here that would like to ask a couple of questions about criminal law here in Orange County. There's some really fraudulent things going on, and I thought maybe somebody would know, an attorney, or give her some advice or something. I know it's
All
a
right.
pretty close class. I don't even know if she'll speak up. It's Darth Bader. Hey, Darth, are you there?
Well, hold on one second, Cynthia. Let me just then go ahead and formally stop the recording.
Recording stopped.
Okay.
And I need
perfect.
to
Thanks.
hold on. I still need to do one last thing because I need to get going too. I need to find somebody who can volunteer to be the host because I'm going to log off. So who here can volunteer to
How
be?
about Zeke, or what happened to Michael? Is he around?
He's around. He's still busy with his stuff and he's doing all right, but he's been busy. But is there somebody here who wants to take over the hosting? Because if I log off, somebody's going to get it.
Okay, well, what do you want to do? What do I got to do? Just take it and then close the meeting when it's time?
Yeah, there's nothing to do. Just
Okay.
in case somebody comes in and you got to block them or do something.
Okay. Well, no, I doubt if anyone's coming in.
You have the power now for all that. All right. Well, thank you, folks.
Thanks.
I appreciate your attention. Yeah. Thank you,
Good
Zeke. I
job.
appreciate it. Yeah, thanks. And I will,
Yeah,
I think maybe next week what we'll do is we'll go back to the police powers thing. I apologize. I forgot we didn't finish it. And then because that will give me more time to kind of button up my
I think that it was the 14th Amendment, and it brought us into the discussion of the right to counsel. And that's why I was going to have you read the Diet versus Turner case.
Yeah, I still need to do that. I brought it up, but I don't know where it is now. And
Yeah.
I'll put
Okay.
it on my list of things to do. But yeah, I'll definitely do that, and we'll come back to that next week, and then come back to the land patent stuff after that. So,
All right.
all right. Thank
All right.
you. Talk to you later.
Good night. Okay, you guys, I'm in charge now. Look out.
Is this Dennis Whipple?
No, this is Zeke.
Okay, hi,
I did
Zeke.
want to talk to Dennis though, but he's still on. So let's see.
Oh, you do good. I think you've taken over his meeting before.
Oh, Dennis.
Anyway, next month is the 20-year anniversary of my friend Lynn Meredith, who wrote the book Vultures and Eagle.
Oh yeah, I bought that book.
Yeah, it's the 20-year anniversary, April 15th, when they arrested her unlawfully, and she's like the queen of Amazon right now. Vultures and
Really?
Eagles on Amazon right now and see what they're buying it for. And the
Wow. Oh yeah,
tragic
we
thing,
loved her. She was
well,
good.
she was,
She came on about 10 years after we were into it, I think.
yeah, she's ruined.
Yeah, she's
She doesn't
ruined.
go after these people at Amazon that are copy and pasting her book using her name, her cover, and all of the contents. And I'm in that book, by the way.
Oh,
You know, she's
But she had-
afraid to go after them because she owes restitution and all this stuff. But it was all about the income tax being voluntary. And
that's right.
I was out of the tax system for about 12 years, and then I got kind of scared and went back in, but I'm still paying, but I was legally out.
You should never got
But-
that. Remember that Al Capone?
Oh, yeah.
They told him if they didn't file, they'd get him, and they didn't file, they get him. And then he filed, and they got him.
Yeah.
Oh boy.
Yeah, it's a really crooked system. I didn't mean to go off on that tangent. I have a family member that got in a bit of trouble with the law here in Orange County. She's here visiting, and Orange County Jail is just one of the most corrupt I've seen. She went to an arraignment. They had no proof of an assault on an officer. She's a tiny thing, too. She's tall, but she's very petite. And it's just not part of her nature to assault an officer. And she wasn't drunk in public either, you know, and they arrested her on these things. They didn't give her her Miranda rights until a day after she was in Orange County Jail for 3 days. I had to file a missing persons report. I mean, it's just criminal. And we've got these horrible public defenders, and they don't call you back, and they push for jury trial because they're getting paid so much money for it. They have no evidence, but I know they're just going to keep her in the system for probably a couple of years. You know, she's on the line here, but she won't talk. I don't know.
Okay. Well, this is actually so the thing about this all is see that okay, we come into this thing we think we have a right, and the taxes, and when taxes are voluntary, and the taxes, and then or we think we can travel without driver's license and registration, so we do that.
Big.
But when you do those things, then what we didn't realize is you think you got rights, you try to do them. The problem is that now you get arrested or whatever. Now you have to defend those rights.
Right.
And that's a whole different thing. So now you got to, from the beginning perspective, oh, now you got to be a lawyer. Okay. So we didn't know. I mean, we were totally, we thought we were, justice. We had a right. We're doing it. So we get it. So then we get arrested. We get tickets. We go to the public defender. We tell the public defender the story. Here's how it is. He's a new guy, right? Brand new.
Yeah. Yeah.
And he says, well, you know more about this than we do.
Yeah.
Oh, yeah, here we go. I know more about it than a lawyer. And obviously at that point I did, which is nothing. So he knew minus nothing. No, he knew this. He knew the system and learning how to play the game, not how to defend rights. And so this is what I learned. The whole thing is that defending rights by using law and statutes and the way the lawyers think isn't the way to go, because we need to learn the language that the lawyers learn so that we can understand that we don't defend rights by the method of defending complaints.
I think the problem with this is, once you're in the system and you're arrested, you're appointed. You don't get an attorney right away. You're appointed a public defender, and that public defender is going to
Go
push
down
for.
make a deal.
They want to keep it in the system as long as they can because they're
Right.
getting paid for it.
Because we don't know how to take it out of the system. That's what I learned, how to take
So
it out.
I tried to file a 170.6 on this idiot I've had.
Okay,
and
but
this
again,
conversation about that. But then they pulled a Marston hearing on me,
there you go.
that day. Okay. But I
Okay.
was prepared for it, and the judge deemed me incompetent. I was so pissed.
Okay, so see, here's the thing. You have experience right there.
Right.
Okay. Now I have experienced, maybe 10 or 20 times what you got. Now,
Mhm.
if I can set up the class and I can teach you this stuff, see. Now, one way I figured out is because I used to just say, well, what's your question? Well, people didn't even have enough understanding to ask a question. Now you brought up the 170.6. Well,
Yeah.
we use the 170.1 A6C or A63, as Michael would say. Now, Michael did this, and that was when I first saw it, he did that. He fired the judges in
170 A63.
170.1 A6C. Now
C. Okay.
they may have changed it to III, 3 or whatever. It's 3, ABC or 3. Okay, so I saw the video. Have you seen Michael's video?
No.
So it made him famous. Okay, so I'm here. It's about 1995 or 6 or somewhere in there. So I see him and I go, all right, this guy figured it out. Okay, well, he'll tell you how brilliant he is if you want to listen to him. But I saw it and I said, okay, he figured it out because I had figured it out. We fired the judge. That's how you fire the judge. It's not 170.6 because you get one of those for free. And then they bring in another judge. But you can bring this 170.1 A6C is for any cause. So you have to have a cause. Okay.
Okay.
And then that cause goes to then the judge has to answer it, and then they send it over to another county, and it's really just for time. But one time I won it because the judge didn't respond, and the other guy said he didn't respond, so he loses, so he couldn't be the judge. Okay, but so that's just a game. That's part of the game of technicalities to beat them. Okay. The other one is, and the which is a better one or a good one along with that is you do discovery. So when you do the discovery, but the key is here, you can't ever wait.
Wait a minute before you go on with the discovery. How do you get public defender to ask to get discovery? Because she already had the arraignment, and
you got to fire them.
They were supposed to.
Is that the Marston hearing?
No, this is a Marston hearing I had on something else. This is my niece. I rescued this dog. It's ridiculous why
Okay,
I'm
well,
in
wait,
the court.
don't get into that story. But the Marston hearing, there's the Marston hearing and there's a Ferretta hearing. Okay, so
She hasn't asked for the Marston hearing yet, but
okay,
how
so
does
here's
she
the
break
deal.
discovery?
I'll just tell you how it is.
Okay.
You tell the attorney that you're firing him. I don't
Okay.
want you to be my attorney. Then he says, well, we got to go to the judge, and the judge has to determine, whether you can be be the attorney or not. Well, so then You go to that, and usually they'll accept you them being fired. They'll accept it, okay, because they don't want to fight it. They don't really want you as a client because you're a patriot or something. You keep telling them what to do.
They
Yeah.
did me.
Huh? Okay,
They
so
did
then
me on
so
March
so
3rd,
the
but
judge
go
will
on.
say, okay, do you want to be okay? So then you say, the judge says, well, why do you want to fire him? Well, why do you want to fire him? Because he won't defend me properly. He isn't going to win my case. He wants to make a deal. He wants to do something. He won't give the defense I want. Okay.
Right.
I'm just, so this is, okay, because I could tell you the story, how we fired 12 public defenders and 4 judges, and my buddy would keep going into the hearings, and then he'd go, and then he'd come out and he'd ask the guys, what are you going to do for me? What are you going to do for me? You're my lawyer. What are you going to do for me? Oh, well, I'm going to make a deal. Well, that ain't going to work. Well, then it got to the point where he says, I'm going to, send you in for mental competency. Oh,
Right.
well, that wasn't going to work either, because they'd already done that and he'd already been through it. Okay, so
See,
again,
they
I'm just
arrested
saying,
her without giving her her Miranda rights. They wouldn't tell her she was what she was
I
being
know, but
arrested.
those
They put
details,
her in solitary confinement.
I know, it's sad, and those details are explanations for the story, but they're not gonna see the whole thing about all these cases. We have to realize from the beginning is that the court they're taking us into doesn't have jurisdiction.
Right. We all
Okay,
know that.
so that's why, and there's a case in California, in Ray Walters, and in the United States, it was a case out of Florida called Gersten versus Pugh, and these guys explained in a misdemeanor case, when they arrest you,
How do you spell Gersten? Gerston?
either O-N or I-E-N.
Okay, and Pew, P-E-W or P-U-G-H?
P-U-G-H, I think, yeah.
Okay.
Now they talk about
Okay.
misdemeanors and arrests on misdemeanors. And when you're arrested on a misdemeanor, if you sign out, then you'd lose your claim to a wrongful arrest.
Okay.
Because you could have signed right at the beginning.
Mm-hmm.
Okay.
Well, they gave her nothing to sign.
Well, did they give her bail?
They did 20,000.
Okay, so what was the crime?
The crime that was the felony was they were trying to put her in the cell. They wouldn't tell her what they were arresting her for. And
What did they arrest her for?
it was public intoxication, is what
Okay,
they
well
said.
then, okay, now you told me she wasn't. So she either was or she wasn't. Okay. Huh?
They arrested her for that, but in the interim, when they wouldn't read her her Miranda rights or tell her what she was being arrested for, they tried to put her in the cell, and she tried to get away and got restrained. They said that she bit the police officer, but when she arraignment, they couldn't show the video because I don't know if it happened or not.
Okay, so you know that this is the whole thing about understanding how government and police powers work. And this is what I've learned, and I've learned from other people. I don't know if they learn, but they get the lesson, whether they learn or not, is that they get to go first. So don't resist them. You're just going to get hurt. Don't cause any problems. Go along with it and demand to be taken before the magistrate because they only have 5 hours to do it. They think they have
I
48
wish
hours.
we would have known it then because,
I know this. Oh God, you don't know how much this hurts because I do it to everybody, and I want to get the class going for all these people who haven't done it yet and can know, don't do it.
yeah,
Okay, everyone learns the hard way. This is the most frustrating thing, and Salem talked about it before. That now we got to learn, and now and then everyone needs to know this stuff, but they already gave all their money to the lawyers and got ripped off. They don't have any money anymore to hear it. Okay, so again, this is the lesson we have to learn, but we got to learn it. Can't let it happen to our next
Yeah.
friend and our next friend. If we learn it for ourselves, then we'll know. So the point is because they don't have jurisdiction. Okay, then that's the court. Now, see, when you get arrested, that's now you now did see. Here's the thing. Okay. Now you can still go to trial. Okay, but you have to play this out. This is why the one thing is discovery. You always got to do discovery so you can find out what evidence they have. Okay. Now the purpose of finding out the evidence is so that you can suppress the
the
evidence.
public defender is not, they were supposed to dismiss the case possibly if they didn't have any evidence. They didn't have any witnesses, any video of this stuff.
Okay.
Kind of hearing it secondhand from me. She's on here, but she's afraid to speak.
But the cops,
She's not
is she
even
listening?
here. Back east. Pardon
If
me?
she's listening, that's fine too.
No, she's listening, but she's afraid to speak.
Well, then she doesn't need to speak. You're talking for her. We're getting there.
Oh.
She can hear it.
Well, they've been looking at things about the Orange County Jail and
Okay, but
all
those
the
those
things that
those are all issues that only come up when you're suing them. We're not suing them. We're defending her. First, you got to get out of the problem you have. You can't run over, someone's beating you up and then you're going to go, oh, wait a minute. I'm going to go get me a gun and shoot you. Well, I don't think you can really do that until you finish stopping them from beating you up so you can get up and go get the gun. So you can't fight them in the case that they're coming against.
California laws.
Do you understand what I'm saying?
Yeah, I get it.
We're talking about trial. We're talking
Yeah,
about
get
going
it.
to trial.
Get caught in this system and you're stuck with a public defender and they don't call you back. And
Okay, well,
we were at this settlement hearing last week, and we actually listened to this man with his public defender. She got an alternate public defender, and he's I just want to pay the fine and go to traffic school. And this public defender just walked up to the judge, and we were sitting right there in the front row listening. And he says, Your Honor, we're going to jury trial. He told the guy that said he wanted to pay. And the public defender just did what he wanted to do. And I couldn't believe my ears.
Okay, I got a question for you. How did that turn out? How did that turn out for the guy?
He's going to jury trial because the public
So it hasn't
defender
happened yet?
told the judge.
Because I'm betting that the lawyer did the right thing.
To go to jury trial?
Yeah.
When the guy's been in court for like 5 months on this, he just wants it over, pay the fine, get it over with, and go to jury trial? Really? Wow.
Yeah. Because what's gonna happen at the jury trial?
I don't know. They'll probably tell him to go to
the worst that could happen is he's going to be found guilty and have to pay the fine.
Yeah, but it's wasting more of his money having to take off work and go. And this gal, my niece, is from back east, and she wants to go home. She wants to get a job, and every week she's got another hearing coming in.
So again, this is what happens when we start talking about this stuff. Then we're going to go talk about your niece. We're talking about this other guy who had this thing going on with the jury. See, you got to remember when you hear stuff, you don't know why it's going on. You don't know. Even in your own case, half the time you don't know what's going on. Okay, a
Mhm.
good tactic is to always push to go to trial because the other side really doesn't want to. They got to pay a bunch of money to go to trial.
Look at all that
So here's the
can
thing.
stress about, 20 years, in prison, assault on an office happened.
Okay, so here's the deal. Okay, you're in a situation. You
Oh,
let,
think
let
you're
me
gonna
just
give
let me just run
freedom?
this down. Okay, Cynthia, let me just run this down. Okay,
Okay.
so you have an attorney that you don't want an attorney. Now, so here's the question. If you don't have an attorney, can you handle it yourself? Okay, so we're going to assume that that if you can't handle it yourself, then you're going to stick with your attorney and suffer the consequences. Now, if you're willing to handle it yourself, then what do you have to do? Okay, so what you have to do is you do discovery, but you don't have to. But it's really a really good thing to do. Okay, the other thing that if it's me that I do is I immediately challenge the jurisdiction of the court. Okay, so I challenge the jurisdiction of the court, and then I'm prepared to have that denial, because I know it's going to be denied, have it judicially reviewed. Okay, so I have a plan of attack. So that's what I'm going to do. Otherwise, if I don't know to do that because I learned that, because over all these years, I would play the game. I would do like I did when they got me in for they wanted me to pay a fine for, failure to appear. Okay, well, I appeared twice. Okay, and I went through and told them, how are you going to prove it? Well, they said they're going to just take judicial notice. So when they told me when I asked how are they going to prove it, that's discovery in nature. So then they told me. So I said, good. Then I'm going to subpoena those people. So in discovery, you find out who's the witnesses. Okay, the witnesses are the cop in your case. Who's going to testify and what's he going to testify to? Okay, so then. Now, the evidence that anything he's going to testify to, now, was the arrest made with or without a warrant? Okay, well, it was made without a warrant. Well, if it's made without a warrant, then all the evidence has to be suppressed. So I'm pushing to go to trial because I want to put in a motion to suppress. I'm going to suppress all the evidence. Okay, that's in the game plan, but because I understand what's going on, my attack's going to be to the jurisdiction of the court that the court can't even have a trial. There's no jurisdiction to have a trial because who's the real party in interest here? Okay,
Right.
who is? Do you know who the real party in interest? It's going to be that cop. Is the cop the one that said that he got harmed and that she spit on him or hit him or did whatever, resisted against him? Did he get hurt? Is he made a statement to that fact and put it in? So this is because of these things need to happen. That's why the lawyers, they just, oh, well, let's just set it off for 2 weeks. Let's just set it off, set it off. We get paid, we set it off, we set it off, we get paid. It'll probably go away by itself, or they'll push and then we'll scare everybody. Oh, we're going to go to trial. Okay, well, then we're not scared to go to trial because we can suppress all the evidence. If no one got hurt, who's the real party in interest? See, when we know
Right.
these things, when we know it, we play games. When they know it, they play games. Okay, so that's when you want to get down to the bottom line, then you put in a motion to dismiss or make for lack of jurisdiction. It's what the demur is all about. Because in a criminal case, you can either plea or demur. Well,
Yeah.
you're too late to demur, right? But you can move to dismiss for lack of
I
jurisdiction.
so.
Why does the court not
Hmm.
have jurisdiction?
So she'd have to get her attorney to quit or fire him. She has to challenge the jurisdiction of the court. She has to
That's it.
judicially get it
Yeah, review.
reversed.
Here's the thing, you're gonna get a motion to
Can't
decide.
even read my own writing. I'm taking notes because she won't speak.
Well, she
Damn
needs to
it.
take notes. She don't need to talk. She doesn't need to talk. She needs to take notes that you're taking.
I'm taking notes.
Okay, good. Okay, now this
Yeah,
is
they
this,
couldn't,
okay,
bring,
this is
they
big
were
league.
supposed to bring forth the witnesses.
That's discovery. Now, did they
Oh,
have a preliminary hearing?
Now,
Yes, I had three preliminary hearings. I
Okay,
also
so-
had a arraignment, and now I'm having another one.
Right.
And they,
Oh, a rearrangement?
yeah,
Well, they're gonna
A
ask you how you plea? Are they bringing new charges?
they already did that, and they said it disappeared in the thin air.
Oh, so everything's been lost.
I don't think that you understand this is quite a unique situation. It's not like your average criminal. I'm not a criminal.
Okay, well, here's
Um,
the, wait a minute, wait a minute.
It's very unique. There's a lot of layers to the story, which I thought they had honestly, it sounds crazy, a case of false identity. You know, I mean,
Okay. Oh, okay. Well, every case is crazy. Believe me, I know. I've been through a lot of them. I've helped a lot of people with a lot of
I've
them.
never seen anything like this.
I know.
It's lawless.
I hear you. I know, but it doesn't matter because in the context of, and everyone should know this, okay, whether it's an infraction or a misdemeanor or a felony. Now, this is a general statement because there's one or two tiny little exceptions, but the process is always the same. The only difference is the punishment.
Oh,
Okay, so you got to really know that. Now, there's a couple little deals in a misdemeanor infraction. They don't give you a 995 motion, which is a
yeah, they do on a
995.
felony though,
They do on a felony, but
and that's what it is.
but it's a 991 on a misdemeanor. So you get it, you get there, you still get it. It's a probable cause hearing, but the problem at the probable cause hearing is that the lawyers don't know how to conduct them properly. They just
Mhm.
start talking. See, a probable cause means that they have to bring forward the probable cause.
I know you're saying to go by the process and
Yeah,
that's
but
what they
it's
have to
not
do, and
necessary.
that's what's not happening now.
Okay,
It's
wait a minute. The reason it's not happening,
I'm not saying nothing's not fair or anything like that.
I'm
I'm
just
saying
saying,
it
I'm telling
actually,
you, the reason it's not happening is because the court doesn't have jurisdiction, so it's gonna do whatever it wants, whenever it wants.
what do you mean it doesn't have jurisdiction?
Okay, that's a good question. Now, is the jurisdiction of the court on the record?
I don't know.
I-
I don't know what the definition of that is.
What does jurisdiction mean exactly in a situation like this? I know what subject matter jurisdiction is, but they
Mhm.
have no evidence.
Well, then they don't have subject matter jurisdiction. Because a court case is based on evidence.
Yeah,
You don't have
they
any
couldn't
evidence,
produce
then you
the
can't hear
evidence.
anything.
They couldn't produce it. The district attorney could not produce the evidence.
Okay,
They
but
said they had it.
okay, but wait a minute, but okay, but the evidence, that evidence is a one step in. The evidence they don't have on the record, which is on the face of the complaint. Okay? Or
Yeah.
what
So
we
you mean
call the
police
initial
report,
pleading.
right?
The initial pleading. That's the complaint or the ticket, right?
The
Okay.
arraignment.
Huh?
What do you, the initial pleading, like what the
paper.
arraignment?
No, the
I don't-
paper. The paper. Complaint
Oh, yeah, okay.
or ticket. The piece of paper is the initial pleading. A pleading is a piece of paper.
The police report.
Nope. That doesn't give the court jurisdiction. There you go.
That's all we have is the police report.
But that doesn't give the court jurisdiction. What gives the court jurisdiction is the complaint.
So the complaint is the police report, right?
No, you're wrong.
Then what is written during the arraignment by the DA? What's relayed? I don't understand.
Well, there you go. this is okay. So I know you don't understand, and I can't expect you to understand because it's
Well, we can't
legalese.
even tell you it because there's been so many,
Okay. Okay. Well, now let me tell you.
quittings
Let
and-
me say I got to bring you back because, and see this. It's tough because it's so basic that it's like riding a bike. Like get on the seat. Well, what's the seat? Oh my God! Now you're sitting on a back tire and everything's getting screwed up. Now, all cases are started by what's called a complaint. Okay. So this is a good time to take some notes because a complaint, the general definition of a complaint is that it has to have a claim for relief. It has to have a right to relief, and it has to have a short, plain statement of the jurisdiction of the court. Okay, those are three requirements of a complaint, generally speaking. When you have those, that makes up a complaint. Now, there's rules that require a criminal complaint to be verified. Okay,
Yeah.
so it has to be verified, and then there's rules that say that the complaint must be brought in the name of the real party in interest.
Mhm.
Okay, so who's the real party in interest in this
The,
case?
the police officer who,
Okay, so this complaint says the police officer versus Darth Vader.
yeah,
Is that what it says?
no, it says the people, it's the people, it's the, right?
Oh, okay. So the people it's in the name of the people. So now what
Yeah,
statement, and statement, I mean sworn statement, affidavit, did the people put in?
okay.
Okay, you have to have a sworn statement.
And he didn't show up for the preliminary hearing. Someone else did that didn't see it. And
Well, that's because he's you talking about a cop?
yeah, he said he didn't see it.
Okay, so the cop isn't bringing the case, so it's not him against you. He's just what we call a witness.
Yeah,
Okay, so he's not suing you. So what right to relief do the people have?
yeah.
Okay, so again, these
So how
are
does she get the complaint? How can she see the complaint? Because I'm
Just
confused on that as
I
well.
look in the
know.
file.
What
Look in the
fight?
file. You look in the
Like the,
file. You go to the
I
clerk,
didn't,
the court
oh,
clerk, and you say, I want to see file number, and it should have a number on it. You should know the number.
well,
It's gonna
that's
say
gonna be
criminal
hard.
complaint, huh?
So my
You can go
original
on the
arraignment,
internet and look at it too.
my original arraignment date disappeared. Then I had 3 pretrial hearings, which I thought that there was only one and it was my right to only one. I believe that it might be a law. But another thing is right before the first preliminary trial date, whatever, they quit. Public defender of Orange County quit and said that they have a conflict of interest. I don't know anyone in California. Okay. Then on the second and third day, the second day of the preliminary trial, a judge, this is a long story short, the judge got up and walked away out of the room and I think dismissed herself. I don't know why. Then we had to switch to another room where a judge came in and overruled everything my lawyer said. And everything was hearsay. They were supposed to get all the evidence in by that day, the 10th day of the preliminary trial, whatever. And they didn't have it. They didn't have any evidence, but they said they did, but they were supposed to have it. And then they bring in a witness that is not a witness. I mean, he blatantly said, I didn't see anything. And then they said they had a video, they didn't see it. And then they switched my court venue to from so that then we're going to trial now. So then they switched my court venue to Santa Ana instead of Westminster. So I don't know what kind of I don't know if they're going by whatever
Oh,
they're
the court
going
might not
by.
have jurisdiction. It might have to be heard in another venue. Now, now see, your attorney is evidently agreeing to all this stuff.
I'm not.
Okay, well, your attorney is, so you want to tell him you don't agree, you don't want him to agree. If you don't want him to agree, I mean, I don't
You
know
know,
why you'd agree
he
to
told
that.
me that it was going to be dismissed if they didn't produce the evidence because
Okay, well, when was that?
and it didn't. And
When
but
was that?
the last pre-trial hearing, which there were
Last week
three.
was about a week ago.
Oh, okay,
Yeah.
well, so it still might be, he might still be right.
No, because they set it to trial, and now I have
Well,
a
but wait a
new
minute, wait a
arena.
minute. Did they get the witness?
No.
The witness testified. Oh, you mean this victim or whatever it is?
Well, you said the witness. They couldn't get the witness.
The
You're
witness testified that he did not see anything. It basically on my behalf. The cop.
Okay, and what did your lawyer say about that?
Nothing. Everything looked good. The judge, it was like it was already set in stone. They switched judges. This happened within like 10 minutes. They had their own witness, the DA, then my lawyer cross-examined him. And then the judge, it looked like everything was awesome and it was going to be dismissed. And she just said that I was responsible for it and there's enough something to be
Oh,
put
okay.
to
That was
trial.
the preliminary hearing.
Yes.
Okay, well, that's all they need is that. Okay, so
Is what?
a little bit of evidence, someone saying that you did it. That's all.
No, they said they didn't see me do it.
But she still, even if some, yeah, but that's still there's other evidence that they have. Could be the cop.
The
They just
actual
put on
cop that said
They
I
just put
did.
on one little bit of evidence to go to
Oh,
trial. That's it. Because that's where you're supposed to ask, is there a warrant? Was there a warrant for your arrest?
no, I actually didn't know why I got arrested. And I said, am I being detained or arrested? They wouldn't tell me. I was in there for a long 10 hours at the most during the whole night.
Well, you usually know why you're being arrested.
No,
Okay.
I said, am I being detained or arrested or
Well,
PC? What?
but wait a minute. Do you either know why you're being detained or arrested?
I didn't know I was.
What was it
No,
about?
I didn't.
What was it
I was
about?
like, they said I was drunk and disorderly.
There
But if
you
you
go. They just told you that. That's your
no,
answer.
not that. They
That's
didn't
the
say it
answer.
then. No, they didn't.
Okay,
When I
well,
said they
okay,
just
so
came
now we
and
know what it's
grabbed me.
about. Wait a minute, slow down. Now, you were
Yeah,
drunk
I
in disorder.
understand.
Wait a minute, you were drunk in disorder. So who was determining you were drunk and disorder? Was it the cop? Was it someone else around where you were?
I think it was the cop.
Okay.
They wouldn't tell me if I was
So wait a
being
minute,
detained
wait a
or
minute. Why did
arrested
the cop walk up to you?
because the the guy at the bar called the cops, and then I told him to call the cops, and then we were like,
Okay.
"Call the cops."
Okay. See here. So now we're finally getting to the story, which takes a long
Yeah.
time because when you throw in all these little, oh, am I arrested or detained? Am I
No, I
this
didn't.
all
They
gets in the
came up.
way of the
I thought they were
story.
coming on my side.
I know. And so tell me about your side and the other side.
What side? The cops are immediately
No,
put
no, the other side. The other side.
what other side?
You
Their
thought
side?
you thought the cops were going to come to be on your side
Yes.
against who? The
The
bartender?
no, there
Okay,
was this
who?
guy. the bartender,
No, don't tell me about
bartender,
the bartender, the guy. Stay on point here. 'Cause
apparently, there was 4 people in there. But
okay, so now,
Security guard.
okay.
he said he was the owner of the restaurant, and he said I couldn't go in. And I go, what? And my stuff was in there. I was outside smoking a cigarette, and he said I couldn't go in. I go, what? And I go, who are you? And he's like, the owner. But then we later found out he's a security guard, or whatever he was. I don't even know if he
It's
was
the
a
same
security guard.
difference. It's okay.
I didn't see him the whole time, so he
Okay, doesn't
just
matter.
showed up.
Okay, so now
So-
we're getting to the point of you're being denied entrance into a private business.
To get my stuff, yeah.
Yeah.
But I had my purse.
Yeah. And you're not handling it properly because you may have
Yeah.
had too much to drink.
Not really,
Okay.
but
Well, but
I
maybe,
mean, this.
because
I mean, this
even
is
if
just this. This is yeah. I
even-
know what it looks like.
yeah, even if someone who didn't drink anything at all could still end up being so belligerent, saying they want to get their stuff and they have a right to get their stuff and blah blah blah, that it would even appear like they're drunk, but they didn't have
No,
anything.
I'm not like that, honestly.
Well,
So I'm
whatever.
really not.
I'm
Even
just
if I
saying.
had like, come on.
Okay,
I mean,
but
I'm just saying.
okay,
But
okay,
uh,
but
the assumptions
but
are there. I know that's what everyone's gonna think because everyone does think that,
that's
and,
okay.
and
That's
that's why I have to defend myself.
not what's important.
Right.
What I think. Okay, what's
I
important?
know
What the
that's what the
cops think.
court. Well, now what a trial jury thinks. The cops.
Okay,
Cops.
okay. So wait a minute. So it's all got to become played out. Now there's different options to do. One, you can realize what's going on and you can make a deal. Okay,
A
because
deal.
huh?
What with the court?
Yeah.
I can't. I can't have that on my record.
See, again, you don't understand what a deal is.
Oh, what is it?
It's whatever you come up with. So you go, look, okay, I can't have a felony on my
We
record.
have to get the lawyers of Orange County to do what we ask. I don't know in
I
any
know,
kind of
but first you have to decide what it is you want to ask them. Then
no,
you tell
they
your
don't do
attorney.
it.
Then you tell your attorney to say that, and if he don't do it, then you fire him.
Yeah.
So you
Okay.
really you have to know how to take control of your attorney because you have
Yeah,
an
I do
attorney.
have to take control. I can't even get a hold of this guy.
Well, that's another
Yeah.
reason to fire him. But you have to
Yeah.
know what you want, and you have to know if you're so deep into this thing that, and you probably are because it's not worth all the hassle and everything else. You say, look, I'll plead to a misdemeanor and no fine.
No. I don't care about that. I don't want any of it. I'm not doing that.
Okay, well then guess what? You're
I'm
gonna
going to
get the
jail.
worst of it.
I am.
Obviously. Yeah. How are you gonna get out of this thing by not giving the other side anything? You're not willing to plead to a misdemeanor and no fine. I doubt if they do.
How am I
think
going to get a misdemeanor for you can't take away this assault on a peace officer, not a real police officer. I didn't even know I didn't know I don't know if you've ever been in Massachusetts, but we don't have those. Okay? Those security guard guys that arrested
what are you
me.
talking about? I don't understand what you're saying.
We don't have peace officers. That's who arrested me.
It doesn't matter.
Well, I wasn't aware that they were police
I don't
officers.
understand. Wait.
They searched me.
Wait a minute. Slow down here.
Yeah, there's a
talking
lot
about-
of layers. I don't really, honestly, there's so much. It's just,
I'm talking
People
about
think
making a
it's-
deal with the court.
I know.
And if
So
you
they know that I'm running scared because I have,
That's
I
right.
have, I don't want this on my record.
Well,
That's what people. So what you want, even if I have the misdemeanor, it's still gonna be bad. I mean,
how
I was a
bad is it going to
teacher
be?
for
Wait,
7
is it going to be worse than a felony?
Yeah, it is because if you look at the Corey
well.
reports for my job, you can't have that. Definitely can't have violent crime on
Okay,
you.
well, then I don't know what you're going to do. Then tell me
Exactly.
what an infraction.
What's that?
Well, it's a It's a misdemeanor that you don't go to jail for.
Oh.
Traffic tickets are infractions.
They
So
won't
Zeke,
do that.
if she went to jury trial and they said, you know, they didn't have any evidence, they did the, you know, the urine test and all this stuff and all the abuse they put her in there. I don't know if they have it on video or not, but
Okay.
they just say, we don't see her guilty of anything. They dismiss the whole.
Yeah.
Okay.
Yeah, but you got to remember these DAs control the thing, and that's why there's reasons that you don't want to go to trial, and there's reasons why you want to push to go to trial.
So I don't
So-
want to go to trial. I want to make a plea.
No, we're just talking options. I already told you
Yeah.
what I would do.
I want
I
to, I
told you what
want
I
to
would do. Tell me what I told you that I would do.
fire the public defender.
No.
What did you say to do?
Well, you have to do that, I guess, in order to challenge the jurisdiction of the court.
You can't challenge the jurisdiction of the court if you don't fire the public defender? Yeah, because he won't let me say anything.
That's right. That's right.
The problem is with the public defenders here. I was under the impression that your attorney has to do what you say legally.
I know that's what everyone's thought. That's why we never get attorneys. We never get
But-
attorneys. That's first thing we do. Don't get an attorney. You know why? Because it's the attorney that gives the court jurisdiction.
Oh,
But she didn't ask for an attorney. They just appointed her one.
Well,
Yeah.
she didn't refuse him. Good night.
I
See,
guess.
that's
but
how they
now I
work.
have
This is how they work. See, they give you something. If you don't object, then you agreed. Yeah, isn't that interesting? And you know why? And because you agreed, you went to the attorney, and he agreed for you. So guess what? Now he runs the show, and he puts the pressure on. And guess who? Guess who controls the public defender?
the DA.
Exactly. Bingo.
Yep.
So you,
We find
What-
out this is a game, and it's a serious game.
no, I know it's a serious game. I'm trying to figure it out why they're not going by like, protocol laws, like whatever, you talk
I
about
told,
playing the game.
and I told you why they're not doing it. Because they don't have jurisdiction.
So what is the result of me saying you don't have jurisdiction? What's the point of that? What would happen?
Well, it's here. This is an important deal. Just saying it doesn't make the challenge. You have to challenge it, and it's done through a process.
The process that they haven't been abiding by the whole time.
No, you have to do the process.
How do you do it?
Well, there's different ways. In California, we have a number of different ways to do it. I don't know how you do it in
No, in California, I have to.
but they're basically the same, but it's different ways. They're just the vehicles,
Mm.
And
Do you make a motion or do your
Yeah.
lawyer has to file something, right? Like, I don't know. I don't
No,
understand.
no, wait a minute.
You yell out in the courtroom?
No, you have to make a motion, and your lawyer won't do it.
No, he won't.
I know, yeah, I know he won't, because when we came in and said we want you to put in a demur, which is what the challenge to the jurisdiction is in California, he said you have to do that yourself. I'm not doing that. So this is the problem we have. See, people don't know. I could tell you got to put in a motion. So hey, you don't even know how to write a motion, so you probably wouldn't even know what to put in the motion.
Well, I could figure it out, but
Okay.
I can't file a motion, right?
I think you can.
I'm pretty sure I can't.
Well, why
Because
not?
he's already represented by counsel.
Yeah, but what if,
That's the problem. You need to get him fired first and then file
See-
your own motion. But the judge is going to have to deem you, deem the public defender that he hasn't done what he's supposed to do.
No, he doesn't have to deem that. He just has to take step down off the case. The public defender doesn't have to be found guilty or not guilty
Now
of
they'll
anything.
pull him a Marsden hearing on her, and then
Okay.
the court will deem her
And what's the
incompetent.
Marsden hearing say? That's
Okay.
right. Is she competent to defend herself or write a brief? That's it. Is she? She go to high school? She speak
Yeah.
English? She told me she could do it. You know,
yeah,
you
you
gotta do it.
there.
So there you go. This is how we all did it. We all end up being our own lawyers or being in pro per, and we know we have to do it. We've accepted it. That's why we have these meetings, because we're all learning. And that's but no one's set down to give the course. So I'm
Do you know
ready
if
to
there's a templates on motions? If you can download any templates on how to do the motion in the correct format?
well, I'm sure there I'm sure that there are templates for
I've
motions,
looked, yeah, I've looked. I'm like, wow, there are, but
but you got to pick which one to write and put the specifics in yours and know how to
Mhm.
serve it and know how to make it sufficient for the court to make the ruling. And then you have to expect that they're going to deny it. Okay,
yeah,
so know they're going to deny it. Then you have to know how to take it up on what's called an interlocutory appeal or a writ of mandamus. So you have to know how to do that and what the procedures, and then you need to know what the argument in there is and which law that they're not following. But,
Welcome to Law School 101.
did they do they have to be do they have to tell me why they have what is it, conflict of interest? Do they have to be transparent about that at all?
yeah, I think they do.
Well, they won't. I mean,
Did you ask your attorney?
yeah,
What did he say?
I don't know. He
He said,
seems like,
wait, he said
yeah,
he didn't know, or you don't know what he said?
no, he said he didn't. He said, I don't know, like that verbatim quote. I don't know.
Well, there's a good reason to fire his ass.
Yeah,
He's probably lying to you.
yeah. And it was weird how the third judge just came out and that happened when it sounded like it was in my favor.
Yeah, he's supposed to do that ethically. I would ask him about that. I would tell him I want to know why they have a conflict of interest.
Yeah.
Now, see, a lot of they could know one of the people at the bar. They could know someone who owns the restaurant. They could know, you know what I mean? They could have a
Yeah.
friend, someone who's acquainted to them. There's a
Well,
lot of
that
different.
could, if that's the case, then the conflict of interest would happen every 5 seconds. The conflict of interest in my case would only be if someone's on my case, or if I pretty much, I
What do you-
thought I knew I was right about the conflict of interest. It doesn't, that wouldn't fall into that guideline, the conflict of interest.
What do you think the conflict of interest is?
Conflict of interest, there's different ones, a judge, a lawyer, everything, but they're saying that the conflict of interest with the public defender's office is that they're not saying anything. They're just saying there's a conflict of interest. Now,
Dick, let me tell you what it is. I'm in the public
no, it's
defender's
not her,
office.
because she wouldn't be under the
Okay.
conflict of interest. She's in a go ahead, tell him.
Wait a minute. Are you making conclusions of law and you don't know anything about the law?
No, but why don't you
So
tell
why
me
don't you
what
let her
conflict
tell me what it is?
Go ahead. But it doesn't fall in the thing. Like, go ahead.
Maybe you're wrong.
Well, they
Why
should
don't you let her tell me what it is?
No, go ahead.
You're in the
The public
office,
defender
Cynthia?
believes that looked at her when she was in the arraignment as defending me on this dog rescue I did. I've been in court for 4 years. He looked at her, and that day they decided there was a conflict of interest because I'm
Yeah.
in the courthouse. That
With her.
I mean,
Okay,
we
yeah.
would assume that's it. We would assume definitely. That's what I initially assumed. We both did, but
Okay.
I don't think it's that.
So well, obviously it is. They
supervisor
said
there at the supervisor there at the public defender's office at Westminster Court. His name is Darren Thompson, and he's been horrible. I'm not going to go into
Yeah.
the story, but
okay.
when
Okay, well then now
Tammy was a
after an hour and a half,
Tammy's
you
a
got
witness for me. She's a witness for me in a jury trial that's going to be coming up in April. I think the conflict of interest is.
Okay, well, obviously we've finally got to what the story is. And you got to do what you got to do. I can't tell you what to do. I'm not an attorney.
I guess probably because I was a witness, I guess, but it's
I would tell you what I would
how
do.
many witnesses do it go through their courtroom that are on other cases that know the other people and have their own case going on? You know what I'm saying? They'd have to be conflict of interest in every second.
No, was their name Cynthia?
What do you mean?
I mean, Cynthia is a special person down there. They don't want to have anything to do with her. And if you have something to do with her, then that's a conflict of interest. Now they can get off of cases on conflict of interest if they want to. And if they don't want to, then they would say there's no conflict of interest. They decide whether they want to do it or not. And they know Cynthia, and so they don't want to be hammered with this stuff. So they're gonna just stay away. There's no law about it. They just say, "Oh, no, I know her and I've dealt with her. So her friend, I got a conflict. It's a personal conflict."
So the public defender's office, which now I heard people call it public pretender and stuff like that, and they call it the DA's office, is not like Massachusetts. I mean, most of them work like pro bono or something, and you get kind of real lawyers. I don't know.
I think they're all the same all over. I don't think you ever get any real lawyers because it's a real lawyer. A real lawyer costs like
Someone with their own
$600 an hour.
office. Yeah,
Yeah,
because they have to do so many hours a month.
no, because they get results. The public defenders who go pro bono, they make $200 or $300 an hour.
Yeah.
Okay, there you go.
Um,
They're just running the mill.
yeah, I don't know. They said public defenders in Orange County make $300 a day, which is nothing. Are you saying an hour?
Yeah, an hour.
Jeez.
Well, this is California, They got big taxes here and big everything here. Big bucks.
So does the Department of Justice oversee the trial courts?
Yes.
And are they in on it? This little
Yes.
Oh yeah, so you can't count on them, right?
Correct.
What about obviously the governor's office is in on it too, right?
Yeah. Yeah.
Oh, that's Newsom. Oh, good luck with him.
Oh God.
See, what people don't know is the way it's set up is that it's there's a thing, there's a process, okay, a system, or a like the way we think it's supposed to be.
Yeah.
Okay, that's called judicial power. Okay, and this judicial power, it's vested in the one Supreme Court. You know what the one Supreme Court is? That's the national, the constitutional Supreme Court. Okay?
Yes.
Okay, so that's where this judicial power is. Now, the Congress made all the courts, all the other courts, you know, the appellate courts and the federal district courts, and then all and the states made all their courts, but they still fall into this judicial power thing. So the judicial power has been leaked out like into all the courts, all right?
Mm-hmm.
But it's only leaked into all these other courts into the very top of the court. Okay, so you go in looking, thinking you're going to find it when you go to court, but it's not in those courts where you're sitting at. It's only in the common law section. Okay, so to speak. And that common law section, that's like at the top of the court. Okay, and the top of the court is run by the what they call the like the chief justice or the presiding judge. So the presiding judge or that position, if you understand what I'm saying, doesn't have to be that person, but that position. Every year someone gets put in that position as presiding judge.
Okay.
So that presiding judge position is the only place where you can get this judicial power. Okay?
Okay.
That's why we can't find justice anywhere, because it's only in there and there's a process to get to it. Okay? And that process, the lawyers, they kind of know about the process, but they don't really understand what the purpose is because they would never use it. Because remember, when they go to the court, they're under the court, they give the court jurisdiction. So they would never go to this one part and challenge the jurisdiction of the court. But it's really the challenge of the jurisdiction because you're getting all this legislative law, but you're trying to defend rights.
Yeah.
And the rights and the justice is only in that one spot with that you get to by a old English common law process. So it's in the common law process that gets you to that remedy. See, and that's why we don't get justice in there, because we didn't go in right, and that's why I say that court doesn't have jurisdiction. Because you want to be in the court that has jurisdiction is the rights court, which is the common law judicial power court, not legislative complaint court.
So, okay.
So you have to petition the government. You have to petition the court for a writ of mandamus.
A what?
A writ of mandamus.
Oh, okay.
To have the lower court, you're going to sue the lower court to have
Is it
them.
still going through the process, the steps, or am I just going to jump to that?
Well, that's what this steps do. It's
Oh,
like
okay.
filing. It's filing the process. It's filing a petition instead of a complaint.
Yeah.
And it's called an alternative writ.
Once we do that, do I still have to have, then I go to a different court file?
Yeah, no. Well, no, you go to the superior court, you go to the same court,
Mm-hmm.
but you don't file it in your criminal. Well, you
It
can
would be
file.
like civil, right? Because it's one human against another or something? Or
Well, you can be civil, but there also is a they let you
that's
do
a
that
felony.
if it's an appeal. So you could probably do it under that same code section, and it would go to the appellate department. But I would, yeah, you could just file it. You could file it under that in that case, the same case number, petition for writ of mandamus, alternative writ of mandamus, and then see, then you put the alternative. You say dismiss the case for lack of jurisdiction, or in the
Oh,
alternative, or in the alternative, show the jurisdiction.
how would they defend that? How would the DA, well, how would they come back to that?
Well, they'd have to show the jurisdiction of the court.
How would they do it?
Well, how can if they don't have it, they can't.
Okay.
See, because I said they don't have jurisdiction, and you kept saying, "Well, how do I know that what gives them jurisdiction? What gives them jurisdiction?" Well, they know. The judge knows. The court either has jurisdiction or it doesn't. It doesn't matter whether you claimed it did or
Isn't
didn't.
isn't in felony cases of the violence, the people, the DA always takes over? Um,
Well, they do, but that doesn't give the court jurisdiction. Because
so
you
that
remember, okay, so remember back in the, I mean, I remember in the 60s and 70s, maybe even into the 80s, I don't remember, but I remember when the cops had come out, and the husband was beating the wife, right? And they go, okay, we're going to take you in, and then she'd say, no, I'm not pressing charges. I'm not pressing
then the
charges.
state takes over, right?
And then they say, okay, well, we can't do it. So because she won't press charges. So then somehow, some way,
Yeah,
the state took over,
yeah.
but did they really? Can they do that?
I know.
So I say they can't do it still. They just did it and fooled everybody.
Yeah.
But no one challenges it. And it's because the lawyer don't challenge it. Remember, no lawyer challenges jurisdiction because they give the court jurisdiction. So who's going to challenge it? So there you go. It's pretty
Thank
simple.
you. I'm gonna
So
research all of this.
I would continually tell them, look, you got to show that the court has jurisdiction. And don't ask me. Just show it. Put it on paper. Don't ask me. I'll take it to my friend and he'll determine, or somebody, I'll take it to another judge. But you don't need to say all that stuff, but just you put it on the record that this court has jurisdiction. I know that it doesn't. If it does,
Okay.
show me where it is.
I swear, Zeke, what you were just saying about, the husband and wife and the thing in the 60s and 70s, it's kind of like the same thing here. Could be a mistake of identity, I mean, what if somebody completely was just passing by there? I mean, they didn't read her rights or anything.
Well, wait a minute. Wait a minute. Now, wait a minute. Wait a minute. Wait a minute. Let's keep this thought within context. Okay. There's not just someone passing by. You're talking about a cop. Remember, we talked about police powers last year's. So we assume and presume, and the cop gets to go first because we know he don't get to do anything without a warrant, but we know he's going to do everything without a warrant.
Are they allowed to search me if they're peace officers in a cell by myself with no woman? And ask me if I have a hotel for the night? I mean, I know that that's all hearsay and sounds like whatever, but I mean, I honestly thought they were like some kind of, I didn't think they were police officers. They were wearing t-shirts with writing on the back. There was no badges. We don't have that in Massachusetts. They're not allowed.
Okay, well,
Security.
I don't know if you're in a cell. Okay. Are they allowed to do it? Of course not. Do they do it all the time? Of course they do. Now, is it worth it to you to go spend all your time, energy, and money learning all this stuff, running it down, figuring it out?
I really didn't know I was arrested. They kept me in there for like
Well, okay, okay.
7 hours and then another 3 hours.
So see, I'm answering your question, but you're just telling me some more information.
Yeah.
Okay, because remember when I did this, I just took my plates off and got rid of my driver's license. Okay. And I could have easily just said, okay, well, I'm gonna then pay it off and go back to what they could do that. But I didn't think they could do it. Okay. Then I kept thinking, hey, I'm doing it wrong. I'm doing it wrong. I'm not doing it right because I know I'm right, but something's not right. I'm not doing it right. I'm not doing it right. Then it took me 40 years to figure out they're corrupt. So I got to figure
You
out
know,
how
Zeke, I think where it's confusing for her is they never did a breathalyzer or anything to prove that she was publicly intoxicated, and then they her
Okay.
random rights,
And
she
my
got
lawyer
a little
fought them.
bit.
Well, okay, wait a minute. The testing of the alcohol is important. The reading of the rights is not so important. Because if you're
Well,
supposed
they
to know
didn't
your
do a
rights, you're supposed to know your rights. And what information did she give them before they read her rights?
They never read me my rights ever.
Okay, well, but what information did you give them that they can't use against you?
Oh, nothing. I said,
Okay, well
what?
then
Am
the
I
reading
being detained?
then the reading of the rights doesn't apply.
And I was like, why are you
But
taking me? They just came up and took me,
the
and they could
evidence
tell you.
as to whether you're have alcohol drunk, that applies. So they have no evidence you were drunk in public. That's their problem. And that's a good reason to
They
have a
don't have
conflict of
jurisdiction.
interest to get off the case and just keep the damn thing going till it fizzles out.
Oh, geez.
So
Is there a timeline on this thing?
well, no,
Like,
your lawyer waived it.
what do you mean? So
I
what?
think you
How?
lost your right to a speedy trial because he already took it into the next step.
No, because he waived the speedy trial.
Yeah, he did. No, what's the alternative to waiving the speedy trial?
Firing your attorney.
No, I'm saying what he said.
Oh, you mean if it was 60 days?
Yeah. So I
So have you
think
been
that's what I
arraigned?
did.
Have you been
Huh?
arraigned? 60 days from the arraignment or the
She got
plea?
arraigned twice.
I'm apparently, which they never told me.
Did you listen to what I said? 60 days from the arraignment or the plea, whichever is last.
I'm not sure because I think I pled already, right?
Okay,
Or
well,
they
the day you pled is when the 60 days starts. But that was
Well, she
waived by
pled
your
not
attorney.
guilty of it.
Yeah,
But
I'm
you know,
not.
but anybody that's listening can know, even if they give you an attorney, you tell them, I don't waive time. You don't want to waive time. Now, if you're guilty, you may want to waive time to figure out a way to get out of it. But if you're not guilty, there's no reason to waive time.
Yeah, I
Anybody-
didn't. I don't think I waived time.
Well, your attorney did.
But we won't know that court clerk
Huh?
standing.
How long has it been since you pled?
She doesn't even know if she pled or not.
Yes, she does. She knows she pled.
I know I had a arraignment, right?
Not guilty.
Did you say not guilty or guilty?
Yes, I had an arraignment.
What day was that?
That was the day they something the 22nd, I believe. I'm not
22nd of
February.
February.
Oh, okay. So it hasn't been it's only been 30 days. Almost. Okay, so maybe you ask your attorney, ask him if you waive time.
But
If
it
you waive
could
time.
just might be, so they said my real or my arraignment has disappeared in the system of the DA's office or the county,
Okay.
not the DA's. For some reason, the original arraignment, which under my impression is when the first start of the court process, right?
Yep.
That disappeared. My pleading, meaning not guilty, disappeared, and my new arraignment, even after the pretrial preliminary hearing, is Thursday. I
Oh.
don't know what is happening, and that's what
Well,
happened,
okay,
right?
so if so you before the Thursday, okay, you're gonna have to talk to your attorney. He probably isn't gonna want to talk to you. So when you get there, and they call your case, and before whenever you get a chance before the hearing, you tell them you want to talk to him.
Yep.
Tell them I don't want you to waive time, and I don't want you to this and that. Or you just tell them, look, you know what? You're not going to spend any time talking to me. Then I can't have you represent me. So I'm firing you. I'm going to tell the judge right now. And here's why is because he won't talk to me. So he's fired. And so now you can continue the arraignment, or we can do it right now if you're ready. And then you need to be ready. If you
What
can take the
happened?
case on, if you can take the case yourself, you better take it. And if you can't take it, then you're going to suffer. But you can still tell your attorney what you want.
Yeah.
Suffer.
I
You
know.
don't ask, you don't get.
I mean, I'm not the type of, I know what, like, I'm not the type of person. I do recognize that what is it, that statement? Your own defense is the worst or something?
Oh
Being
yeah,
your own,
yeah, right.
Offense is a defense, so you're getting,
No,
that's defense.
yeah.
a lawyer who represents himself as a fool for a client.
Yes, 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 yeah.
I got that. I
I'm
wrote
not-
that
What,
down.
did you repeat that? What?
a lawyer who
Zeke, what did,
represents, say it.
Let me see here.
A lawyer who represents himself has a fool for a client. Or yeah.
That's right. Yeah. So that's
trying to take notes here, so I didn't even hear what you said, Zeke.
yeah. Okay, so I'm putting together a course.
Yeah.
I can't open the damn thing up. Let's see if it's going to open for me. Let's see if I can open it in notes.
Oh, you're not the leader of the class, so you can't share it on the,
No, I have I had it in on my computer, and I'm not at home, and it's on a laptop. And this laptop is Apple, so it doesn't take it does. I don't have a word processor.
Word. Yeah.
Maybe I can get Microsoft Word. Okay, so they can't complete the purchase. Okay.
yeah,
All
we
right.
need to put more money in that account, Zeke.
Yeah, exactly. But anyway, this is how I put together that quote, and then I said that there's a quote that says that that the lawyer gives the court jurisdiction.
Yep.
Okay, so now you have to pick. You're either going to give the court jurisdiction, and the lawyer is going to proceed and take over your case, or you're going to take control of it by yourself. Now, because that quote that she gave, guess who made it up? A
A
lawyer.
lawyer. Yeah, yeah.
Of course. And the lawyers even believe it. They don't even represent themselves.
No, never.
Yeah, because
I never see it.
they're systematized. They believe in the system. They don't realize that they give the court jurisdiction. They just couldn't think otherwise. Of course, the court has jurisdiction. I mean, how could it not? We're here. right? Then that the judge tell you, I got jurisdiction. You're standing in front of me. Okay, but who's got the guts to say that when the judge says, "Well, you're here." Oh, judge. Well, excuse me, I'm in the wrong court. Bye bye. Now you don't have jurisdiction and walk out. Walk out.
It were that easy.
Well, it is. It's that easy on any traffic ticket for sure. But guess what? I did it, and guess what happened?
What?
They put out a bench warrant. They
Oh,
wrote a
yeah.
letter. They said, okay, if you we found that you failed to appear. So they
Mhm.
said they're going to charge me with failure to appear, right? So I said, okay. See, technically, I'll tell you, I think I told this story. But anyway,
I want to hear it.
I go to the court. I got stopped one night. It was about midnight. I was coming home with my girlfriend, and we finished a bottle of tequila
Oh
because
my
there was a party. And I'm cruising home, and we're on this road that's very, there's no place to pull off really, and it's dark. So it's midnight, so no one's on the road. And I look up, and I see this car coming up behind me, and I go, man, this guy's moving, So I saw him coming, and boom, all of a sudden the lights are on. So it happened to be right there. There's very few pull-offs on this road, but boom, the church was right there. So I pull in, and I'm like, oh man, what do we, this guy? I mean, I've had half a bottle of tequila, and it probably was only a half because my girlfriend, she could outdrink me. So he says, oh, your tail light's out. And I go, oh, and I get out and I go back and I look, and it's half out, right? But I don't want to talk to the guy. So I give him all my stuff. And this was after I'd went and got a license, because I drove without for 20 years without a driver's license. So it was fortunate that I had one, and my girlfriend made me get one. So I give it to him. I give him the registration. He comes back. He says, you didn't give any proof of insurance, so I wrote you the ticket. I'm like, great, sign the ticket. Awesome. See you later. Okay. So now I go, and they said I didn't have insurance. So my girlfriend says, you got to have insurance. Okay, I'm going to go get insurance now, because, I went 20 years without insurance. So I go get the insurance. I go to the court. I go, here's the proof of insurance. And the clerk goes, well, you got to pay $200 fine. And I go, what? And she goes, yeah, you get a $200 fine. And I said, no, I don't think so. And I'm leaving, and she goes, well, you better show up tomorrow, because that's the court date, right? So I go to court. I go, and I know the commissioner. He knows me. So it is unbelievable. So he calls me up. I said, yeah, I took care of everything at the window yesterday. The commissioner goes, he looks at the clerk and goes, is that true? And she goes, yes. And then he goes, okay. And then, and I'm walking out the door, and she goes, but he didn't pay the fine.
Oh God.
Okay, so I left. So now we have the letter saying I failed to appear. Right?
Yeah.
With a warning. Okay, so now we got failure to appear. So I go, they said, you got to go back to the court and settle it, right? Appear. So I said, no, I'm not going to go back to that in front of him again. So I said, send me to a different place. So I go to a different court, and this is all the felony guys, right? The big felony court.
Oh,
These judges hear the felonies.
because you have a bench warrant.
Yeah, I'm on bench one. Okay. So the first thing I go in there and the judge goes, and this is a judge that didn't know me. All the other ones knew me. Okay, this guy don't know me, right? So he goes, "Oh man," he goes, "This is a misdemeanor. We're gonna have to give you an attorney." So I put my hand out, no attorneys.
Oh, what happened?
Well, he started looking at the paperwork. And he's going, well, because he couldn't talk me into it. I already told him two definite, no attorneys. Okay, so he's looking, he goes, well, I guess I'll see you for trial. I'll set the date, on next week or something, or 2 weeks. And I said, yeah, that's a jury trial. And he said, yep. And the clerk goes, nope. And he looks at the clerk, and he looks at me, and I said, jury trial. And he goes, yeah, jury trial. And the clerk goes, nope, no jury trial.
Wait, did you want a jury trial?
Of course I wanted a jury trial. They're going to call a jury for a $200 fine?
I know. True.
Okay, so that's
And then they're all
why
gonna miss
that's why
work
that's why the clerk kept saying no jury trial.
Oh,
So I said, and I already knew what was going on because I've been through this. I already knew exactly what they did. So I wasn't worried one bit because I know that the law says that they can reduce a misdemeanor to an infraction. But here's what the law says. If the defendant agrees. Okay? If the defendant agrees. Well, so the clerk was saying, we're reducing it to a misdemeanor. You're not getting a jury trial, or to an infraction. You're not getting a jury trial.
and you
so,
still have to pay.
huh?
And you still have to pay the fine, right?
No. So if you don't object and say otherwise, then we're going to reduce it. Did you get that? Because this is what we're talking about. They reduce it. You don't object. That means you agree.
Oh,
They're going to deny me a jury trial on a misdemeanor. The judge couldn't believe it either. Oh, but then they reduced it to an infraction. Well, I know. They reduced it to an infraction. And yeah, you guys have already heard my story about me and the judge and reducing it to an infraction. And the DA saying, we thought he meant the infraction, not the misdemeanor, because they wanted to reduce that. Where's my jury? And then the judge said, you get a jury. If you want a jury, you get a jury. The DA jumps up. Yeah, it's a year in jail or $1,000 fine.
oh, geez.
But if no jury, then it's only a $20 fine. Well, you got to decide right now. You want a jury trial or
So what did you decide?
well, that's what he kept saying that, and the judge and the DA kept jumping up, telling the judge to tell me the maximum penalty.
Yeah.
And so, but I had 50 people there. This was my first trial back in 1984, and we had to go into the supervisor's room, and they're all back there, and I'm like, I'm like going at it, and then now this, and then so I look back and I go, well, what do we do, guys? And they're all going jury trial. So I go, well, and the DA jumps up again, tell him, judge, maximum penalty. Okay, well, what do you want?
And
the
then
minute
what?
I said jury trial, the judge, the DA jumped up and said, we move to dismiss double jeopardy.
Yes.
Yeah. Yep, because we already started the trial. That means they gave me a trial without a jury. So now they can't go get one. It'd
Wait
be
a
double
minute.
jeopardy.
How did you do the double jeopardy? Because was it two courts?
We were already in the court. We were already in the court, and we were doing a trial for infractions, but they reduced this charge, failure to identify, to an infraction. So I'm
Okay.
being charged on it right now, and in the middle of it, I go, "Where's my jury?" And they go,
Yeah.
"Well, you don't get it. You don't get a jury. Well, you do get a jury." Well, hey, I never agreed. I never agreed to not have a jury. But they gave it and said it showed up with no jury and started proceeding. Once you start proceeding, then it's double
That's what I'm
jeopardy if you
saying.
start over.
That's, I was under the impression that my next hearing was the start of the trial.
No,
now
the
they're
trial's
saying-
a trial. A hearing's a
What?
hearing, the trial's a hearing's a hearing, and a trial's a trial.
Well, isn't it? Well, that's what he said. He goes, "We're going to trial." I go, "So that's what I'm coming to court for next time. We're going to trial." And I
Well,
go,
unless your attorney calls for a pre-trial conference, and
"But
then
we
they
already had that, right?
well, then if
Pre-trial
they
hearing."
well, yeah, well, if it's set for trial, then it could be set for trial. But a lot of times they
But now they're saying it's an arraignment
well, then it's not a trial.
again. But what no one, me and my aunt only learned. Well, I discovered this when we called the DA's office and asked for the case number or something, or not the DA's, the public defender's office. I don't even know, both the same, but we
Well, yeah.
called them and they said it was an arraignment. And I'm like, I already had the arraignment. What are you talking about? So can they bring up different charges on me again or something?
Well, they can, but the other thing is the clerk can misspeak. The person on the phone could be misspeaking. And what they say maybe not be true.
We got two sources, I believe, right, Cynthia? Is she
Right.
Oh, okay. Yeah.
You
Yeah,
gotta
I-
talk to your attorney about that.
Yeah, but they,
Only trust your attorney.
I've been to this
Or look
public
at the
defender's
file.
office for 4 years and there's no crime tent. It was a dog rescue. I mean, in there and I know everybody's sad. I feel like Shawshank Redemption over here. Everybody's innocent, right? But honestly, I've called the FBI, the district attorney, the governor. I have filed motions. I've even done my own motion to dismiss with this dog rescue that I did with this maniac that used the Secretary of State to make his little 2-bedroom apartment look like a drug rehab center, to turn in his 18-month rehab, trying to extort the court and get restitution from me when he's a loser. You know, that's why I'm in jury trial next week. I've called all of them and filed motions. I have proof of service for 4 years, and they're still coming after a 66-year-old disabled senior that has no record at all.
Mm-hmm.
And they're
Well, there's
taking
a
me
lot
to
of
jury
times
trial.
they
So
get to court and drop it. Remember, they go all the way to the court and then drop it. If they don't have a case,
Yeah,
they're
well,
dropping it.
in the meantime, this family's in the twilight zone because I don't believe my niece was publicly intoxicated. We can have a couple of drinks together. You wouldn't even know. You know, her
Okay,
legs were
okay,
heavy.
well,
I
but
think
they don't have any
I
evidence to
roofied
prove it.
her in that
They don't
car.
have any evidence to prove it. That's
To-
their problem. They got no evidence.
Yeah.
So before the trial, I put in a motion to suppress. But see, there's all these things. You don't even know where you're at. If you don't know where you're at, how are you going to be able to proceed with the process?
I
And you got
know
an attorney
I was
blocking you on
researching the
it.
P9995 motion or something.
Yeah,
Is that it?
995. Yeah.
995 because
So,
it didn't have like grounds to push it to trial. The judge,
right.
with all due respect, didn't.
So did you ask the
Yeah.
attorney
Because
why?
they had no right to arrest her.
Forget about the
They
arrest.
had no right,
It's about going
and
to
they
trial
couldn't
now.
show the
But
urine
see, no,
test
that
that she
ain't
was
gonna stop it.
intoxicated.
That ain't gonna stop it. If the arrest was illegal, that doesn't mean that the trial is not allowed.
You know what,
Did you know that?
Zeke? Did you ever watch the Andy Griffith show?
Of course.
Where's
refer-
Sheriff Andy Taylor to take care of this thing and get us out of this courthouse?
He's over partying with what's his name? Ironside. I mean
These men were so
Perry Mason.
Perry Mason, yeah.
I called them a bunch
Oh,
of Gomer Piles. I really didn't know they were. I'm like, who the hell are these guys handcuffing me? And Who are you? Like, I was like, who are you?
Well, you know, my buddy that first taught me this stuff would say, "Welcome to America."
Welcome to
Yeah.
California, the
Oh,
Wild
you
West.
believe me, it's the same everywhere. You'll see.
I just,
Or it's
Oh
so
yeah,
they were
what did I
really,
tell you about that time? Hey, see, and here's what when I couldn't believe how it was like you till I did believe how it was in about the year 2000. So I get busted, 5 felonies.
oh my God.
So we tell the judge, I tell the judge I'm gonna be my own attorney. Well, he asked me all these questions, you know. Of course, I didn't know half of it, but I thought I knew half of it. So he goes, well, so after that, you know, you still want to be your own attorney? I'm like, oh yeah, definitely, no doubt about it. He's like, well, okay, against my better judgment. Well, of course, you have to let me do it. So he says, okay, you can do it. So I go over to the DA. It's an he's assistant DA, right?
Hmm.
It says, well, I said, so now what are we going to do here? And he says, well, you know, I can't talk to you because you're the defendant, but I have to talk to you because you're the attorney.
Hmm.
I said, there you go. And I said, hey, so I said, so what are we going to do? And he says, well, why don't we just wait and see what happens? Okay, so what's he saying there? See, let's wait and see. Let's wait and see what you do. It's your move. You got to do something, Zeke. What's your move? Right? So I go, hey, you know what? I think I know the DA. What do you think he said to me?
I don't know.
Can't wait.
Huh? He
Can't
said,
wait to hear what he say.
yeah, you
Yeah.
can't wait. Because you know what? I couldn't believe it. He said, that will get you off. Huh?
I mean, it will, but what happened?
Really? And who said that? Your niece or you?
Me, the niece.
The niece said that? Oh, you
Yeah.
kidding me? What do you mean? We're here for justice. They got to do the right thing. They're supposed to do it by the book.
No.
Okay, well then, okay. So now you know they're not doing it by the book. They don't have any jurisdiction. They're going to do whatever they want and put you under whatever conditions they want to and bluff, bluff, bluff. Because
Yep.
you don't know. And that's the thing about it. Everybody gets pulled over. They get pulled over, and then they ask the cop, "Oh, don't I have a right? Don't I have a right?" Well, if you don't know your rights, you don't have them. And if someone has to read you your rights, then you don't know them. And if you
It's exactly what you said before, Zeke. If you don't object, like she object
right,
to
you
a
agree.
public defender, she objects to that 5 hour thing, which I didn't know about.
Mhm.
You know, you don't know what to say. So now you know next time, Demi, there won't be one. But
I know.
that
The
5 hour
thing
thing,
to
what
do
is
is
that?
always be
What did you say
prepared.
about that?
What is it, Cynthia?
The 5 hour thing when you first get thrown in the pokey.
Oh, well, that is, you read that case, read the case.
You ask a judge or a magistrate.
You always want to go to the judge or the magistrate because the arrest is always illegal if they don't have a warrant.
Okay.
But you got to have the judge determine whether there is a valid warrant or not, or if there's grounds for a warrant. You know what grounds for a warrant are?
What?
Probable cause. Only the judge can determine what probable cause is. That's grounds for a
How
warrant.
could she determine probable cause when they couldn't even determine if I did it? What, you know what I'm saying?
No, determine probable cause for the arrest.
Oh, I don't know the probable cause for the arrest because the peace officers never read me my rights. I requested I didn't think they were real officers. I was
Okay,
like, I need a real
you're gonna
officer.
have to write this
I was
down.
in there for 10
You're
hours.
gonna have to write this down, 1538.5
Yeah,
of the penal code.
okay.
Now, you see, the problem and you know, I don't want to sound harsh, but you know, and I'm not,
It
because
sounds bad. I know.
I
It's
know I'm doing
embarrassing.
it, and because it's an emotional thing
Yeah,
both ways. See, is that when you bring up all these facts about how badly treated you were, how long you
yeah,
were in there, how they did this and how they did that. Okay, all those facts are like complaints.
yeah.
Okay, and this is not an arena for complaints,
hmm
and that's
But
kind of why.
isn't there codes that they have to go by, like
No,
not
no, no,
abusing
no,
me?
no, no.
What
You
about
can
search and
complain.
seizure on a female without a female
They already that not in this process. They've already done what they did, and all those complaints go to a different court. They can't be raised in this proceeding. This is why I said I don't want to sound harsh or anything, but we can't even entertain them. That's
Then
a
maybe they
whole
can say
other
I'm
case.
not of sound mind body because maybe I am retarded because I didn't know they were cops. I thought I didn't know who the hell they were.
What they
I
did
asked
to
for a police
you,
officer and a sheriff came. A
whatever
sheriff
they did
came.
to you, whoever they did, are not relevant in this arena. And this is why one reason for that quote about attorneys, because when people become their own attorneys and they get emotional and they bring in
Yeah,
other things that are not relevant, that's when you
yeah.
lose the case.
I know you're prepared to say that, but they the thing is, for me, they're supposed to have they wrote on the police report they had uniforms identifying their badge number and all this stuff. They didn't have badges on. They had t-shirts. You know, I couldn't even I was like,
Okay, okay. So
and I don't believe a peace officer is allowed to
again,
search
again,
me.
that those arguments, and I don't agree or say it's not true. Everything you're saying is does not get you off.
Yeah, yeah. And I mean, I know they don't have to
You
read
can go
me
after
my
them
right.
later. You can go
But what
after
their
them.
probable cause was I smelled like alcohol.
You have 2 years. Probable cause does play into this thing, and they have to show the probable cause. We don't know what it is. That's why you have this hearing, and you do discovery. You do discovery to find out what their probable cause for the arrest was.
Well, the judge assumed they did because she.
No, the judge never assumes, because the judge is the only person who can determine what probable cause is. Probable cause is a judicial concept. It's not
Mhm.
defined in the statutes or the law. It's not, you won't find what probable cause is or isn't. A cop, isn't a judge, so he can't determine what probable cause is. He can guess, and then you take it to the judge and ask the judge. And the same with you and me. I can't determine what probable cause is. I have a good idea. I think like a judge, so I can guess, and I'm pretty sure I know what it is, but I can't issue a warrant because I'm not a magistrate. So I don't determine probable cause. Only a magistrate determines probable cause. So the judge determines if probable cause is there based upon the facts that the cop gives them. So the cop doesn't go, "Oh, I had probable cause." The judge, they say, "Here's the facts." Okay, now, if the judge determines there's probable cause, now there's a requirement. You know what the requirement is when a judge determines the probable cause? They have to issue a warrant. So if the judge didn't issue a warrant, then a judge never determined probable cause, because evidence of probable cause is a warrant. So it's obvious that the cop didn't have probable cause because he didn't have a warrant. Now there's probable cause to arrest you, and there's probable cause to take you to trial. They're two different kind of levels of probable cause. And that's why when we say, oh, if you determine there's probable cause, judge, then issue a warrant for my arrest. And then the judge says, well, why should I issue a warrant for your arrest? You're standing here right in front of me. Oh, okay. See you later. Walk out. I've appeared. But that's on infractions. That's not on felonies, but the same applies actually in a lot of the same instances. You know, the only thing is your bail. I don't know if you still might be able to get your bail back. But you're under bail, which is another level of restraint. So you really need to get them to release the restraints on you. So, you know, that's how it is. I got more stories, but I'll have to tell them another time.
The reason why I guess you file the 995 is because you don't think the judge or the DA or the judge judged the right way, and she was kind of biased or whatever. I don't know. But the DA couldn't prove probable cause. They didn't have any evidence. So it's okay for them to just say they have the evidence and not have it. And actually,
that's because 1538 is going to come into apply before the trial.
And what's that?
The motion to suppress.
Okay. I thought that was, what is 995 then?
Oh, let's see. 995 Penal Code. California Penal Code. 995. Subject to Division B of Section A, the indictment or information shall be set aside by the court in which the defendant is arraigned upon his or her motion in either of the following cases. So you put in a motion where it is, okay, so is it an indictment or an information?
It's what I don't know. I don't know what you're asking.
Okay, well, my guess is it's an information. So I would say that if it's an information that before the filing thereof, the defendant had not been legally committed by a magistrate. Okay.
Yeah.
So that's A. So that would be the motion. You weren't legally committed by the magistrate.
Mm-hmm.
Before the filing of the information. Okay, so there would be that paper because first a complaint comes in, and then after the complaint, they determine the probable cause, and then they commit you to get the information filed against you. Okay, and B, that the defendant had been committed without reasonable or probable cause.
Mm-hmm.
So you do both because maybe you were committed legally, but you were committed without reasonable or probable cause.
Yeah.
They put reasonable in there. I don't know why, because I think it should be probable cause, but that reasonableness means based upon the complaint. Then they get the information. So the information, then you'd have to file the motion to suppress because that's based on the warrant for the arrest.
Mhm.
That's committed by, yeah. So there's a lot of stuff there.
Oh, gee.
So in cases which the procedure set out in subdivision B, 995
And you
A.
can only do that after the pre-trial before the trial. And that's probably why they changed it to an arraignment again, which I already had an arraignment.
Oh
I
yeah,
only
that's right. You're going to be arraigned on on the on the on the
Thursday.
information instead of the complaint. There you go. Court shall
Oh,
reserve a final ruling on the motion until the procedures has been completed. Okay, so have you done the 995 motion yet?
no, I asked him.
Yeah,
I asked him.
and he's good. He probably waived it.
Huh. I
So,
asked him to
well, there
do
you
it.
go. And also, and before you plea, that may give you the opportunity to demur. See, and and I know that you don't have the ability to do it, and that's the real frustrating part.
I mean, I can write. I went to college for 10 years, so I had to write 30-page papers, but I don't feel like it. But I will.
Well, you have to write up a demur, and you have to get rid of your attorney, and you have to have your demur ready to
Well, I don't even know how.
ready to be denied, and then take it up. However, you can also tell your attorney that
Mhm.
you want to fire him because you want to make a jurisdictional challenge, and then
Oh, okay.
you just tell the judge, I want to challenge the jurisdiction of the court. I want you to put it on the record so that I can take it up on an interlocutory appeal or a writ. You really want to use the writ, but I don't know if you know how to do it, because
I
I don't know anyone that knows how to do it
I
except
don't know
me.
how to do it.
I know. Well, that's why this is one reason why I should be giving classes.
Do I need grounds to make a jurisdictional challenge, like on the grounds of something?
On the lack of on the lack of jurisdiction of the
Like,
court.
okay, lack of okay, yeah, all right.
Okay,
Because of
if you know what territorial jurisdiction is, that might be something to raise. But see, they play games with all this stuff, and they're going to deny it. So you have to be ready to take it to the upper court, to the appeal court.
okay. That's
But that's what you're doing. You always want to challenge jurisdiction. The court doesn't have it, and then when they ask you, well, what do you mean, or blah 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 blah. Well, you just say it doesn't have jurisdiction. Now you show it. You show the jurisdiction of the court, so I can take it to the upper court and have them determine if that does show jurisdiction.
oh good. So I can take okay. I'm just
Because I
writing it
need to
down.
take that to the appellate court to see if you have jurisdiction here, because I don't see it on the complaint. I don't see it. Well, what are you looking for? I don't know. You're the judge. Do you see it? Show me point it to me. Right there. Where's the jurisdiction written on this information, on this complaint, on this information now? Where is it? Which part of there gives the court jurisdiction? Because if you ever had any civil cases, it always says this court has jurisdiction under this code section.
What piece of paper would I even find that on?
The information. The complaint, the indictment. There's three things. There's a complaint, there's an information, and there's an indictment. Okay, they don't do indictments unless it's serious. Yours isn't serious. Yours was a complaint that now turns into an information. So whatever that's your initial pleadings, You just ask the judge to tell you on any of those papers which part gives the court jurisdiction. And read the definition of territorial jurisdiction.
Okay.
And Cynthia, do you know what I'm talking about?
I think Cynthia got cut off and she's trying to come back on.
Oh, well, I
Uh,
don't even, how am I
I
going to
will
be able
take,
to do that?
thank you for all the information.
I wouldn't
You-
even know how to put it. I haven't even been watching that one.
What?
Salem gave me if he gave me the right
Oh,
to
oh yeah, you don't know how to do it?
the host stuff.
Yeah, she's
Cynthia
probably
entered the
like trying
waiting
to get
room.
in.
So, okay, here, wait a minute. Boom. Can you believe it? All this time, Cynthia, where are you? There you are.
Oh, I thought you were seeing it.
Oh, you should have told me.
I did. I thought she was trying to get in and it wasn't doing it.
Could
I
she
had no
listen to
idea.
me? No.
Hold on, I'll text her to come in. Is
I
she
thought
in
it
there?
says Cynthia, but it's not the way it was before. Is this a different Cynthia? Cynthia, say something. She probably went to sleep.
No, I think she's.
It's a different one. Well, this other
Oh, it
Cynthia.
is.
Cynthia says she's trying.
Yeah, I can
Oh, there she is. Oh, there she's not.
hear you. Can you hear me now?
Yeah,
Yeah.
there you are.
Are
Okay, I'll let you in.
you there?
Could you hear us?
I'm already in. I can hear you.
Okay.
Salam, they're talking, but they can't hear me, and I can hear them, and the screen is on.
Can you hear me?
Yeah,
Yeah, I can hear you.
Okay, so
That is so. You can't hear me?
yeah, we hear you.
Oh, okay. There you
Okay.
go.
How long you been out?
That was an at
hello?
on for about a minute, but it's
Oh, okay.
you guys hear me now?
Yeah.
Yeah.
Not as good as we could before.
Oh, that's weird.
If you only heard the whole story, I know the complaints and the don't matter about the like abusive conditions in the two jails that I was in.
Right.
They but the process there's nothing wrong with them. The arraignment thing and the judges walking out and the three pretrial hearings. I thought I read a law that you have a right to one pretrial hearing. Like, know that law?
No, I don't know that one.
Yeah, I think I came across it when I was trying to like freak out one night and defend myself, but that's how I came across the 995 motion.
Yeah. Well, your attorney knows all these things and he should be doing them, but a lot of them we think we know, and then there's a little catch to it, just like this complaint, then the information.
Yeah.
You should be able to demur to the information. So before you plea, you can file a demur.
Okay.
So if you got the lined out and tell the judge, okay, I want to be my own attorney. Oh, they're going to make a big deal about that and try to scare the hell out of you. And then,
Yeah.
okay, well then if you tell them you're going to do it because you're going to file a demur, and then you write up the demur and then file that, and then get it denied, and then go up because you need to see whether it is on the record. And if you can and you can tell the judge right there, look, I want to follow demur. I want to get rid of him because I don't see the jurisdiction of the court on any of this paperwork. I don't see it. Can you show it to me? Oh, they'll get all pissed off. You don't believe how much they're pissed off because all they can do is get pissed off to scare you. And I know you're scared. So they're going to put the pressure on.
I can't believe he said that it was being dismissed if they couldn't produce evidence that day, which they did not.
they didn't. I recorded the whole conversation too, Zeke.
Okay, so have your attorney explain that to you.
He turned around and did the scare tactic after it went awry. And I was
There
like,
you
what
go.
just happened?
There you go. So it's a scare tactic. So, okay, so you do whatever you can, and no, then let's go to trial. Let's go to trial. See if they can prove their case, because they don't want to go to trial. They don't want to spend 3 days and $10,000 to put on a trial. that
So
they're
at the
gonna
arraignment,
lose.
they can't charge me with new charges, even though I had a new another arraignment.
No, they can, but what charge are they going to charge you with?
I don't know. They can make up stuff.
Well, they do.
Probably.
Well, they should have already made it all up.
Well, I think they realize that they're not well, I don't know, they are winning now, but they don't have anything. But they're still going forward with this, and now I just don't understand why I already pled. I still don't.
Yeah.
You know, it's like the Bank of New York Mellon, all those guys I'm in court with right now on my wrongful foreclosure. They'll spend $1 billion to take away my $1 million home.
Mm-hmm.
You know, I mean, they don't care. They don't care. Those districts are unconscionable, and they're partying with the public defenders.
I believe that.
They're all in cahoots, right, Steve?
Yeah, they're all in cahoots, but systematically they're in cahoots. Some of them are
Yeah.
good, but then the good ones end up doing a different job, seeing how corrupt the system is, or they find a little niche so that they're not, And remember, how many lawyers do you know that don't drink?
Oh, they all are.
Now you know why.
Yeah.
So,
Well, now I've seen these new lawyers in the public defender's office. They seem like twerps that like to say that they have big cases going on, more important than yours. I've heard it twice already, and I've never seen people act like that we're really good lawyers, but they're not. Like Cynthia's lawyer said, I have real cases going on. Or something. What did he say? And you go, oh, is that your calendar?
I looked at
is that your what?
calendar on there, and I said, "What are you doing? Jury trial on jaywalking cases? What are you doing over here?"
Yeah.
I'm really done with it. I'm just going to push forward and and when I'm done, I'm suing them civilly. And this guy that owns this dog that I rescued from shock collar abuse, it's unbelievable, Zeke. If you saw what I had, but I'm out of money.
You told us this last year or so. You told the story. I remember it.
4 years old now.
I don't remember much, but man, I remember that one. That was so convoluted and messed up. Yeah. Well,
and I didn't think it was that bad until I'm in it now, and I don't know.
Well, I've been telling Darth Vader about it for 4 years, and
yep.
she's in it, and she's like,
and
"Wow,
now she
they
thinks
really
hers
are
is.
corrupt."
Yeah, that's pretty crazy.
Well, they're threatening years in prison.
Well, this is
20
why
years
we
in
got
prison,
to,
they're threatening her.
Yeah.
once
Set
we
some
leave
case
this stuff-
law. That's what I say.
What's that?
Uncover this corrupt. She witnessed a rape in there. No,
What? You're going
You're
in.
cutting out.
woman when she was in there, they put her in jail for 18 hours.
Yeah.
We had to file a missing persons report. Oh no, we released her, but they released her to a mental hospital. I mean, it's bad. See,
And I had my arraignment, and they put me in jail in solitary for another day, then released me to a mental hospital. And the mental hospital was like, why are you in here? You got released from court. And it was so weird, man.
I had a missing persons report by 9 o'clock that morning.
Yep.
And I Googled to see how long it would take her to walk to Westminster from Santa Ana.
Well,
You know, we were freaking out. We thought they put her in there, or she jumped off a bridge from the abuse. It's pretty bad. So now heard the rest of the story.
Yeah,
We're so
that's a short
upset.
version.
Well, it's pretty bad when you flip them off and tell them you're not going to pay taxes or have driver's licenses. They get pretty pissed off. They could take
Well, that's
everything.
Jackie
And that's another
Did.
thing, that the first thing, and that, you know, of course, it's always too late for everybody, but anybody who's listening in needs to understand, before you start to get in trouble, on purpose or not, or go and start fighting in the courts, you need to set up all your property and money
Yes.
so they can't get it.
Yeah, that's why I didn't tell him anything about me.
That's right. So they'll go right after your money. That's the
Mhm.
first thing. Got to be called what's judgment proof. And then you need to learn the law, learn the process, the how it works, and concentrate on step by step, because it's logic and it's reason. It's a science. And the minute you start bringing in the emotional stuff, it blocks you. You start bringing it up, it blocks you. It has a place, but it can't be first. It's got to be last. Just like the cop gets to go first,
Yeah.
then you can get him. But you have to know, you have to take it to get damages. You have to take it. That means if he illegally arrests you and he puts you in jail, then he's going to pay, but only if you take it and hold out till he takes you to the magistrate. Because if you sign out, then you waived everything. But if he takes you to the magistrate and the magistrate finds that there was no probable cause for the arrest, then you can go after him for the pay. But if you sign out, then you don't get to go after him for the pay, even if you win the case.
Wait, what do you mean if I sign out?
She could go after them later on when this is done.
No,
for
you can't.
compensatory.
That's why you got to read that case.
Okay.
Gersten
Oh,
versus Pugh, or In Ray Walters. Totally explains it. It doesn't seem fair, but that's how they do it. And you
Yeah.
got to read these cases, because as you read them, you'll learn how to read cases, because things are not the way they appear.
Yeah, because in
Is that
Massachusetts,
Gersten versus Pugh?
yeah.
Gersten versus Pugh?
Yep. And In Ray Walters for California.
And which one?
In Ray Walters.
In Ray. Like X-ray, but in Ray?
No, I-N, then R-E. Then Walters. 3 words. In Ray, R-E.
Okay.
Walters. It'll come up. They're both
Yeah,
1975 cases. So,
Um,
all right. Well, I did want to, I don't know if Dennis is still up. I kind of wanted to, oh, he's on here twice.
Yeah, I got my iPad where
And is
I
Whipple
listen
on
to
there?
talk better. Yeah.
Okay, yeah, I was wondering, remember a couple weeks ago, there was a seminar given by
Bill Thornton.
1215.
Yeah, Bill Thornton.
Yeah.
Yeah.
How did that go?
It went pretty good. He had a guest speaker, besides the common law, the young Vietnamese guy that said he was a minister or of the court or something, but he talked about a lot of financial stuff. But then Bill called me about a week ago and he said, take him off the website, because he's kind of a con, taking a lot of money from people, not performing. So anyway, but besides that, it went pretty well. It's on my Rumble channel. I was in YouTube jail at the time, but I put it on YouTube as well. If you go to Rumble, put in Video Man #1, you can see and hear some of the there'll be 5 sections now, 6. I'll probably let people hear that other guy, Tony. His name is Tony. Yeah, he's really good, but then business wise, Bill said you got to watch him, you know. But regardless, the seminar was, you know, a pretty good overview again of what Bill's all about, you know.
So the Video Man 1.
Yeah, the numeral 1. Yeah.
Yeah.
And then you can see part 1 of 6, 2 of 6, blah blah blah.
So you do video stuff?
Yeah, that's how I met a lot of people over the years. I met Bill Thornton back in the late '80s, and then Richard McDonald. I started doing his recordings in '91. And he's passed on now, but
yeah,
have a lot of stuff, you know, and most of it's not even on the internet. A lot of Bill Thornton stuff is. A lot of people have benefited from that, though, you know.
So do you do like so with a video, like I'm thinking of, you know, like you got a channel. Do you do interviews? Can we set up something? I mean,
yeah, I'm not really a podcast behind the camera guy or in the front of the camera guy. I know I'm focused on events, you know, lectures, mostly things in the freedom movement that I'm interested in, or alternative health, or I even do UFO meetings, and regular space conferences. Like William Shatner will be honored with an award at a conference in a couple months here in LA at a space conference. I'll be there.
You do so you have a camera?
We do cameras. We'll set up equipment, you know, sound and you know, video production, live streaming, and everything for maybe, you know, 7-8 rooms at the same time. It's a lot of work and it takes team effort, you know.
Yeah. Well, so all I'm looking for is basically to set up a class.
Yeah.
And you just need to, you know, once I get a time, a date, and a place, then I tell everybody, you know, we get the word out, right? And then they come to the class, and then, you know, it's an hour long or so, and we just and I run it down, and then that becomes the class. And then we, you know, we can do like a series of classes, because I'm putting it together to do the introduction part.
Okay.
And it's going to really talk about the stuff I'm talking about here, but it's
exactly it's so needed. People don't understand. Even I think I know some things. I've been around for years, but yeah, no, you know all the basics, and that was good for these two ladies tonight. I mean, it's incredible. Yeah.
Yeah. Okay. Well, that's what I like to hear. And so now I want to say something. Oh, you got the money. Do I need to mute her?
Cynthia.
Can't hear what it was.
That's her phone.
Oh, that's her phone.
That's funny.
Thank you for thank you a lot. This was a lot of information. I'm gonna research tonight, probably not sleep.
Okay. So yeah, when I'm planning on, I've been trying to get this together. Maybe Dennis will help me. We can. Do you have my email, Dennis? Or
I don't know. I used to send things to Michael, and of course I got salams. Yeah. I better write it down,
okay. It's Zeke. It's just Zeke at powerpolitics.com.
At what politics?
Power Politics.
Oh, Power. Okay.
Yeah, that's my website that I haven't done much with. Then, do you know how to do website stuff?
Oh, I didn't know that. No.
You can go to GoDaddy, and they have like basically wicked easy templates, and it's cheap for them to host it. And they give you do you own that domain name? Because someone could just take it from you.
Yeah, I own it.
Okay. So who do you own it through? That they can do your your website too.
Well, I know, but I got it. I got grandfathered in. They're called, what are they called? I can't remember. The kid, he was the best web website in Europe in 1997, and
Oh,
he got in this stuff real early and made a fortune. So he just carries me.
well,
And
make sure you own it and make sure he doesn't own
Strange
it.
Code. I own it, Strange Code, and I got it.
Mhm.
It's hosted by GoDaddy, I think.
Oh, okay.
So yeah.
Yeah.
But really, I just want to get these together. And really, when a good time is, and and we just set it up, and then just start doing it, because I can give the introduction, and then I can do a traffic course, can do unlawful detainer, they can do some family law, custody stuff. I can break it all down, but first cover the basics of all of it, all the cases, courts, plaintiff, defendant, and then the real inside stuff but it's higher level, but it's really not, is the breakdown of the different systems of law. Because there's 5 different systems of law, and when you're in a system, you sometimes other systems, they don't really, sometimes you can use words in all of them. All the words are kind of the same, but the systems don't really mix. They can intersect sometimes, see, and that's why it makes it uh, confusing or complex. It's just because it's a lot of interactive pieces, but there are some separations. And when you understand, that this can't go with that, just like, you can't mix civil with criminal, even though they do, and it's called special, and then that court really doesn't have jurisdiction, but it kind of has its own jurisdiction if the parties agree. See, so that's how that all works. So anyway, I'd break it down, and then decide how many, how much per lesson, how many lessons, and do different areas, and then maybe have also a whole show of questions. But the questions, see, I like to get questions and then I answer the question. I don't like to explain too much because it takes a lot of time. But to someone who doesn't know what the words mean when we say the answer, then it takes too much time. So we have to know what a complaint is. We have to know what an information is. We have to know what the indictment is. We have to know what a motion is. We have to know the difference, between, a hearing and a trial. These are basic things but when everyone, and now there's always someone new coming in. And then you got to tell them again, oh, this is that, that's a that, that's a that. So everyone would start at the same, you'd get the same homework. This is a study. This isn't going to be just, oh, show up and let's see what happens. It's going to be, you're going to have to study to learn these things. You're going to learn stuff, not just hear it. See, on this thing, we don't hear it. The Salem goes and studies, he researches, he lays it out, he finds some stuff, and then he presents it. Okay, the rest of us just listen. So we need to, I'll be, like Brandon was saying before, we got to do our own research.
All that stuff.
Huh?
Awesome. Let me know when we're having our next week.
Okay, I'll let you know.
Can you hear me?
Yeah, can you hear me? Oh, you have to, have to unmute. I got you blocked or something. Has to unmute. Chat.
You guys can't hear me. Can you hear
I can
me?
hear you.
Oh, okay. Well, we'd like to join into whatever your format's going to be. Thank you so much for.
Okay, I'll probably announce it in a week or two. I'm going to talk to Dennis if he helps me just set it up, get it on. I kind of know. I think I just need to figure out how to get the money and how to keep everybody, and and to get the video so that someone else can, set it up so someone else can take the course too.
Right.
You know,
You're gonna have a subscription?
maybe, I don't know if that's how you do it. It might be, yeah. That's I
There's
have to
a lot of
decide.
ways.
Yeah, I have to decide. Maybe you can help me do that too.
Yeah.
So, yeah, send me. Yeah, let me give you my email, and then you can send me an email, and then we can talk. And Darren's got mine. So send me one.
Okay.
And Brandon just said he sent me an email, but I don't know where it is. Let's see.
Oh, your email Zeke at Power. Oh, no, that's your website.
Yeah,
No,
that's no Zeke. That's my email.
Oh, it is?
Yeah,
Okay.
Zeke at my website. Yeah, so to speak.
What's your email?
Zeke at powerpolitics.com.
Wait,
he
wait,
owns
is
the
it?
website and the email.
Okay, so it's all right. Oh, okay.
Uh-huh. There you go. Okay, Brandon, I don't see, so it must, I don't know. Let's check my trash here.
This audio on this meeting the last hours. Can you guys hear me?
Yeah.
Oh, okay.
Okay, Brandon, I don't see an email. Maybe you better send me another one.
Well, Demi, you've got Zeke's, right?
Yeah.
Okay. I can always call Salon, but I'm signing out, guys. I've got clients coming at 7:30 in the morning and I need to get my beauty sleep.
I'm gonna sign out too. Thank you very much.
Okay, you're welcome. Okay.
I'll
Well,
send you an email.
Thank you.
yeah, send me an email and then we'll send
Great
it.
meeting. I wasn't expecting it because Salon's been off.
Brandon, can you hear me? I didn't get an email from you.
Okay, yeah, I can hear you. I sent it on the 14th, but I'll resend it again right now. Hopefully it'll go through.
Yeah. So do I need to respond to it today or tomorrow?
I think I'm like down to the wire on only having a few days until my case management meeting.
Oh,
I
so
I don't even I don't even know if it's even worth pursuing or salvageable. So
it's a
that's kind
civil
of
case?
yeah.
You're filing it?
Yeah, I already filed it, yeah. And
Okay.
they demurred and I dropped the ball on responding and then it got dismissed with the chance
Without
to
prejudice.
amend.
Yeah. Yeah. Well, have you talked to Salem about it?
No, all this was happening right when he fell ill, and I sent him some emails updating him on the situation, and he never replied. And then the next thing I heard from him is, "Sorry, I couldn't help you with your finish your case." So they want to keep pressing him on it, and so I don't know if he forgot or if he just assumed it's over with. And
Yeah, because he's been researching that, got to write a cause of action. And I don't know. I mean, um, I'm really like shying away from filing complaints. I like to proceed by petition. So I don't know who your civil case is against. Is it against the government or a private party?
it's my old employer,
Huh?
my ex-employer, the terminated me for the mask issue.
Oh, for the mask.
Yeah.
So that would be so I really don't have time to look at it. I would say that I would take the approach that he violated your constitutional right to due process and equal protection. People have walked in there before without a mask on, and so what's the difference? Okay. I mean, if you go in with the, because Salem, I don't think he's going to salvage his case. He's going to try about the mask. So were you damaged or not really?
Yes. Yeah, I was terminated, and then
Oh,
and then
terminated, right. Okay. So that termination, it's did you take the course?
Yes.
Okay.
With
Yeah.
Clint. Yeah.
Yeah.
I've invested.
See, we didn't raise the constitutional rights that were violated. I think we did. Did you do it off of one of the complaints that we talked about?
No, when Salam was helping me, he drafted up the complaint. I think that's the what is it? The cause of action was incorrect. That's why they demurred.
Yeah.
Um,
So
I
need
just
to, yeah.
go ahead.
I would look at, remember we went over a couple complaints about the firefighters, and I'd get those complaints and then write it in the nature of that, where you list all the violations and the cause of action. 14th Amendment violation. They threw a lot of them in there.
Yeah.
Okay, and then you state that your injury. See, you have to have the claim for relief, the right to relief. What gives you the right to collect? Well, your right was violated. You were injured. Your right was injured because you lost your job, and then the jurisdiction of the court. See, the jurisdiction of the court might be the key, because we brought those under Title 42, 1983, civil rights violation. But I would bring it under, but I think you can still use that, but I would state constitutional violations. Even if it's brought under Title 42, the civil rights, your constitutional rights are violations, and those are the ones you want to state that were violated.
Mm-hmm.
And so I don't know if Salam, I remember in his case he didn't even put Constitution.
Right.
He used are you in California?
Yes.
So he used the Unruh law, but he really should have used the other law. Say, are you doing state or federal?
State.
Okay, state. Yeah. So I would now also in the state California Constitution there might be some causes of action,
Mm-hmm.
And that I would bring up too that I don't think Salam brought up.
Yeah.
And I would carefully read their demur, because in it they tell you what you're missing.
Yeah, I did notice that they said that the whatever the law or cause of action didn't apply to employers. That's the reasoning. Yeah, I recall from listening to Peggy Hall and taking the course with you and Clint that there's a handful of the Constitution, state of California Constitution, and then when Salam drafted up my complaint, he didn't include any of those, but I just trusted this, and went along with it. And then they demurred, and I didn't respond. And then I went to the case management, and the judge asked me how come you didn't respond, and he said, can you get an attorney? I said I couldn't, and he said, well, because you didn't respond, and they can get dismissal. So I'll go ahead and dismiss, but you have a chance to amend. And I think my next case management meeting was coming up in a few days, but the other day I got a FedEx notice of some kind of meeting that I wasn't even aware of, and I got the mail the day after, and then I got an email from their attorneys again with another some kind of dismissal or something.
Motion to dismiss.
Yeah, and I know initially they offered me like $1,000, and that's when I didn't respond, and that's when Salam fell ill, and I was hoping he would tell me the next step for a good strategy to recounter the offer or something. And
okay, so here's you got your situation again. you know, the amount of work you're going to put in, what you're going to do, how you're going to do it, you're not prepared, you're behind the deal, then you may just try to say, okay, I'll take the $1,000. Otherwise, you're going to have to still write it up and put it in, and then really, you probably just need to get it written so that it does state a cause of action, throwing in the violations, because the Constitution does apply to employers.
Yeah. Yeah, I don't know if that offer, how it works, if that offer's still on the table, but yeah, that would be better than nothing, but still unfortunate because I've already invested a lot more than that.
Yeah,
you know,
well, you're learning, so that's the money's all for learning. So
Yeah.
that's all I can tell you. You know, I don't know. You got to put it together. I quit writing and working for Salam. He does it all for free, and then I give him all these. I tell him all this stuff, and then he asks this and that, and it's like, I mean, come on, you know. I mean, Randy, you know, Randy's case. And it just goes on, and he just brings it up. So I don't even talk to him about Randy's case. If Randy could, and Randy has money, you know, if he put down some money, I'd tell him what I think and how I think it should go. But Salam, he got sick, and he got, you know, he had his problems, which, you know, happened. But he's still, and you know, then now he's trying to get a lawyer for Randy, which I don't know that that's going to really help. But there, you know. Even no matter what, you got to have a coherent approach, and you got to stay within the time frames. That's another point that I learned from you that, I mean, I already knew, but reinforced, that I have to bring up. It's work. It's a class. It's time frames. You have to do that's why people get lawyers, because they don't do time frame. You know, the lawyers do a lot of things people don't realize. But, you know, it's really just staying on and organized and staying on meetings and doing the meetings. You know, they go in, they appear, because otherwise people. But, you know, when you get around the court, you learn more shortcuts. You know, because they got it set up to where it's not worth it to you to fight it. You pay it. So that's what, you know, all the shortcuts is that, you know, when you don't have to go to an arraignment, you can waive the arraignment, or when you show up with your demur right there and settle it right there, like everyone thought you should in the first place. But you got to know how to do it. Yeah, you do. You settle it up, you talk, and then you walk right out, and you don't sign anything. Say people go sign. Oh, sign here. Okay, sign. Why'd you sign that? Well, I don't know. He told me to. So, you know, the judge, the bailiff says to me, he says, I got something for you to sign. I said, yeah, you going to make me sign it? Looked at him. He goes, well, that's up to you. I said, yeah, okay, I'm not signing. And walked out. And my buddy goes, let's go, let's go, let's go. I said, no, we're going to stand right out here outside the courtroom, and I'm going to tell you guys what happened in there, because that was a big show, drama. That's all it was. And then guess what? Boom, out the doors. Guess who's coming out? The bailiff. Hey, you going to sign this? No, you sign it. No, I can't sign it. Well, I'm not going to sign it. Goes back in. Comes back out. We're still here talking. Okay, now what? Well, the judge said you can sign it without prejudice. Yeah, okay, no, sorry, not going to do it. All right, go back in. Oh, come back out again. Oh, well, I'm talking to Joe. Oh, here's he comes out to get to talk to me. He sees Joe. Oh, hey, Joe. Yeah, he knows Joe. Hey, Joe, you're looking old. Oh, that's great. Nice compliment. Okay, see you guys. I gotta go. I never signed it. So guess what? Because I never signed it, they couldn't collect.
Yeah, nice.
Couldn't collect. So, but you know, I learned I could do it the first day. I didn't need to go to the trial and have the judge find me guilty and then tell me he's going to fine me. you know, because of a mock trial, you know. So, you know, then he finds me and I said, so are you done? Yeah, I'm done. Okay, well, see you later. Okay, so I was never there. I was never there. Never signed in. I've never signed out. Yeah. So, and that's the other thing, you know, they can't collect because when they make their judgments, they send them over to collections. Well, collections can't collect. They're, you know, they're debt collectors. They can't collect someone else's debt. So you guys, so I wrote them, so you got an order to collect? You stop collecting until you got an order to collect. Never heard back again. So, but that's our defense. I know. Offense is the other is a whole nother deal suing them. I sue by writ, you know, and I think you can sue your employer by writ, you know, and then we'll go over that once we get through these other understandings, because the writ is again, it's a alternative writ, which gives them the alternative. But what do we? It's kind of late for them to do anything, you know, because they did what they did, but I don't know how they. Oh, they fired you. Okay, so then we could tell them give your job back, or tell us why you're not giving it back. Have you reapplied?
No,
Are you willing to?
no.
Okay. Well, then, yeah, you'd have to figure out how to couch uh, your writ, but I don't know what your cause of action is, except a violation of your constitutional right to work, or which is a violation of the contract, right? You had a contract, but they could fire you at any time, but they can't fire you for those reasons because those reasons are you have constitutional rights. So I think that's what you need to do is have your constitutional rights be the cause of action.
Right.
You have to, yeah. So you have to think about this stuff, and you know, like I said, if people give it to me, boom, I'm thinking about it. Hey, this lady came on the show right there, boom. Now I got to think it through. So I'm just talking and thinking it through for you guys. But when I do my cases, I think it through like that. Then the next day, I go and put it all together more and think about it more and put it in line and line it up with the rules and how the procedures work and you know state the case and then go over it again and then think of something new and then go over it again and go over it again, you know, because that's just how I do it. I mean, I go over it way too much for, you know, this stuff because I'm a perfectionist and I try to get it all 100% right, which really is, you know, it's not worth it in the as far as money and time go. You know, I do that and I take it seriously, and then you know, then I end up, you know, oh yeah, now I'm struggling for making any, you know, paying bills and you know, prices of food's going up. So, you know, I can't even go out to eat anymore. You know, it's just so that's just the way it is for me. And so I figured that I could put on a course and put the step because I can't write it for everybody. They got to write their own, you know, but you know, we can at least get everybody on the right track, you know, but you know, most people don't win their first cases, but some do. You know, when you understand and learn what a cause of action is and how to fill out the state the facts in a way that is reasonably understood, then the other side can answer. Really shouldn't be that hard. You know, so I don't know, but people write them. They put in too much of their own information. Really, I think because complaints just need to be short and sweet, just like they complain against us. How long is a complaint? You know, 1 or 2 pages. Why do people go into all this extra stuff? Lawyers just write them to look pretty. They only need to include the basics. So that's all I can tell you. I don't know what more, you want me to review it? You want me to write it? I mean, I don't know.
Well, I mean, oh, I'm sorry, go ahead.
No, go ahead.
Well, it seems like I could probably replace the cause of action in the original complaint, and that seems like I would think it would suffice. But as far as how to resubmit it or how to reply or respond at the next case management meeting, I was,
Well, what did he say? What he said that what the lawyer said that you didn't do. That
so the
you said it. You said it already.
Yeah, they made me the offer.
No, what did he say you didn't put in your why you demurred?
A cause of action, applicable cause of action.
Okay. So what was your cause of action? What was the what was the code section you brought it under?
I believe it was the UNRWA.
Okay. And it should have been the Ralph.
I don't know what the Ralph is.
That's what Salem was saying. He brought it under UNRWA, and it should have been brought under a different one. Okay. So that is what I don't. If you focused on that and just said to Salem, just have him talk to you and say, you should it have been under the UNRU or the other one, and then you'll need to maybe bring it under the other one, or how would he have brought his? Because that's what his problem was. And I haven't researched the UNRU Act or the Ralph Act, enough to know which way to go and what the facts of your case are. Okay, so you may need to do that. If you can do that, okay, then at the settlement hearing, all the settlement hearing is to set up the process of how the complaint's going to be dealt with. See, so you filed a complaint. They said, "Oh no, it's insufficient. We can't really even deal with it. Can't go to trial. Can't do nothing. Can't do nothing." Okay, but if you can amend it, and that's what it'll be called, first amended complaint, then you file it, and then they demur again. Then they tell you what your problem was. Then you try to correct it until you finally can correct it. Okay. Now in Salem's case, they said he can't correct it. It's going to be dismissed with prejudice. Meaning with prejudice, that means you can't bring it again because you can't bring it. There's no way you could figure it out. So you might be able to, or you might not. If it goes from the UNRU Act to the Ralph Act, then you may not be able to do that. You may have to file a whole nother complaint. You see what I'm saying?
Yes.
Okay, so that's what you need to determine first, and I would talk to Salem about it if that's the deal. Now, if you can amend it, then you can amend it, and then the hearing at the conference, they just set up the time and date and place of everything. You're going to do discovery that needs to be ended by such and such a date. We're going to have the trial on this date. There's deadlines that have to be met for the discovery these period of time. Then we'll have another conference to see where we're at, and that they just how you work the case. And the key is the discovery, and that's what you want to do, and that's what you would always want to do is your discovery, because when you do discovery, that costs the other side money, and that's really the key to this whole game, is to cost them money, because then they go, oh, we're spending $700 an hour to answer all these bullshit discovery questions. So we need to just give this guy $4,000, and then because by the time we get done, we're going to be spending $30,000 just on bullshit, and we can go away from 4 or 5.
Mhm.
See, so that's the whole game to make the money, because you ain't gonna really, what are you gonna do? Are you suing to get your job back? Not really. So you see, that's how we play the game, because when we're up against these high-powered attorneys, we ain't gonna win. We just want to show that we're going to cost them time so that they'll pay us off. And so how much money do you think that you were damaged by losing your job?
Like, I guess I would say probably 20,000, or just to throw out a
Okay.
number.
Yeah, okay, but so now that's uh and now whether that was it or not, because you still would have had to work for that, right? I mean,
Mhm.
so it's just the ability to go. You didn't do that work. So that was money that you would have made. So not really, but looking at it from the lawyer perspective, okay. I'll tell you, back in 1997, okay, I went to sue my business partner. We had a little deal going, sprayed in bed liners, and it was $12,000. Okay. So I went to a high-powered attorney. Okay, so I call this high-powered attorney and tell him the story. And this is in 1997. He said, that that isn't even a retainer. He said, we'd want $15,000 for a retainer, but we really don't take a case unless they're going to win $80,000 or more. So the point is that it ain't worth it to sue for 20 grand for any attorney to do that. Okay, so that just tells you that really you're doing the lawsuit for your education, and that's what Salem is too, and that's why we know he wanted to get 4,000, or he wanted to get. Well, he didn't lose his job; his was a different deal, but it was about the math. And you can win the case, but not any amount of money, and that's called a Ferrick victory. You know what I mean? You ever heard of that?
No, I haven't.
A Ferrick victory. It's like, you go into war, you get totally wiped out, and then on your last falling down, you kill the guy that's coming at you, and you don't really lose the war, but you lost everything. You
Right.
see,
Yes.
it's a victory, but it's an empty victory. Like, you're going to spend all this money, you're going to, and what are you going to get? 20 grand if you win? How much are you going to spend on it? Probably going to spend 15, 20 grand, at least in, time and all that, aside from the money put out. That's how this stuff is. When we learn, we learn all the time. It's taking up time. We aren't doing other things. That's why the investment is in the knowledge. So, I'd say give it a try, and then that's it. If you can amend it, then I could help you to tell you what's going to happen. And basically to do discovery. I mean, that's what you do. You have to learn what that means. There's forms now and everything for it. So
Does that cost money to submit a new amendment?
No.
Oh.
No, it doesn't cost. It's First Amendment complaint. No, you already paid your filing fee.
Mhm.
They sometimes they charge for to file motions, but you wouldn't need to file any motion. The other side filed their demur. They might have had to pay for that. I'm not sure. But no, you shouldn't really have to pay any more money. Discovery doesn't cost any money. Really, it's there. In technically, there's a complaint and an answer. That's it. Complaint and an answer. And then the rest of it is emotions that you pay for, but you don't really need a lot of the motions. You get a complaint and an answer, and then you go to trial. And the trial, but you don't even need a trial because you basically agree to all the facts. So then the trial is the damage. See, so what's the damage? So the damage to a constitutional right, could be 20,000, could be 50,000, but it could be 5,000, depending on the right and how it's injured, how the injury has occurred, and how the jury decides on that. That's why it goes to a jury because, see, in your case, there is no issue of fact, right? There's no fact. You didn't wear a mask, you got fired. We all agree. So it's an issue of law. Are they allowed to violate the law in that manner like that? And no, they're not. But which law did they violate and that they're not allowed to? So you have to be able to word it. And Salam, I would have brought up the constitutional rights. So you might be able to do that in your amendment. That's what I would try to do. I would say they violated your your right to equal protection, and they also violated your well, yeah, it's one of the rights. There could be a well, let's see, rights of what are they called? Like social security rights kind of thing. Disability could be under disability rights. You have the right to work. They have the right to fire you, but they can't fire you for certain reasons. Remember, we went over those.
Yeah.
Okay. Well, so those need to be put in there. See, I can't remember now. It's been a couple of years.
Like Title 42.
No, the right. Well, Title 42 is the civil rights. That's like the unreacted state.
Oh, okay.
All right. Well, hey, I gotta go, you guys. It's getting late for me.
Okay.
Midnight. All right. So you send me an email if you want something. I'll let you know when if I can help you. Ask, be specific, and I'll try to get this course together. I'll get Dennis's email, and then.
Yeah, I just sent you an email with parts 1 and 2 of Thornton from last month. So my email is Dennis Whipple at Yahoo. You'll see it. I had your email in my list for some reason already. So
okay, cool. Good. Well, then I'll get my thoughts together because I just need a guy that knows a little bit about this stuff, and then will help me just put it together. Because I just need I don't know anybody. There it is. Okay, so then I'll talk to you. We'll talk, and
okay.
I can help you, and you can help me.
Where are you located, Zeke?
Well, I'm up in Chico.
Oh, okay. Yeah, I'm down in Long Beach here myself.
Yeah. Okay, I figured you're down there. Yeah, that's right.
Yeah, I used to record Jackie's seminars quite often,
Yeah. Okay.
at her
Well,
house.
good.
Yeah. Okay.
It's nice to know all that stuff. All right, you guys. Thanks a lot. I'll talk
Okay,
to
Good
thank
job.
you.
All
Yeah,
right.
thank you. Good night.